Olisa Susan Williams disappeared from this earth before she reached her first birthday. It has been long thought that her legal father, not her biological father, her legal father, Isiah Williams, was responsible for her death. However, she has never been found, and it has taken 42 years for him to be convicted of her murder. Olisa was last seen in 1982. She had been living with her mother, Denise Williams, in Cincinnati, Ohio. Denise told her attorney that her ex-husband, Isiah Williams, also known as Bobo, somehow fitting, entered her residence in May of 1982, knocked her down, and took Olisa. Now, Isiah is Olisa's legal father, but not her biological father. Isiah and Denise were married at the time, but Isiah was in prison when Denise got pregnant and conceived Olisa. When Isiah was released from prison, he and Denise resumed their relationship. There are a lot of laws regarding this that have caused problems even till today. When a couple is married and has a baby, regardless of who the biological father is, the legal father, which is the husband of the person having the baby, their name goes on the birth certificate. There's been multiple cases that we've covered about this, and it's something that really needs to be looked at heavily because it causes a lot of custody disputes. Denise notified the police about her daughter's abduction, but they didn't do anything at the time because they thought of it as a custody dispute. Isiah was 36 years old at the time of the disappearance and was thought to have taken Olisa to Ann Arbor, Michigan, after he abducted her because he had family in that area. He took her to a family reunion in Inkster, Michigan on July 4th of 1982. According to his brother, Olisa appeared to be in good health at the time. Isiah also took Olisa to his other ex-wife's home a few days later, and she said the baby was fine. On July 9th, Isiah was served with a summons ordering him to produce Olisa in court and explain why he violated a restraining order in taking Olisa. The very next day, according to Isiah's ex-wife, Olisa was gone. Isiah appeared in court the following year, February of 1983, without his daughter, and said he would reveal what happened to Olisa if the judge dismissed the restraining order violation. The judge refused and threatened to jail him. Isiah then told the court he last saw Olisa sometime in June of 1982, which conflicts with the statements of his family when they saw her in July at the reunion. He said he had been smoking dope and drinking while driving with Olisa in the vehicle, like Father of the Year material. He parked at Island Park, which is a 35-acre park in the middle of the Huron River, and he fell asleep. When he woke up, he said the car door was open and Olisa was gone. He didn't report her abduction at the time because he said he believed Denise or one of the other family members had taken the child because, yeah, that's what happens. After Olisa's disappearance, Isiah allegedly called Denise several times and gave her different stories as to the baby's fate. He claimed he had lost Olisa, that he had killed her, that she had died at a hospital, and that she was across the water. Ann Arbor police searched the Huron River for Olisa, but turned up no evidence. In October of 2021, nearly 40 years after Olisa's disappearance, Isiah was finally arrested and charged with one count of open murder in her case. Isiah Williams is, by all accounts, an absolute monster, in my opinion, and the next 7 or 8 hours are him making a court case much more difficult than it needs to be and refusing to give a mother closure, regardless of the fact that it probably could have made his life a little bit easier. So, let's go to court.
My dearest Olisa, you were taken from me by force when you were just 9 months old. I looked at the calendar, remembering the day you were born. You are 34 years old now. 34 years is a long time to be away from your child. I missed your growing pains, the mother private talks when you're feeling blue, the happy times of going to the prom, high school dances, your school accomplishments, and milestones of life. I have not forgotten or given up in my search for you. I know within my heart you are out there somewhere looking for me too. You hear and see stories of how mothers have been reunited with their children after so many years apart. I pray one day we will be on the news telling everyone our story. I love you, Olisa, and I miss you so. It is all I can do to keep your picture and information up front. and hope someone will recognize you. Until that happens, I will continue to do all I can to bring you home.
Okay, court does call the case of the people versus Isiah Williams. Yes,
Good morning, Your Honor. Danielle Russo-Bennett, Department of Attorney General, on behalf of the people.
Pretty Judge Torshell Feaster, Assistant Public Defender, on behalf of Mr. Isiah Williams. Mr. Williams, please state your name for the record.
Isiah Williams, pro purpose Sonic. I've explained to the court, Your Honor, that I told Mr. Brown, and as I have stated,
Mr. Williams, Mr. Williams, I'll tell Judge what's going on. Just give me 1 second, okay?
Well, I'm trying to explain it because you haven't been able to do so, Your Honor. That's why I'm saying it, because this officer, this attorney here before you, something is wrong here because we have a lack of communication. I keep taking writing to their people and writing and telling them, you understand, and I read it.
I'm going to tell the judge that you want to go
Simpson, who is the Chief Public Defender's Office in Washington County, on April the 22nd. Then I've written her again, you understand, another copy just last week. And I took it straight to them on the phone, Your Honor. And every time I talk to these people, they do not get to comprehend that I no longer wish they help at all. They are incompetent. They are not providing me with what I need. I need someone who can represent me, that's going to take and let me know what they're doing in my best interest. These people are not working in my best interest. They do not want me to take and get a copy of a true motion for discovery. They do not, you understand, want to get me in the courtroom where I can take and bring the deal that I want this illegal device taken off my person, that I can be able to sit in the courtroom and be free of the privacy of my mind. I have a device on me, Your Honor, and it invades my privacy of mind. The United States Supreme Court Justice said they would not allow such an atrocity on the United States citizen to walk around with an invasion of privacy of mind. But yet, these people here who want to represent me go tell me today, we can't even get your property. I've already, you understand, been illegally kidnapped on October the 12th in Chicago off a CTA bus, Your Honor, and was kidnapped and robbed.
No, you were not kidnapped. You were arrested. We've already been through that before.
I was not arrested, Your Honor. I was kidnapped and robbed for
yeah,
$12,000.
You were arrested.
My property. Now the property doesn't come up.
Kidnapped, arrested, tomato. All right.
You don't want to hear it. I know it.
No, I'm listening to everything you're saying. At least those parts that make sense. Mr. Feaster, you were saying.
Thank you, Judge. I've spoken to the Attorney General's office and to Mr. Williams. Mr. Williams did indicate to me that he wanted the letters that he sent to our office returned to him so that he could file a motion on his own behalf. For our part, Your Honor, our office has hired an independent investigator to look into this matter. I am waiting for a report from that investigator. If we could have about 4 weeks, Judge, to get that report, then I'll make sure in the meanwhile, I return to Mr. Williams all of the communications he's sent to our office. So he has everything that he needs, and he already has his discovery, Your Honor, just for the record.
Before I hear from the Attorney General, just so
Your
that
Honor, I do not want to take it.
Mr. Williams, Mr. Williams.
I'd appreciate it, Your Honor.
Just
I have
stop.
almost 5 different.
Just stop. Mr. Williams,
Yes,
stop.
Your Honor.
I've listened to you. Now you're going to listen to me.
I will.
So that council's aware, Mr. Williams did file some documents. Some of them I don't entirely understand. I have reviewed them. One of them is a form motion for discovery. I don't know that what he has put in there is applicable to this case. However, upon receiving that, what I did is I sent copies of that to the Attorney General's office, or had the clerk send it to the Attorney General as well as to the Public Defender's office, because it appeared to me that council may not have been aware that this had come in. All right, Madam Attorney General, is there anything you'd like to do?
And there is a couple of points. Thank you, Judge. And I do appreciate the court sending that to me. And I think that we're going to have to make a record on this, whether or not Mr. Williams is really competent, in fact, to represent himself. You did make it clear to him at the last hearing that if he does choose to go forward on his own behalf, he has to serve the people. He did not serve us with any of those motions. So I do appreciate the court sending that to us. I think the court statute and the case law is very clear that he has a right to. However, it must be knowingly and intelligently done, and that the court is going to have to make him aware of the pitfalls, the dangers, the disadvantages of what that really entails. He does not have an absolute right as well to question the victims in this case. And so I think that's the Daniels case. I bring that up for a very specific reason, and maybe Mr. Williams needs to hear this as well. Mr. Feaster is aware that I did file a very substantial, extensive other acts notice with the court way back in January, and served it upon Mr. Feaster. It is extensive in that the people have put the parties on notice that I intend to produce an extensive amount of domestic violence and sexual assault evidence at the exam if Mr. Williams intends to, in fact, hold his exam. So he needs to be aware of that and be prepared to knowingly be able to address that at the exam. And so that is one of the issues that I wanted to address as well. One of the other things that I wanted to ask, I know Mr. Feaster said that Mr. Williams is going to want some additional time to perhaps go to the law library, do some research and file some additional motions before deciding whether to set an exam. I have absolutely no objection to that, because if this does go to exam, I expect it will be lengthy, 10 witnesses or so, and we have some out-of-state witnesses, so I have no objection to that. One thing I am going to ask of the court to consider, and obviously the court doesn't have to consider that today. If this does go to exam, I would ask you, Judge Simpson, to consider retaining this case for exam. I know that you're very busy and your docket is very busy, but because you are aware and you've had this case since January, you are aware of the unique challenges and issues in this case, you are ultimately probably going to have to make a ruling on whether or not Mr. Williams is going to, in fact, be able to represent himself going forward, at least at this stage. And because of the length of the exam, I'm going to ask that you at least consider retaining this case for purposes of preliminary exam.
Since you brought that up, I will just, it's a very quick answer to that. I realize based upon what had previously been filed, where this case started, that it was probably going to be in the best interest of judicial economy and otherwise that I do retain the case. And so that is my intention.
Thank you, Judge.
For you, Honor, if I may address to the court, you please. For you, Honor, first I'd like to take and state to the court that I have went through and looked at some constitutional statutes here. I said on October 12th, I constituted as a kidnap. You said it was an arrest. I was not given no memorandum of right. I was taken off the bus. My property was taken, and I was informed by Mr. Pritchard that they were telling me they can't find my property. So evidently, I constituted as a robbery. Over $30,000 have been taken from me. I have 3 children, are minors, and they have been taken away from me after their mother has deceased on July the 21st of last year. That's how I got this money. This money was the $20,000 came from the insurance policy, and the $12,000 came from Mariana grocery store for where I was injured, where I was jumped on. This is how we found out.
Okay.
May I address 2 points, Your Honor? I know you're very busy. Mr. Williams.
Mr. Williams.
Thank you. I appreciate it. You said this is my hearing. I'd like to take a speak.
No,
Mr.
Williams, no. Mr. Williams, this is my hearing.
Fifth
not
Amendment
yours.
right, and the 6th Amendment right, the 8th Amendment right, the 9th Amendment right, and the 14th Amendment right.
One more word and you're muted.
I've been denied all of
Mute
these
him.
rights.
Madam Attorney General.
Thank you, Your Honor. I did not get a chance to address the discovery just because it's an official, I don't know if it's official, Your Honor, but it's a filed motion for Mr. Williams. Mr. Feaster was delivered a voluminous amount of discovery in January, and obviously he is the one who has the right under the court statute to the discovery and to share it with his client if he chooses. He said he's done so. And just with Mr. Williams, this is the second time he's brought up his minor children and getting out for his children. I just want the court to be put on notice. Mr. Williams was residing, and by his own statements to law enforcement for 20 years in Chicago, Illinois, and he was not the children that he is speaking of were not in his care and custody. They are here in the state of Michigan. He was not taking care of any of those children. So I just want the court to be aware of that.
All right, very good. Mr. Feaster, go ahead. What were you going to say?
I don't know if another competency referral may be appropriate in this case, Your Honor. I'm having difficulty communicating with Mr. Williams. My thought is that I can have our social worker at our office go and meet with him and speak to him, and she can maybe give me some guidance and advice on next best steps for dealing with Mr. Williams and trying to move this case forward, Judge.
And Your Honor, he absolutely has a right to an independent, and I obviously would not be able to voice any objection to that. And I think that I don't even have a concern with that at this point. I think the report was short. The last report we had was kind of basic. It was kind of short. It didn't have a lot to it. I would agree on that point. But Mr. Williams has brought up 2 points that I know we can't ignore over the last 2 hearings. And I know Mr. Brown was present at the last hearing. He keeps referring to a chip that is inside of him. Mr. Feaster and I are in receipt of many, many medical records for Mr. Williams that do not cite to anything that he is talking about. So that is concerning to the people that he keeps very zealously referring to this chip that is inside of him. He's asked you twice to order it be removed. I don't know what he's referring to. That's concerning to the people.
Yes, there's a number of, quite frankly, what's being said by the defendant that is concerning to the court, and particularly the relief that he's requesting of the court. Mr. Feaster, in terms of an independent, are you going to be making that request, or?
So yes, Your Honor. So my initial thought was to have our social worker speak to him, since she has more versed with mental health than I am, and to get her take on that, Your Honor. But I do think an independent is going to be necessary, given the statements that Mr. Williams is making and his request to represent himself. And I just want to make perfectly sure that he is competent to move forward before we put him in a position to put himself in line for a potentially very long prison term, Your Honor. So I would like to make sure he is able to proceed and aid in his own defense, Your Honor. So I would like to move in that direction, Judge. Yes.
All right. Well, let's do it this way. I'm not going to even, and I realize when people have brought this up, I'm not going to even address any medical issues, whether it be a chip or anything else, until such time as this defendant, we get through the issue regarding competency. It becomes difficult, I think, also given what the defendant has said, for the court to even properly address the defendant's desire to represent himself, because I'm not clear that without additional information, the court's not clear that that decision on his part is even voluntary. I couldn't in good faith say that, given what he's saying to the court and what he's expressing to the court. So I guess, Mr. Feaster, how long would it take you for your social worker to make the attempt and maybe be successful in speaking with Mr. Williams? How long will that?
I can put in an emergent request, and I think she could go see him within a week, Judge, and evaluate him. And then if she determines an independent is appropriate, I can seek approval from our management to get that started, Judge.
All right. And I don't know how long that process would take. So I am inclined to just adjourn the probable cause conference with that. There is also, and at this point, you are counsel record, there are also these motions that, this motion that has been filed. Here's how I'm going to lead the motions at this point. If, as counsel of record, you deem it appropriate that they be filed, then, or be heard, then somehow or another, either that you'll sign on to these or place these in some form that the court can understand them and that the prosecution would be able to answer if necessary.
Yes, Judge.
To the extent they need to be. So you had originally requested a month adjournment. Are you still requesting that time period, or did you were looking at something else?
I will still request at least a month, Judge, because I think we have a lot we have to tackle here in this matter. And so I request at least a month, please.
Mr. Feaster, the master of understatement. All right. Without objection, I will adjourn this as the probable cause conference. I'll adjourn this out to July 21st, 2022, 9 a.m.
Thank you so much, Judge.
Thank you,
The
Judge.
bond will continue as denied. Mr. Williams, I'm going to give you one admonishment. When you come back on the 21st, if you're going to represent yourself at some point, regardless of what it is, you will conduct yourself properly before this court. You will not try to overtalk me, because that will not happen. All right, am I understood? You can nod if you understand me, because I'm not unmuting you. Okay, there is no nod. I've said what I've said. I will expect your behavior, and that you will govern yourself accordingly. Thank you, folks.
Thank you, Judge. Thank you,
Judge.
Attorney General.
Thank you, Mr. Feaster. Judge, my good friend Yasmin Tucker wishes me to convey, she says hello to you.
Tell her hello and let her know that we've forgotten her name.
Don't even know.
Don't
Dead to
even
you.
know her.
He's dead to you.
Thank
Have
you.
a great day. Thank you, Judge.
Thank you.
Following these hearings, a competency evaluation was held. Mr. Williams was found to be competent to participate in his own defense. So, how do you know when the shit show's about to begin? It's easy. It's when Mr. Williams walks in with a filing cabinet worth of paperwork. This isn't going to be pretty. Lord help us.
Here we go. Court does call the case of the people of the state of Michigan versus Isiah Williams.
Good morning, Your Honor. Danielle Russo-Bennett, Assistant Attorney General, on behalf of the people.
Good morning, Your Honor. Danian Woodson on behalf of Mr. Williams.
Okay, to do this, Mr. Williams, can you state your name, please?
Isaac Vernon Williams II.
All right. I do have the forensic evaluation. Did everybody get a copy of that?
Yes, Your Honor.
Is there any additional information regarding the issue of competency?
Not from the people, Your Honor. We would stipulate that Dr. Jeffrey Wendt, if he was called to testify,
Yes, Your Honor.
he would be testifying consistent with his report that Mr. Williams is competent.
And defense stipulates to that as well, Your Honor. I have had an opportunity to talk to Mr. Williams after reviewing the report, and I do agree with its findings at this time.
All right. The court, upon reviewing that report, would find that the defendant is competent to stand trial. Specifically, the court would indicate that based upon that report, the defendant understands the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I would need an order regarding that filed with the court so that I can sign off, but I will sign off once we receive the order.
Okay.
Okay. So where do we need to go from here? We need to set for a preliminary examination, I'm sure.
And Your Honor,
That's-
I apologize. I didn't mean to cut Ms. Woodson off. I do need, we had talked briefly via email whether it was going to be a waiver or a hold. I think he is going to hold. It is probably going to be a lengthy exam, Your Honor. So it might have to be done in parts because I'm sure the court cannot dedicate an entire day to us. But I am just going to respect
Well,
for a few weeks.
well, I had given my promise way back that I would hear the case and that I understood that might take at least a day. So yes, we do have a date that we can dedicate to this, sort of foreseeing this coming. I do have April 25th that we can begin it. If it's going to take other days, then I could look at my schedule at that point. But
I am in a trial. Well, I'm in a trial it's set to go to the 26th. It could be done before then. It starts on April 19th in Genesee County. I do, you know what? And I also have another date on the 26th in Wayne County. So I'm going to be unavailable that day, unfortunately. I'm sorry, Judge.
on the 25th?
Oh, on the 25th.
Yeah, on the 25th. I'm sorry.
Yeah, I'm hopeful my trial will be done in Genesee County by that date. If it's not, I will contact the court immediately and try to make other accommodations. But let's go ahead and grab that date since it's a good date for the court.
All right. Miss Woodson, will that work for you? Where'd she go? She dropped? No.
Well, Your Honor, if I can address the court, please.
Well, hold on. I got to get your attorney back.
Okay.
Can we try to contact her?
Yes.
All right, Mr. Williams.
Yes,
and
Your Honor.
Attorney General, just sit tight for a second. We're going to get Miss Woodson back, and then I'll continue
Right.
the proceeding, okay?
I think what Mrs. Wilson, the attorney Wilson, was going to bring to the court attention, because I spoke with her yesterday, and I bring it to her attention that I will be standing pro per persona.
Okay, Mr. Williams,
Yes.
I'm not going to hear anything until she's present. Okay, here she comes.
All right, Your Honor.
Hello.
Hello, Miss Woodson.
Sorry. I
Okay,
think
there
I
you are.
have picking up. Yes.
Okay. I was setting the preliminary examination for the 25th at 9 before myself.
April 25th or
April 25th. And I don't know how much of
I
what was going
started
on
jury
that you
trial on the
heard.
24th.
Pardon?
I said I started jury trial on the 24th, Your Honor.
Your Honor,
Okay.
I do want to make, I mean, I know we have a lot of movement. Sometimes dates need to get made. I do have 3 witnesses I got to bring in from out of state. So, you know, we should obviously have a date that's gonna work. For
Yeah, that's firm. Okay.
After that, May 23rd is your next date.
Okay, I'm just gonna have to, May 23rd would be my next prelim date, but we're gonna have to just give a Monday. Yep, we'll just make a date.
Your Honor, I'd appreciate it. You'll let Mrs. Wilson bring it to the attention of the court that she is being relieved of as my counsel.
Hang on, Mr. Williams. What?
Monday, May 1st.
That'll work. Well, let me see. Did you say, will May 1st work?
I think so.
I don't know. Will that give enough time to get the witnesses here?
I will do my best, Judge, and at the very least, and I don't want to bifurcate it, but if we have to, I can at least get some of the in-state witnesses on and at least get this going on May 1st.
That's fine.
I think that's probably our best option because I know the court's so busy. Let's grab that date.
All right, Ms.
And that
Woodson,
works for me as well, Your Honor.
that would? Okay. So
Yes.
that's the date we'll go with. Mr. Williams wants to address the court. Go ahead, Mr. Williams.
Yes, Your Honor, Mrs. Wilson is being relieved as my attorney. That's the first thing I want to bring to the attention of court. And also I wanted to ask the court that I need to be understood what the court has been holding me for a year. And then I find out here that there is a hearing set for, as it stated here, for June the 1st of 2023 to determine whether or not Olisa Susan Williams has been considered as even dead. That's what it states here, but the court has already issued this here case number 23-000104-M.
I don't, first of all, Mr. Williams, as to that part, I don't know what you're talking about.
Well, they're saying you holding me on behalf of this individual being dead. They're saying they haven't determined as being dead.
What Dipstick there is talking about is Alina's mother filed the paperwork necessary to have her legally established as deceased. Someone has to have disappeared for, I believe it's 5 years. An individual whose death is not otherwise established under this section, who is absent for a continuous period of 5 years during which he or she has not been heard from and whose absence is not satisfactorily explained after diligent search or inquiry, is presumed to be dead. The individual's death is presumed to have occurred at the end of the period unless there is sufficient evidence to determine that the death occurred earlier. So even though, unfortunately, her body has not been recovered, her mother is still able to have her declared dead. You may ask what the purpose of this is, considering she was still an infant when she passed and would not have any assets. We did see this, something similar to this. I'm not sure if I ran the case, but there was a wife and her husband had disappeared, and she jumped very quick to try and get him declared dead, even though the statute says a period of time. If there's sufficient evidence, the courts can do it sooner in some states. This was Florida. That happened. It turned out she was involved in his disappearance. Bad times. In this case, in a lot of cases, it's about closure. Having that death certificate actually closes the chapter for the families and gives them that sense of peace. In other cases, it's about settling the estate and dividing up any assets that the deceased person may have and passing that along to heirs.
Judge,
Okay.
Mr. Williams, okay, Your Honor, what he's referring to is, I believe he was served with a probate matter because mom is finally, now that the charges have been filed, she is pursuing a death certificate in this matter. That's why he's being served with that. This is a homicide case, and we are alleging Miss Olisa is very much dead.
Yes.
So then
Okay,
I would
that
like to
answers
bring
that.
my attention, you understand that, because I asked the court and filed with the court for account, you understand, by a licensed physician, the coroner, to determine what their claim it is. I have nothing, you
Okay,
understand, about
Mr. Williams.
there's been a death.
Mr. Williams. Okay, the first thing is, are you intending on representing yourself?
Yes.
Okay.
And I also would like to be brought into the courtroom, you understand, to represent myself and not on.
Oh, you will be here.
Thank you. I appreciate that.
You will be
Thank
able
you,
to see me in all splendid color.
Thank
Yep,
you.
that day.
Thank
Okay,
you.
so we got May 1st. That's the date that you'll be here. Right now, Mr. Williams, I'm going to leave Miss Woodson on the case.
Okay, also, Your Honor, can I get a copy of the motion for discovery? I've been asking for a year. I've stated that to the court, and I keep being denied a copy of the motion for discovery. Now, the United States Supreme Court justice said that I'm entitled to a copy.
Oh,
of the
Mr.
motion
Williams,
for
Mr.
discovery.
Williams, Mr. Williams,
Yes,
you
Your
want
Honor.
discovery. I
I've been
believe
asking for it for
discovery has
years.
already been provided to your attorney. Did you ask your attorney
The attorney
regarding
doesn't
that?
have a copy. I asked her, she doesn't have it.
Your Honor, I do have discovery, and I have given discovery to Mr. Wilson,
You
Mr.
have not
Williams.
given me a
He's
copy of
talking
your
about a
motion for
very
discovery. I'm
specific
sorry.
motion that he filed for discovery. I do not have that. I'm not sure when he filed that motion, but in terms of police reports and things like that, he does have that.
That's not a motion for discovery there. That's why you understand, I don't need you as my counsel, Mrs. Wilson, because you don't even know what a motion for discovery is.
Oh, she knows what it is. She
But then
found it not.
would she want to take a comment here on a murder case and don't have a copy of the motion for discovery?
She has discovery.
No, she does not, Your Honor.
She does.
No.
She very
She have
much.
a
It's been
state
turned
police
over.
report. That's not a motion for discovery.
Okay, look. I am not going to sit here and argue with you, Mr. Williams.
Oh, I didn't realize I was arguing with you, Your Honor. Forgive me, please.
All right. I'm telling you, your attorney has discovery. We went through this before. Additional discovery was provided. It's been made, that representation has been made. There would then be no need for a motion for discovery because it's already been provided. So I'm done dealing with that issue, sir.
Well, then I guess.
May
we can
1st.
Go to the next thing. So.
Thank you, Your Honor.
Well, Your Honor, are you saying then that you have something to provide me that Olisa Susan Williams by a coroner, a licensed physician, or someone to state that they will? We know there is a death, or have been determined by the court that there is a death, and that you have grounds that can hold me, you understand, regarding, you understand, a charge of death. This is what I need, because from what I've been getting in the courts and what has been presented before me, it does not, you understand, bring to my attention. Nor
Okay,
does it
all right.
take. That's why I.
Mr. Williams, Mr.
Honorable-
Williams,
The honorable
Mr.
president.
Williams,
asked the
let me
president
stop
to see if he
you.
would look
Let
into
me
this matter.
stop you, Mr. Williams. Come May 1st, or maybe shortly thereafter, the people will be putting on evidence that there has been a death.
Thank you. I'd appreciate it.
And so that will happen.
Thank you, because I think that's what we need here to take and try on me on a charge, and death have not been proven. What we got here is accusation.
Well, I think
I've
it
got
will
something
be.
here brought to
We'll
my
have to wait
attention.
till May
Bro,
1st.
Can I bring this into your attention, what it was given to me? I was given a copy, and it's dated here for my arrest, and it's dated back here. It says Detective Daniel Everson declared a death in 1982.
Okay,
Now, I've been incarcerated. They told me that I don't have true knowledge, but they said I've been
Mr. Williams, Mr. Williams,
95.
Mr. Williams.
Yeah.
Now is not the time, now is not the time for what you're trying to tell me.
Well, I'm just trying to establish here, and he's had a death this here time.
I understand what you may be trying to establish,
Oh, you do?
but there will
Thank
come
you,
a
Your Honor.
time
appreciate
where
it.
Mr. Williams, Mr.
Your Honor.
Williams, there will come a time I will hear from both sides.
I appreciate that.
And right now, I've set that for May 1st. So you can keep talking at me if you want,
Well,
but
Your
it's
Honor,
not
I'm
gonna do
gonna
you
take
any
it
good, because I'm just gonna tell you, I'm gonna hear it May 1st.
God
What'd you say?
forbid. I don't want
Your-
to disrespect you in any kind of way. God forbid.
Yes, Miss Woodson.
I know the court has kept me on, I guess, as second chair to Mr. Williams. I would advise him to stop discussing the case because things that he says can be used against him.
Okay, I don't need to follow up on that, but you're right. All right.
Also, will you have, Mrs. Wilson, will you provide me with everything you have regarding my case after you've been resigned from my case? Any documents that you have, please.
Okay,
provide me
Mr.
with
Mr. Williams, Mr. Williams,
Yes, Your
you
Honor.
had an opportunity to talk to Ms. Woodson. You've got a very good attorney. Ask her for it. And just ask.
Oh, I sure will.
Don't be trying to make all your demands like you're trying to do with me. If you just
Oh.
ask her,
Excuse
she'll
me,
cooperate with you.
Excuse me,
Okay?
Mom.
All right. I think then we're done for today.
Thank you,
bound
Your
to-
Honor. Have a
You
great
have a
day,
blessed
everyone.
day, and the
Continue.
peace of God be with you and your family. God bless you, and thank you for the.
Or
your
maybe we're not
time.
done. I think the Attorney
Judge,
General
I
may
just
want
have
to
to
say
ask.
something.
I just have to ask, I'm ready to start on May 1st. Does the court have time on May 2nd? I do have an expert witness that is available on the 2nd. If the court's got, if we need to continue, will it be continued on the 2nd, or will we be continuing it on a different?
We would normally give another date. Let me
Okay.
just check.
That's fine,
what-
Judge. I just wanted to check.
What's this?
The next day is currently being held for unintended cases. And we did.
That's fine.
You set those on the second? Okay, but those are the remaining 61 Arbor One cases. Oh, so what we're gonna do is I'm gonna give them May 2nd. I'm gonna give them May 1st and the 2nd in the morning. And we'll move the Arbor cases maybe to the afternoon, or we'll move them. But we'll give them May 1st and 2nd. We'll just do it that way.
Okay, and my expert is not available to the afternoon, but if we still have people who are
okay.
on May 1st, we can just, I don't want you to move your docket, Judge. I don't want you to have.
No,
to-
no, it's okay. We'll do what we can.
We'll just plan for the 1st and then we'll go from there, Judge. That's fine.
Sounds good.
Thanks, Judge.
All right.
Fine.
Thank you, Your Honor. Have a great day, everyone.
Great
Thank
day.
you.
Yes, I will now. All right, thank you.
Bye-bye.
Bye.
For cause the case, people versus Winona Harvey. I'm good.
Or I forget.
They're on my desk. Does call the case, People State of Michigan versus Isiah Williams.
Good afternoon, Alex Peterson on behalf of the people.
And good afternoon, Your Honor. Danian Woodson on behalf of Mr. Williams, who is appearing live from the Washington County Jail.
Yes, he is here, and so that the record is clear. During yesterday's proceedings, Mr. Williams was here, tried to leave, did not. He stayed through the entirety of yesterday's proceeding. Day shortly before the time at which these proceedings were to begin, the court was informed that Mr. Williams refused to come up from his cell. So the Washington County Jail has been wonderful in making an accommodation, and so the court could elect not to have him here and present at all, in essence, forfeiting his right to be present in the courtroom. However, the Washington County Jail has provided a tablet with the use of technology. Mr. Williams can hear, and if he does turn himself around, he would also be able to see the proceedings as they are going on. So he is effectively participating. What we will be doing is we will be muting him so that he cannot speak back and disrupt the proceedings. But if it looks like he's going to say something, I'd ask the deputies in the Washington County Jail that if he does try to say something, if you could let us know so that we could address whatever issue he may have at that moment, if it's relevant to any of the proceedings. So, having said that, is there any objection, given the circumstances, to proceeding in this fashion from the people? Any objection from defense?
Not from defense, Your Honor. I would just ask if one of those moments does happen where he needs to communicate with me, that I'd be allowed to excuse myself to just log on to Zoom.
We would certainly, if he wishes to communicate with you, we will certainly attempt to try to accommodate that the best that we can.
Thank you.
Right? Thank you. We had concluded with the last witness, unless there's anything else preliminary. People were still in their case. You may call your next witness.
Next call, Inspector Sarah Francis.
And if you could please come forward and be sworn.
Raise your right hand. You solemnly swear affirm the testimony you're about to give me, be the truth, the whole truth, and nothing but the truth, so help you God. Have a seat. State your first and last name and spell it for the record.
Inspector Sarah Krabs, Krebs.
You may inquire.
Thank you, Judge. Inspector Krebs, where are you employed?
Was it the Michigan State?
How long have you been with the Michigan State Police?
In my 23rd year.
And is there any specific division or unit that you are currently assigned to?
I'm currently the Chief Diversity Equity Officer for Michigan State. I'm assigned to the missing persons unit.
As an inspector or an officer that's assigned to the missing persons unit, what would your job duties include?
When I was in the missing persons unit, we were a missing persons clearinghouse and unidentified remains clearinghouse for the state of Michigan. So we investigated both missing persons cases and unidentified remains cases to try to resolution.
How long were you part of this missing persons unit?
From 2014 to 2019 when I promoted out.
As far as the case that we are here for today, did you have some involvement as far as being involved with the missing persons unit for a Olisa Williams, date of birth 8/10/1981?
Yes.
Can you tell me how it is that you became involved with this particular case?
Detective Iverson from the Ann Arbor Police Department contacted me and wanted to know if we had any unidentified remains cases that could be Olisa Williams. Asked me to kind of do a clearinghouse check on her case to see if, we thought there were any remains in Michigan or even nationally that we thought could be her, or any, child abduction cases that we're currently investigating. So I did a scan back then on all the databases that we checked for any cases that matched her and none matched at that time. And then I did that again yesterday. I checked the same 3 databases to make sure in the gap since I left until the trial today, to make sure that there were no other cases in there.
Before we talk about those 3 different databases, you left the missing persons unit in 2019, correct? So is 2019, am I fair in believing in 2019, that was the first time you had checked for the Olisa remains, or was it before that? Okay.
It was sometime probably in 2016 that I did the initial.
And as far as this clearinghouse check, I think you indicated you did another one yesterday evening before testifying here today. Is that correct? Let's talk about these 3 different databases. Can you tell me what one of these databases are that you checked?
One is the NCIC, which is the National Crime Information Center. Records are held by the FBI. It includes both missing persons and unidentified remains records.
Did you check the NCIS? Okay. And NCIC. And in terms of checking it or doing as you said, a clearinghouse check, did anything in your check come up as identifying as matched to Olisa Williams? Okay, let's talk about another database that you checked.
Another database is the NAMUS database, which is the National Missing and Unidentified Persons System. It's run by DOJ and NIJ. It's an online database. It's a more relevant database for unidentified remains than missing persons.
Tell us why it's more relevant.
Well, it has more records in the system than NCIC has for unidentified remains. And that is because a lot of medical examiners who have the burden of identification in most unidentified remains cases don't have access to NCIC.
No.
So they use NAMUS instead.
And in terms of NAMUS, have you yourself done any work in backfilling or putting cases into that particular database? Can you tell us about that?
I was appointed back in 2007 as one of the state experts for NAMUS to start backfilling records into it. NAMUS was a new database at that point. It is a publicly accessible internet-based database. So when we were starting out back in 2007, we had to manually enter all of the both missing and unidentified cases in it. So I started researching unidentified remains cases within the state of Michigan and hand entering them into that system. So upon yesterday's check, we have 334 cases of unidentified remains.
Were there any particular cases that came up in your search that you cross-checked or referenced against Olisa Williams' case?
Well, in this case, this is a juvenile child. So that will exclude most of the cases because most of them are going to be adults in this system. There were only 7 juvenile cases entered to NAMUS presently. And then I was able to go through all 7 of those and exclude them.
And so in excluding each of the 7 cases, would I be correct in saying not one of those cases has come back as being identified as the remains of Olisa Williams? Let's talk about the third database that you've mentioned that you checked and checking for the unidentified remains of Olisa Williams. What is that database?
This would be the National Center for Missing Exploited Children's database. So the Michigan State Police serve as the Missing Children's Clearinghouse for Michigan. We are the sole liaison National Center for State of Michigan for all the records. I checked with the case manager that oversees Olisa Williams' case, which is a current case with the National Center. She's still considered a missing child, and just made sure that there were no pending investigations or cases that we were looking into. There were 2 cases that were cleared recently by DNA. that people had skipped to NCMEC.
Okay.
And both of those were cleared by DNA. So no pending cases for the case manager.
And I think the acronym you used was NCMEC. Okay.
National Center for Missing and Exploited Children.
When you say in terms of after 41 years in that particular database, her case is still active as a missing child, is it fair to say those cases remain active until remains are found?
Yes.
Okay. Do you, is there DNA also on file on a national database in terms of trying to identify remains for Olisa Williams?
Yes. We have DNA from Olisa Williams' biological mother. It is in the CODIS database by DNA. It's running on the national level.
Can you explain a little bit, if people aren't familiar, what CODIS actually is?
So if we take DNA from a family relative of a missing person, like Olisa's mother, her DNA would be profiled. It would be uploaded into the database. The computer system that profiles that DNA and tries to match it to other cases. So her DNA is entered as a family reference sample in the CODIS system. That file in CODIS will search against the unidentified remains database, crime scene databases, all the other parts of CODIS to try to come up with a match. And as of today, there is no match.
So between 2016 and as recently as yesterday evening, has your work as part of the missing persons unit identified any unidentified remains, either locally in the state or nationally, been identified as that belonging to Olisa Williams? Okay. One moment. No further questions. Thank you.
All right. Cross-examination.
Just very briefly, Your Honor. Thank you. Good afternoon. So is it fair to say that if you are not dead, or if you don't recognize that you are in fact missing, you would not be in any of these databases?
It would depend if you volunteer your DNA, or if, for example, you would be in CODIS.
Okay, I'm sorry. Assuming I didn't volunteer any of my DNA, I'm not missing, and I don't have any remains, I would not be in the system, correct? Correct. Thank you.
No further questions. Thank
All
you.
right, Inspector, thank you. May I call your next witness?
You can call Holly.
Please go forward, be sworn.
Take a seat, raise your right hand. You solemnly swear affirm. Yeah. Steve, state your first and last name and spell it for the record, please.
HOLYRSTN.
Thank you. May inquire.
Thank you, Judge. Ms. Rosen, can you tell me how you are currently employed?
Yes, I'm employed at Michigan State University.
And in what capacity do you work for MSU Safe Place? Do you hold down any other jobs?
The job as director includes supervising all programs and staffing and finances, the outreach, grant writing, that kind of thing. But in addition, I do extra witness testimony, and I sit on various boards and professional groups.
How long have you been with MSU Safe Place?
I've been since the program started in 1994. And prior to that, I worked for 13 years at Environment Encounters, which is the emergency program. It used to be called the Council Against Domestic Assault. So I've been doing this work for 42 years, since 1980.
Can you tell us a little bit about your educational background?
Yes, so I obtained a bachelor's in social work from Michigan State University in 1981. And then I obtained a master's in social work also from Michigan State University.
As far as other sorts of training in terms of for your background working for MSU Safe Place, excuse me, what kind of training and experience do you have becoming the director for MSU Safe Place?
I'm a licensed social worker with the state, so I have to get continuing education every year. In addition to the 15 CEUs or credits that are needed every year, I also attend a lot of other webinars and conferences.
You mentioned being an expert witness, but do you also train other professionals in the field?
Yes.
Can you talk a little bit about that?
Yeah, so for years, when I first started doing expert witness testimony in 2001, I worked with the Prosecuting Attorney Association of Michigan to train prosecutors across the state. I did it for years on how to utilize experts. I also have been faculty for PAM for other programs as well, like teaching prosecutors how to look for signs for domestic violence homicides and how to prosecute those kind of cases. And I've been faculty for the Michigan Coalition to End Domestic and Sexual Violence to teach new service providers about various topics. In addition, I've trained law enforcement, different attorneys, defense attorneys, counselors and therapists, and different service providers locally, as in the Lansing area, as well as statewide.
As far as you did mention testifying as an expert witness, have you been qualified in court as an expert witness?
Yes, I have.
About how many times, if you know?
As I said, 100 times, 62 times for prosecution, 23 times for family cases, and 15 times for the defense.
May I approach, Your Honor?
You may.
Ms. Rosen, I'm approaching with a 4-page docket. Excuse me, People's Court Post 59. Do you recognize this document?
I do.
What is that?
That's my CV.
Okay. And does this reflect your educational background, employment background, and the like? It's essentially a very, very detailed resume, essentially, correct? Okay. I'd ask that People's 59 be admitted into evidence.
Commissioner Wardier,
No objection, for example.
but 59 is admitted.
Thank you, Your Honor. Ms. Rosen, how, in terms of you being qualified this many times as an expert, is there a specific area of expertise you've been qualified as an expert in?
Yes, violence and sexual assault cases as well as trauma. To explain non-intuitive victim response, perpetrator tactics, context, and other factors.
Your Honor, at this time, I'll turn over to voir dire to counsel in terms of qualifications for Ms. Rosen before I ask for her to be.
For that purposes only, I'll stipulate your expertise.
All right.
Thank you.
Relating to the, okay.
And again, I had asked if you qualified in the wide variety of what she outlined in her testimony, specifically domestic violence, sexual assault, trauma dynamics, Your Honor.
She is an expert.
Thank you, Judge. Ms. Rosen, did you have an opportunity to review the case materials that we are here for in terms of Olisa Williams and her mom, Denise? Statements, police reports, timeline chronology, and the like. Did you also have an opportunity to meet with me a couple times and discuss some of the factors and the facts in the case? Okay. You mentioned working 42 years, I think it was. I mean, if my math is wrong, I apologize, with survivors interacting with domestic violence perpetrators, correct? I think you said since 1981? Okay. You also have experience, you mentioned, training service providers about these particular, what we would call perpetrator tactics, correct? Okay. Can you explain for the court what you would qualify or what you would define as perpetrator tactics when we're talking about domestic violence or intimate partner violence?
So it's any tactics or behaviors that are used by someone who is selecting, grooming, or abusing somebody that they are targeting. Domestic violence.
Are all perpetrator tactics going to be exactly the same case to case, or do they vary? Okay. When you are providing this training to other service providers, are children ever part of the equation that you factor in when looking at particular perpetrator tactics?
Yes.
Can you talk a little bit more about that?
Yeah, so children are often used during a relationship that is abusive, and they often are used post-separation after a victim and the police are worried about their relationship. So the children are used in a lot of different ways to punish and control adult victims.
What kind of situations, in your experience dealing, well, let me ask this, right that. You have dealt with the practical side of domestic violence and the academic side. Is that fair to say? Yes.
Survivors and the academics.
Yes. You've worked in the shelter setting, you've worked in the academic setting, correct?
Yes.
In terms of working in sort of the real life setting, what kind of situations have you seen in your experience to quote unquote punish the adult person in the relationship?
Use children or pets and or pets to control the victim, to threaten to take the children or to take the children. For instance, if the victim is attempting to leave the relationship, they might use or neglect the children, take the children to make sure that the victim does not feel intimidated and worried about the children's safety in terms of child support or other issues. So it's often related to relationship, child support, or calling the police on them and prosecuting. So using children to dominate and control the victim, because a lot of victims are very concerned about the safety of the children. They can take a lot of children for that's a successful way to dominate and control.
And is successful ways in dominating and controlling the victim, is that similar to how you would talk about tactics of using the children as leverage?
Yes.
Okay. Let's talk a little bit about the acts of strangulation, if we could. Did you, in reviewing the discovery, read some allegations of strangulation to multiple people that are involved in this case? Okay. Did you read it as involved to an ex-girlfriend and as to the mother of Olisa in this case? Let me ask about the term strangulation versus choking. In your expertise, is there a difference? Is it a different terminology? Help me understand that.
Yeah, so choking is when food or some other object is lodged in one's throat. So there's a gagging or choking action. It can be good sexual assault when there's a forced object or penis, for instance, but it's usually food that gets lodged in the throat. Then there's strangulation, which is putting pressure on one's neck and that's not oxygen. That can be done with hand, with leg, ropes, with anything that restricts the ability to get oxygen. And it is very dangerous, resulting in either death, near death. Then there's suffocation, which is covering your mouth and your nose at the same time. So people typically use strangulation and choking. Maybe because of the word choke, hold perhaps. The people, victims, usually use the word choking. I'm referring to
Have you found that in your experience dealing with survivors in shelters and the like, that survivors will talk to you about being choked by their perpetrator versus strangled?
Yes.
Is strangled more often used as a legal term?
Yes.
Okay. In terms of you reviewing the documents in this case with the ex-girlfriend, Mary, is that the name you recall? Okay. Mary, making some statements that the defendant made to her during a strangulation episode. Do you recall reviewing that? Is there any significance in your mind, based on your expertise, to statements being made like this during a strangulation episode?
So often when abusers strangle victims, whether it's in domestic violence assault or sexual assault, survivors often report that abusers are also verbally telling them ways that they should do it. So they literally are holding the victim's life in their which is terrifying enough, but many times abusers will also tell victims, I can kill you, or I can kill you later, or I killed other people before. So there's lots of ways that abusers will add additional comments to the strangulation experience. And that escalates or increases the terror.
You mentioned being in this field dating back to, I think, 1981. Have you seen a change in the way law enforcement and survivor advocacy groups deal with strangulation in the 80s versus today, even the 70s, if based on your research, versus the way we handle those kind of cases today?
Yeah, so shelters started in the late 70s, early 80s in the United States. I started working at that time. The shelter programs that I knew of and I would just stick with intelligence never asked about strangulation as a screening tool when the shelter is. So that's the same with law enforcement, as we would review police reports and work closely with law enforcement and prosecution. Even that's years has been increased awareness about strangulation being tied to sacrifice, reality, and things like we believe that a lot of local law enforcement entities, not just in Michigan, but across the country, are now screening for community restrictions. And I know that a lot of domestic violence programs are pledged to do that.
In terms of your work, we talked already about batterer tactics and the commonality of using children as leverage. Have you worked with a lot of quote unquote parental kidnapping cases and cases where children have been used in that manner?
So I've worked with thousands, 5,000 domestic violence survivors since 1991. And I would say that I'm aware of many cases cases involving kidnapping at some point of either the parent and the children.
When there's an allegation of domestic violence occurring in a relationship, can you talk about or address children being conceived outside a relationship and any potential risk factors that you've seen in that particular relationship?
So there's a danger assessment scale where people can be trained on doing assessments with survivors to determine the reality of the factors in having a child outside of an abusive relationship. Because abusers like to be in the center of attention, they like to be in control, and if there are children from a past relationship, they often treat those children differently, more abusive, neglect, or using them as leverage more the children they might physically have in common with. And then the children can see during the time that someone has left an abusive relationship, people come and go many times. If the child is conceived in between that time while they've left and they are still then getting together in the future, abusers often will target those children. That's also legality in terms of the children.
In terms of specifically not just children, but child abuse, in your work, have you seen any sort of correlation between domestic violence, intimate partner violence, and child abuse? Can you talk about that a little bit?
Yeah, so domestic violence, is one result of abuse another, but the children also are affected and impacted, and they are exposed to domestic violence. And even if they are never abused or neglected, they experience trauma. But many times children are also harmed accidentally or intentionally by an abuser as a way to again punish or control they've done worse because they don't have patience and they are terrible. Right? So there's lots of things as well. This child abuse is highly correlated with domestic violence.
You've talked a couple times about the term lethality. Is there something called lethality factors or lethality assessment? I'm not sure if I'm using the term right.
Yes, so there's lethality factors, and it's tied to the research from John School of Nursing that was done many years ago. Has created a danger assessment scale or danger scale. And there's many lethality factors, and some of them are made others determined.
Are threats of homicide or suicide part of those factors? Are access or use of firearms part of that? What about isolating in terms of isolating from friends or family, moving people up to other locations?
That is domestic violence tactic. It's not solely lethality factors, but it is a tactic that is related to why victims of sexual assault.
Is sexual abuse also part of the lethality factor assessment? Okay. You mentioned already pet abuse. What about extreme jealousy? Rage?
That's an abuse tactic.
Okay. We've already talked about strangulation. Do you consider that in your work part of one of the lethality factors?
Not my decision to evaluate. So
yeah. Okay. Okay. Is drug and alcohol consumption part of what in your field they consider a lethality factor?
It's way less than some of the other factors, but it is a lethality.
You've already talked about children outside the relationship. What about separation of the relationship when a partner chooses to leave the abusive partner? Is that part of the lethality factors?
is when they leave the abusive relationship. Might be all this separation violence. And that's where the risk for lethality increases at the time the victim leaves the abusive relationship. And the domestic violence homicide risks are either for the victim, for the victim's children, for the victim's partner, or for other things, or
The effects of trauma, you already talked a little bit about children, even when they're not abused specifically in the intimate partner relationship, they can take on the effects of trauma. The effects of trauma, is there a standard period of time that lasts for a particular person who's abused?
no, there's no way to know if someone is exposed to a certain experience, whether they will have trauma and how long it will last that their experience.
Does trauma present the same for everybody in terms of things like emotions, memories, and things like that?
Trauma will be quite varied, but if someone is experiencing trauma, it does affect their ability to encode memories, to recall memories, it affects their affect, which is their feelings, which is why you sometimes see people giggling or reporting back, explaining horrific things. Trauma can also affect the brain in terms of being able to move or to speak. Some survivors say they can't even speak, and that's related to emotional trauma. And it also affects the so when people are experiencing trauma, they experience kind of a fuzzy brain, they can't say it clearly. But again, the response that the people have greatly depending on the experience. So that's while they're experiencing trauma, and then there's a long lasting effect of trauma. And that refers to some people will have anxiety, depression, intrusive thoughts, suicide, self-inflicting. There's a lot of different types of trauma. And for some people, it's short-term, for other people, it lasts.
In terms of, you mentioned kind of the fuzzy brain and decision making. Have you seen in your work it affecting actual memory and the ability to recall specific, even traumatic events?
Yes, and so that's why law enforcement and other service providers, including advocates, are trained in how to interview in a trauma-informed way, so that there's open questions, so there's certain strategies that are used to help unlock the memory. And see, people that are recalling traumatic events, they often don't recall the details sequentially. There might be gaps in their memory. Sometimes they're some details one day, other days they remember other details. So it's important to understand the effects of trauma on memory and to help people unlock.
We started kind of this whole testimony off with what your expertise is, and one of the things you talked about was non-intuitive victim behaviors. Can you talk a little bit about what that means?
Yeah, so non-intuitive means doesn't make sense. So, for instance, if somebody is being abused, people either have been abused or have been trained on the topic, work in the field like I do, would just think it's totally wild, they just do. When in fact it's very difficult to leave. There's a lot of factors that keep people staying in abusive relationships and going back. And so that's an example of that.
Let's talk about that specifically before we talk about a few other of the non-intuitive behaviors. Reasons why, and I'm going to say why women stay, but men are also victims in these relationships, as you've seen, correct? But let's talk about specifically here why in a domestic violence relationship, why you have seen some of the reasons why women have expressed staying in a relationship. What are some of the things that you have seen, some of the quote unquote reasons?
So in a healthy relationship, if you decide over the other party, usually maybe disappointed or sad that they will accept it. But when you tell an abusive person that the relationship is over, they're not going to accept it. And so it's not the same. Abuse doesn't end at the time that the victim says, I want to come into a relationship. It's an interesting time for the survivors. They often are stalked. They often are charmed with lies and promises to them. Again, their threateners, their children, or pets, or any loved ones are put at risk. So sometimes it's related to safety. So reasons, because in an abusive relationship, even if there's not a lot of money in the relationship, an abusive parent is going to make sure that suffers financially if they think something. Control that or they find that they can do that. So there's finances and safety reasons. As well, there's a lot of abuse or anything. When the relationship first starts, a lot of times it's really good. That might be short lived, a few days or weeks or months, but victims wanted to go back to what it was like in the beginning. And they are optimistic and hopeful that the person will change. It's also sometimes safer for a victim to just get half of the person than to live their life silently when they are always looking over their shoulders, worrying about being broken, how might be assaulted, it's being kidnapped from school or daycare. And so sometimes it just feels safer to go back. There's also community and family pressure to go back sometimes. So it's hard. A lot of the support people that they had, if they weren't being abused, or cut off during the abuse, now they have left is, you know, the assailant's family, or the abuser's family, and other people that they have relationships with, that make pressure victims to stay. There's lots of reasons.
And you talked about isolation as a particular, perpetrator tactic. Can that also play into a role that the sense of victim being isolated away from a support system?
Yeah, so there's different types of isolation. Physical isolation, where an abuser will actually move someone to a different community or different state or to a rural area where there's not a lot of transportation or access to people miles down the road. So there's the physical isolation, and then there's the emotional isolation. A victim wants to call a sister or a friend or go be with their family, just go out. The abuser will become very interested and jealous. It's easier to just stay home and not contact. So that's more psychological isolation. And then also, if survivors want to go meet people, a lot of times the victims will go and remove them from that party or that social situation or embarrass them, or create scene where other people are put in harm's way. So there's lots of reasons why survivors end up being isolated. It's usually related to multiple tactics.
In terms of seeing the reason sometimes abused parties stay, do you see the same them returning to the relationship?
Yes.
Okay. And in terms of that, do you also see you see the commonality with these abused persons delaying disclosure or not disclosing at all the abuses that they're suffering?
Yeah, most survivors do not share what they're experiencing because they know if they tell other people, or they might contact the abuser in an unsafe situation. So I wanted to differentiate the disclosures from reporting. Sometimes they might have a close friend or someone that about what they want. Then there's reporting, and that's more official according to authority, child care decisions, things like that. And so a lot of people might disclose to a few people, but usually many survivors don't.
Thank you for that. One moment, Your Honor. Thank you, Ms. Rosen. Thank you for the questions.
Cross-examination.
Very briefly, Your Honor.
Next.
Good afternoon. Is it fair to say that your testimony today has been, I don't want to say primarily theoretical, but it's not based on any interviews with any of the victims in this case, correct?
It's very similar to general testimony versus specific.
Okay. So when you say versus case specific, that means you haven't interviewed or talked to anyone involved in this case, correct? Okay, thank you. No further questions.
No one mentioned yet.
We are back on the record in the case of the real estate of Michigan versus Williams. And Mr. Williams is still present in his cell. It should reflect, and the video and audio, as I had explained before, is still operational for him. All right. And prosecutor, you may call your next witness. It's Lord to be spoken.
You seem to state your first and last name is spelled for the record.
Daniel Iverson, I-N-E, Garrison.
Main choir.
Thank you, Your Honor. Detective Iverson, how are you currently employed?
Really going to the issue of his office of Inspector General.
How long have you been there?
He went
Where were you previously employed?
for the previous 29.5 years, I was a sworn police officer in the state of Michigan, 26.5 of those with the police department. Of those 13 years of major crimes that
Okay. As a major crimes detective for the Ann Arbor Police Department, were you what is referred to as an officer in charge of the case that we are here for in court today, Olisa Williams, and the defendant Isiah Williams? When did you take over as the officer in charge of this case?
Sometime in the spring of 2011.
Who was the previous detective or detectives on this case?
Originally, it was assigned to Detective William Canada in 1983 through 1997. Then there was Detective Cypher, and then Detective Caldwell, and then language historical open cases for several years. Right, first.
And did you remain as the officer in charge of the case from 2011 until the point at which it was charged and you left the department?
Yes.
Okay. And in terms of taking over a case of this magnitude, a cold case as it were, what is one of the first things that you did?
First thing I did was find together all the information I could to collaborate with regional police reports that were in existence to track those down. That to require me to go into the archives in the police department, try to gather as much information as I could, probably go to the courthouse and see what records were still available. Also required me to contact all the previous detectives in the case, who was with me, contact with them to gather more information that may not have been captured in the original police report.
As far as the police reports, starting back in 1983, were you able to recover those police reports from the archives and review all of those?
Yes.
As far as speaking to the previous detectives, were you able to do that as well?
Yeah.
Okay, tell us why.
Sergeant Bill Canada passed away probably within 2 years of retirement before I was a member of the police department. I tried to track down his frequent partner, was also, I believe, his relative. He'd also passed away. I tried to talk to all the detectives in the 1980s. I found one or two that were not primarily involved in the case, but had bits and pieces from them.
Were you able to at least review all of these detectives' old reports, their interviews, et cetera, to be able to bring yourself up to speed on what they had done in the investigation?
Yes.
You had indicated in terms of interviewing witnesses, did you interview all the living witnesses that you could in this case?
Yes.
Did that include Mr. Williams' siblings in this case? Betty Peters was one of those siblings. She testified yesterday. Did you interview her?
Yes.
Denise Frazier Daniel was one of the people that testified yesterday. Did you interview her?
Yes.
What about Elizabeth Reese and her children?
Yes.
Attorney Molly Reno? What about Mary Leslie Bryant?
Yes.
One of the names that had come up in the investigation was a Diane Taylor that Miss Frazier Daniel had said she lived with when she was separated from the defendant in the state of Ohio. Were you able to interview her? Tell me why not.
After exhaustive checking various internet databases, information last known location of her was in Tennessee, Nashville, Tennessee, where it was possibly at a homeless shelter. I think within she had passed away.
When you were reviewing Sergeant Canada, his initial investigation, can you tell us, was there an investigation done as far as efforts to locate Olisa Williams alive at that time? Were there efforts at that time to locate Olisa Williams deceased in terms of identifying remains at that time?
Yes.
Were there remains from a baby in the fall of 1982 from New York?
Yes.
Can you speak a little bit about that and whether that was fruitful in the investigation?
For the record, Sergeant Canada had found about this case looking for any unidentified remains, human remains that matched Olisa's physical. He had gone out to contact the various medical facility where Olisa was seen and got her type of information entered into the database at that time. He was in contact by a detective by the New York City Police Department because they had recovered a small female child who somewhat matched the demographics of Olisa. She was found 40 in the Hudson River. If I reviewed the police reports, there was someone seen carrying that body, black African American female. But it turns out the photographs were then sent to him. He was supposed to spend 6 weeks to get there. He then reviewed those photos with Denise and with Elizabeth Reese. They both indicated it was not Olisa.
Okay. And you indicated he had followed up with some medical chart information for Lisa, and did that match her physical measurements either?
No.
Okay. You indicated you had reviewed all the Ann Arbor Police Departments. Are there other department police reports that you reviewed in this case?
Yes.
Can you tell us about some of those?
Well, I was reporting into the criminal investigation to establish a timeline of the offenders, locations and behaviors. So I went about a quest of looking at every single police department that ever has contact with Isiah Williams in the United States. It's quite a vast network of agencies, but many departments throughout Illinois and Ohio and Michigan had contact with them through the years of 1981 to present day.
And in terms of reviewing them, did you also obtain them and put them in your file as part of the discovery in this case? Okay. You talked about court records. What court records did you ultimately obtain and review in this case?
I obtained certain court records in Washington County, also from a briefly testifying in the wrongful death suit of his son, Isiah, in a car accident. Obtained that also.
In part of obtaining these records, are you trying to do anything with respect to your interviews of different witnesses that you've been interviewing?
Well, one of the main points, this seems such a unusual allegation. That one had been in our historical archives for so long as an open case. I thought it was important to collaborate as much as I could possibly of what the witnesses had already said and what they were currently going to be saying.
Two of the specific pieces of exhibits that have already been admitted, and Judge, these were admitted as part of exhibits related 23 through 55 arrests. Part of court documents, 2 arrest cards in this matter, one from the Inkster Police Department in 1982. Another one is the arrest card. I redacted some of it to take out portions I did not think were relevant to our case. Elizabeth, please. May I approach, Your Honor?
You may.
These are people's exhibits 33, 5%, and 42. Do you recognize that? What is 33?
This is an arrest card from looks like Inkster Police Department.
Okay, and did you discuss a September 1982 alleged assault in Inkster with Denise Briggs-Jordan?
Yes, I did.
Okay, is that card reflect an arrest with respect to that assault?
Yes.
Did you also obtain a police report with respect to this?
Yes, I did.
Okay, what about People's Exhibit 42? Is that also what's commonly referred as an arrest record?
Yes.
What are some of the things? Well, let me ask it this way. Is there contempt proceedings that are reflected on there as far as arrests for Mr. Isiah?
Yes.
Did you review the court documents in this matter from the Washington County Family Court?
Yes.
Were there contempt proceedings with respect to Isiah Williams in February of 1983?
Yes.
Did those arrests corroborate that?
Yes.
Was there also an arrest in 1984 with respect to an alleged assault from Elizabeth Reese that Mr. Williams was hoping to be convicted of?
Yes.
One of the things that I believe that you looked into are tips. Do you know approximately how many tips the department has garnered from 1982 and forward on this case?
I remember visiting on the Excel spreadsheet, but the exact number, I think it was close to 100.
And did any of those tips from the public ever produce any viable information with respect to Olisa Williams being found alive or deceased? Okay. You talked already about reviewing the investigation for a deceased baby and remains from fall of 1982 in New York. Did you yourself, were you involved with some potential people who came forward claiming to be Olisa Williams that ultimately did not end up being her?
Yes, I am.
Okay, do you recall a person by the name of Keisha, the last name being Palage?
Yes.
Can you tell us about that?
We had contacted the police department after seeing an age progression image on the National Center for Missing Information website. Was that person? So I investigated her, got additional information from contacted her family members, which I was able to obtain through independent resources, and contacted her sibling, I think her mother specifically, and got details
Was her DNA ultimately obtained, compared with Denise, and it was not Miss Blage or Blage? I'm not sure if I'm correct. Okay. Was there also a person by the name of Cyrell, Syrell Nunali, Nunnally, a 2021 hip?
Yes, that's what so I confused those things. I contacted that last time to her mother and her family.
Did you confirm, excuse me, through a birth certificate that she was not Olisa Williams?
Yes.
Okay. Did you also confirm through her biological family that she was not Olisa Williams? CPS records also record that you reviewed and obtained in this matter.
Yes.
Was that also part of this corroboration that we're talking about with talking to Denise Fraser Daniel and Elizabeth Reese?
Yes.
Okay. You also interviewed someone by the name of Mary Leslie Bryant. Did you obtain documents in this matter with respect to Miss Leslie Bryant? What were those documents?
Miss Bryant had got her own records in file. She expressed to me how frightened she was with Mr. Williams and had kept this information because she wanted to make sure her open investigation since the end of his term was a warrant at the time of his arrest. She wanted to keep those records in case he was ever arrested. True.
We've talked about your investigation and the department's investigation into Olisa and potential unidentified remains. You heard Sarah Krebs testify today, correct? Was she the inspector? I think she was not an inspector at the time, but was she one of the officers you worked with in trying to identify remains that could have been potentially belonging to Olisa Williams? Was that ever fruitful in finding Olisa Williams? Did you also look into the possibility of Olisa being alive?
Yes.
Okay. What kind of things did you look into to see if Olisa could have been alive?
When I contacted Mr. Williams' siblings, there was always a working theory that he had somehow placed her with relatives out of state. So I spent a significant amount of time contacting these relatives of this relative, seeing if anyone didn't choose her. Was able to locate some business relatives in Alabama, and everyone he did, he didn't even really know him. Could not.
There was you were sitting here during the testimony. I know you reviewed the documents. Sherfield, Alabama, in the affidavit. Did you follow up on that particular city?
There was discussions in the reports that perhaps he had gotten one with the municipality of Sheffield, Alabama. So I contacted the captain of Sheffield, Alabama Police Department, asked him to check the human resources records for that. He later contacted me and said he had checked their records, all that time.
Were you able to ever check any tax records or student loan documents against the information that you had Olisa Williams to see if anything had been opened up under her information?
Yeah, I contacted the United States Secretary of Social Security Administration Office of Inspector General. I also contacted the U.S. Department of Education Office of Inspector General, requested they try to attempt to locate her through the Social Security number, any usage. They both indicated there was no hourly record of student loan or taxes been filed under me. Also, somebody found out that because she was missing as a child, her birth certificate and her Social Security number had been flagged in the system, and no one had ever inquired on it or had used them.
In terms of, I know that you reviewed the documents in this case, both court and police report, and interviewed witnesses. Were you provided with Mr. Williams' statement about an alleged abduction in Island Park in Ann Arbor? Can you tell us what Island Park is? Can you tell us a little bit about Island Park?
So Island Park is located just on the north side of the University of Michigan Hospital, Maiden Lane. It's about a 6.5 acre park. It has the Huron River runs through it. 1 acre, that 6.5 acres is a little, and it has a great statue. I mean, facility on like a building. You go to, there are 2 parking lots there. There's a lower parking lot, upper parking lot. As you travel east to the park, there's one parking lot with a higher one. So upper and lower parking.
Is there a body of water in that park?
Yeah, the Huron River branch that runs through that.
Do you know whether any department has ever searched the Huron River, whether it was 1982 or present day?
I talked to a detective who said that he recalled in that time period that they had drugs that here and there, but I could never collaborate that with any. I also contacted the U.S. Coast Guard because the currents flowed down to the anything land that would recover. So I think they also contacted the Ohio jurisdiction along that pathway and the Canadian side of the board to see if it remains them covered. No, she never.
In reviewing the court documents, specifically the affidavit, one of the affidavits filed by Mr. Williams' attorney, was there information provided in there that the defendant had been living during the specific time period of 1982 with family in the city of Ann Arbor?
Yes.
And that he also had been residing temporarily at a motel in the city of Ann Arbor?
Yes.
Did that same document we're talking about indicate that he had gone to Alabama in July of 1982? And that's the investigation that you did in following up on that particular fact in this case. Have you interviewed the defendant, Isiah Williams, multiple times in this case? Okay, let's talk about a couple of those interviews. Was he interviewed also by your predecessor, Sergeant Canada? And did you review the statements with respect to that?
Yes.
Did that include the statement about the abduction at Island Park, if you know?
I think that from front of them, that information provided.
Was there any other information that you're aware of that was provided to Sergeant Canada at that time? Okay. Let's talk about February 20th, 2014. Was that your first time, to the best of your memory, that you interviewed Isiah Williams? Okay. Where was that interview? Where did that take place?
To Mr. Williams' residence inside the city of Detroit.
Was Mr. Williams at his home in custody or out of custody? Was he free to leave? Was he free to refuse to talk to you? Okay. Tell me about that conversation.
Probably my purpose was going to his residence to ask him and make sure I had learned from the other people that he had contact with this. Oftentimes he would be very agitated about child support issues. So I wanted to make it perfectly clear when I went there to him that I was not there to try to put any child support or anything like that, but just to get the find answers where whatever happened to Olisa.
Okay.
So I really clear it was just going to find out where she is.
Did Mr. Williams indicate that he had any knowledge about Olisa?
Never didn't.
Did he indicate whether he knew someone by the name of Denise Williams or Denise Frazier Daniel? Okay. Did he indicate to you anything about his memory?
Yeah, he said that 2014, November 2014, he said that he had been at a bar and the bartender had spiked his drink. He drove away, crashed his car, and sustained caused a head injury, and he had no memories of his life before 1995 in the traffic accident.
So he indicated to you that this was from a car accident. And at that time, did he indicate to you anything that the head injury was due to a poisoning? Did he indicate to you at that time it was due to anything that had happened to him in prison, that something had been implanted in his head?
He said he had no memory of his prison 10 years back.
Okay. Did you ask Mr. Williams at that time if he had taken Olisa Williams to the state of Alabama? What did he indicate to you?
He didn't remember. He would get kind of agitated and say, how would I take it?
At that time, if you asked him about his years in prison and he indicated he didn't have any memory of that, did he indicate whether he had any memories of the decade of the 1980s?
No memory.
Did he talk to you at all about brain control and anything like that? Do you recall him talking to you about that?
Yeah, he did mention that police can involve themselves in mind control and get letters to every senators up for us.
After this interview, did you invite or talk to Mr. Williams about possibly interviewing him and speaking with him again?
Yeah, Mr. Williams had expressed that he had traveled back from Alabama for some doctor to help him jog his memory of his life before the traffic crash. So that gave me an opportunity to express him, but I had developed some timeline was like to help him with that. Invited him to the station and be willing to drive with the residents help him.
Was he receptive to that? Would he commit to meeting with you again? Before your next interview with Mr. Williams, did you make efforts at that time to follow up on some information about a clinic or organization in Alabama?
Yeah, traveled to Alabama to go to the Alabama Brain Institute, I think it was, for treatment. And that's where he had met that doctor that referred to, eventually get treatment and come back to Michigan and from younger.
Did you contact, I think it's the Alabama, does the Head Institute sound right? Okay. Did you contact that organization? Were you able to confirm whether they were a treatment organization?
They were purely advocacy.
Okay. This advocacy organization, did they do any medical treatment at all? This advocacy organization, did they require any medical documentation to allow Isiah into their program? And you confirmed that with the Institute?
I talked directly to a person who knew him, who was there, and had just received a referral for his records to go to Detroit.
Was that Debbie Dean? March 1st, 2014. Does that sound correct as to the next date you tried to speak with Mr. Williams?
Yes.
Okay. At that time, where do you recall trying to speak with him at?
During our February of 2014, he had expressed how busy he was and he was his calendar. And when there was one Jensen point, which is our neighborhood public school, so myself and Texas.
It appears on that date you made 2 separate attempts to talk to Mr. Isiah Williams on that date.
Yes.
Tell me, were you successful in speaking with him?
Yes.
Okay, tell me what, if anything, was said.
He said he had no memory, but he might be able to recall something if I were able to produce some kind of short documents related to the identity of the police. Fraser Daniels didn't scare us. She was known for her marriage. And so I didn't know why we were there. He became sort of sweating profusely. He had nervous and fidgety, and voice got raised with us, most like he was trying to make a scheme in front of everybody. So we left and then went back to the station for retrieved the court documents that he kind of outlined what he'd like to see. And we came back around.
Did he want to see those documents when you came back with them? Okay, did he look at those documents?
He sat down, looked at them, we gave him plenty of space, and we sat there and watched him for about 15 minutes to read over the documents.
Okay, and did you proceed to ask him a series of questions then?
Yes.
Did he answer those? Did he have any memory at that point?
He claimed he had no memory, he did not know what was even talking about.
During this particular interview in March, was Mr. Williams, in your opinion, cooperative with answering your questions? Okay. Can you elaborate a little bit on that? Was he evading you in any way?
We never answered questions directly. It's a base of when I pointed it out to him, he got more agitated. So he caused more of a scene.
Fast forward to the year 2021. Did you have the occasion to go see Mr. Williams in the city of Chicago? Okay. Can you tell me why it is that you went to Chicago?
What happened to Olisa? Opportunity for him to tell it. We were not at gas. Like more to talk to us about it.
Was he living there at the time?
Yes.
Okay. So where is it that you ultimately had this interview with Mr. Williams in Chicago?
Mr. Williams, I was one more central Chicago. It's a four-story YMCA. It's about 300 single room residencies there. They all share common bathrooms on the floors. And found them there.
When you first began interviewing Mr. Williams, did he indicate this time whether he had any memory of particular people you were asking about? Okay. What was his reasoning on this particular occasion for his lack of memory?
He said that he had been poisoned. Is this the first time he brought up the poisoning to you?
Did he bring up the car accident to you this time?
I don't believe he did it. The first time.
When you brought up the subject of Olisa Williams, what was his demeanor? How did he act?
Well, it's interesting. We had spent so with him, hadn't even asked why he was there. So I told him that we were there talking about what would happen to Olisa Williams. He then got really nervous and started straightening things out in his little apartment and seemed to get kind of agitated and nervous about it. And so we said we had, I was there with another executive, the communications where I expressed to him, we got information might help him with his memory, since he didn't remember Denise or Liz Reese, anything, so he says, wedding's very slow.
How did he react when you showed him his marriage license to Denise?
Seemed to look at it for a significant amount of time, it's kind of awkward, and then he eventually said that that signature had been forged.
So he denied the signature on the marriage license was even his. Did he say he did not even remember the marriage initially, but then denied the signature was his? Did you ask him about Mary Leslie Bryant? Did he claim whether he remembered her or not? Did you ask him about his time in prison in the 80s? Did you bring up his prior statement about this alleged abduction in the city of Ann Arbor that he had told Judge Campbell about in Washtenaw County? What was his response to that? Did you bring up the topic you've mentioned before that you didn't want to bring up in your first interview, child support? Did you bring it up this time?
No, he did.
Okay, tell me about that.
He was talking about some woman and gone to court and when children went there and so forth. And I think I asked clarifying questions about who that. So it was a Liz woman named Liz and discussing his kids then, yeah.
What was his demeanor or emotional state when he was talking about this, about the child support and being taken to court for child support?
Yeah, actually, it was just claiming that child support was really so disability and everything. And that was really source of contention for him. Seems that
When talking about Olisa and Denise, did he indicate at any time that you should bring Denise to him? Tell me about that.
so he might be able to help me if I just brought Denise to him, so he could talk to her and see what he would have to do.
Made this request that you should bring Denise Frazier Daniel to him. Okay. At the end of the interview, when you were talking about child support again, how did he react to this, and how did the interview ultimately end?
And when we were talking about it, yeah, so I had the kid told us something.
Okay. And did you do that? This interview, was he out of custody?
Yes.
Was he free to come and go as he pleased? Okay. Was this interview captured on body cam footage?
Yes.
You've talked about this statement that he first gave you about this brain injury being from a car accident. Then you said in 2021, he mentioned a poisoning. He never mentioned a chip in prison being implanted in his head, to the best of your memory? You heard some of the testimony in court, correct? From the children? Okay. And sitting here today, you don't have any memory of that. After you visited Isiah Williams, did you learn who his emergency contact was at that time?
Yeah, he had 21.
Yeah.
The plaza had listed his residence and his son was Scotty Williams, his wife's contact.
Okay. And did you in turn then go interview Mr. Scotty Williams?
Yes.
Okay. As part of your investigation, did you investigate this claim by Mr. Williams that he had this closed head injury and therefore lacks sufficient memory to remember his life or any of the people in it?
Yes.
Okay. You've already talked about going to the Alabama or talking to the Alabama Head Institute. Did you take statements from his ex-wives and his children? Was that in an effort to sort of try to get information about this alleged brain injury?
Right.
Did you also obtain some medical records in this case?
Yes.
Your Honor, may I approach?
You may.
Detective Reimer said, I am approaching with People's 57 and 50, People's 58. Can you tell me the direction of 57? What is 57?
These medical records of the St. Joe Mercy Hospital, Ann Arbor, that took such one.
And what about Exhibit 58?
These are medical records pertaining to Isiah Williams from the University of Cincinnati Medical Center.
That for a 2-year period of time, I believe 1995 to 1997.
Yes, it is.
You obtained both sets of those medical records, correct?
Yes.
And you have reviewed those records thoroughly in your investigation of his alleged brain injury and lack of memory.
Yes.
Your Honor, I have access to those 57 and 58 in a minute.
Any objection?
No objection, for
7:58 are admitted.
Thank you, Your Honor. Let's talk about first the medical records for 57, the St. Joseph medical records. Those records indicate they are from February 10th, 1994 to February 11th, 1994, correct? What is the subject or the reason, from the best of your memory, on why Mr. Williams was being treated at that time?
Those records corroborate the information that Mr. Williams shared with us in February 2014 that this car accident he claimed to have been involved in. He later in an interview on February 2014, towards the end of it, I asked for if he had any records because he had a large relief case for documents to look at the one brought to the court. If he had perhaps a traffic record for he could introduce one to us from February 1994.
Were you able to, in those records, see one note of a self-report of a head injury in that record? Was there any information in the totality of those records of any follow-up testing sent to any neurologist or anything of that like? Was there a CT of the brain that was in those records? Did anything come back unusual or abnormal in that CT scan that you saw? Was there a CT of the head in those records as well?
Yes.
Was that negative? Was there neuro checks that were completed and that were documented in those records?
Yes.
Were those normal or abnormal? Was there anything in those records? Well, let me ask this. Does it indicate in there that he was released to a relative, like a sibling?
Yes.
Okay. Is there anything in those records from St. Joseph Hospital that indicates Mr. Williams left that hospital exhibiting lack of memory, memory loss, or amnesia? Was there a doctor that you ultimately followed up with from those records and did an interview with?
Yes.
Okay, who was that? Okay, if I refresh your memory with Dr. Cropsey, okay, does that sound familiar to you? Was there any information you were ever provided that there was a follow-up neurological exam or anything like that that was ordered by Dr. Cropsey? As far as the Ohio records, the records from 1995 to 1997, there's indications in there that Mr. Williams indicates he'd been in a car accident, correct? Okay. What kind of injuries are reported by Mr. Williams or symptoms of injuries does he report in those records?
Someone's actually supposed to back in for.
Okay. Did you review one 1995 November PT record where he reports a closed head injury? Is there anything else in those records by way of neurological exams for a closed head injury? Is there anything in there reflecting that Mr. Williams had reported amnesia or lack of memory about who he was? One moment, Your Honor. No further questions. Thank you, Detective Iron.
Cross-examination.
Good afternoon. So, is it fair to say that the checks and the investigations that you did on the birth certificate and social security number, all that was done basically searching the name Olisa Smith, correct? Olisa Williams. So you weren't using any other social security numbers or any other dates of birth, right? So if Olisa Williams assumed a different name and a different social security number, your investigation wouldn't have shown that, right? And you said that you could not find anybody to corroborate that back in 82, 83, that the Huron River had been dredged at that time, correct?
And the police reports and the arrest records and everything you researched, none of them showed any child abuse or any violent actions towards a child, correct? As it relates to Mr. Williams. I mean, there were domestic violence incidents, correct, with his spouses and ex-girlfriends.
Right, there was one of his children from his current, well, his last marriage, there was a child.
Were they tied to Mr. Williams? Was Mr. Williams subsequently convicted and sentenced for those? Okay, so he was not convicted or arrested for that, correct? Okay, thank you.
Just briefly. In review of those CPS records, who was Kimberly in the care and custody of when she sustained those injuries? Okay, and did CPS take action with respect to Kimberly based on those injuries? As far as any other social security or any other name, we never provided any of that information or Olisa Williams to be able to check into that. Thank you, Judge.
Sure, you may step in. Thank you.
No further witness reports. Just ask for 3 seconds to set up the computer.
All right. Any witnesses for the defense?
Oh, Your Honor.
All right. We'll step off the paper more. I gotta make a quick phone call. She's gonna set up her computer and then I'll come back. Okay.
All right. Okay, listen, report, probably watching them, they're missing. All right.
You seated. All right, we're back on the record in the case of the People versus Isiah. Counsel is present. Good for argument. Motion.
Thank you. Thank you, my court for the day.
So how does she not have any icons? Do you know that?
That's number 16.
Oh, my bad. It's like, how do you get through life? You know, there is nothing to click on. That's right. Everything's there. So, who are we watching then?
Pleasure.
Just enough out of dead.
That's my right, correct? That is the right law table.
Yep.
But I.
Good broadcast.
Yeah, and normally it goes black on. Oh,
There she is.
no.
Oh, you had to turn hers to the stuff. Gotcha.
All right.
Never, it's never happened to me.
Thanks, guys. Thank you for your patience. And I think that the case is clear, circumstantial evidence, reasonable inferences is what we're talking about here. And it's very important for the court to make those reasonable inferences from the evidence that we have. And I think that it's a very common misconception that you need a body for a murder case. And I'm saying that to Mr. Williams too, whenever he's listening. Because that is a very common misconception all across the state. Let's talk a little bit about Olisa Williams. She was born August 10th, 1981. The defendant, Isiah Williams, is her legal father, not her biological father, based on the testimony that we have. She was taken on or about April 29th, 1982. She was last seen in July of the summer by multiple people in 1982 in Ann Arbor, in Michigan, in Washington County. She has not been seen as of Saturday. That's this Black Saturday, 21 minutes. The evidence points to murder, that she was murdered in July. He left to go to Alabama at the end of July. She was last seen at the beginning of July. He did not discount her in the United States. There's probable cause that she is deceased, that she did not die of natural causes, that she died from a homicide, that the homicide was committed by the defendant. This is one of the defendants that was admitted. This is what decades later Olisa Williams would look like had she been alive, but she is not alive. The evidence points to her being very much deceased, Your Honor. We're asking for a bind over on count 1, the only count charged here, open murder, that Mr. Williams did murder Olisa Williams.
There is no degree that is required here under open murder. No evidence of premeditation, no deliberation required under case law. But of course, motive is always relevant. That's why the other acts here, especially the other acts than Denise Frazier Daniel, are so important. And I would submit they're not even other acts when it comes to Denise Frazier Daniel. They are part of the case. They are evidence of the defendant's motive, his opportunity, his premeditation, and his deliberation, even though that is not something we have to at this stage. The case law is clear. There's prior threats, prior feelings of ill will, that deliberate action on the part of a defendant, and premeditation. Evidence of marital discord, either known to the defendant's spouse or showing the case. That was all things that came in under Denise Frazier Daniel's testimony in this case. Corpus delicti, we don't have any corpus delicti issues, even with the lack of a body. There's no corpus delicti in usually this multiple statements that we put in the defendant. His admissions, his confessions, they are all admissible. We have circumstantial evidence of a death that was the result of a criminal act or an agency. That's the McMahon case. The body is not necessary. Again, people need Williams and people need Modesti. Testimony of a medical examiner is not even essential or requirement. Where there's competent and substantial other evidence of unnatural death or injury. Then people early on in this case designated and filed documents stating that a venue here in Washington County, that was under MCL 762.3. But let's look at the totality of circumstances that we have on this evidence. Look at the court documents that have been admitted. Isiah Williams, through his family court attorney, said, I temporarily lived on Pittsfield in Ann Arbor at Motel in Ann Arbor. There was attached copies of the driver's license prior Ann Arbor addresses. The testimony of him in family court was that he had her in Washington County in Ann Arbor in an island park when she quote unquote disappeared or allegedly was abducted. This, as I submitted this court, this false abduction story. Testimony that from Elizabeth Reese that she was seen at a hospital in Ann Arbor and at her house. Again, we have multiple pieces of evidence that points not only in having her in the venue of Ann Arbor or the venue of Washington County, but that's where he killed her. That is where he killed her and ultimately where she got her demise. So a couple cases I do want to talk about. Unpublished case law here in the state of Michigan, holding no-body cases. In people being raised, Court of Appeals affirmed a first-degree murder conviction with the body of the 13-year-old victim that was never found. The victim was to meet the defendant there under false pretenses. She was last seen at a meeting place. There was a white van there. The evidence was that the defendant later replaced a white van that he had and got rid of some stuff with some total records he had. He denied knowing the victim in this case, then later admitted to a particular person that he knew where the offender was, although the body was never recovered. He took a picture of her. He admitted he had a fetish for 13 and 14-year-old girls. And he admitted to an inmate awaiting trial that he was going to trial because he won't kill the girl. We know that Isiah Williams, telling multiple stories, but he has told multiple people that he killed this child. People being Phillips, the Court of Appeals also affirmed this second-degree murder conviction. This is a very similar case to our Sherman. A body of a 4-month-old never found. The defendant sent the victim's mother a letter in the case that the child was now at peace. The child was thrown from a car seat. That's how she died. An inmate, also an inmate, said the defendant was bragging that he wouldn't be charged with murder because they never found the body. Again, think back to Mary Leslie Bryant's testimony. They never found the body and killed him. It's very similar to our case, both in that regards, the fact that in the Phillips case, he had a very tumultuous and violent relationship with the victim's mother, and the defendant was not the biological father of the victim in that case. There's a direct parallel to that lethality factor, that tactic that we have, that issue we have based on the expert testimony of Holly Rose. All the evidence that we have, and it talks specifically about some of it. Fact is, he is the last person that is seen ever with Olisa Williams alive. He makes multiple inconsistent statements. He makes false exculpatory statements, and I'm going to talk specifically about those. The false abduction story and the closed head injury. Those are false exculpatory statements. Court can also look and make reasonable inferences. This conscious guilt, right? Inferences based on his conduct, his behaviors, and his statements. Leading from those things, reasonable inferences of the defendant's guilt. The timeline and taking of this child is fleeing to Alabama. That is going to be a question of fact for the jury based on the jury charge. Flee to Alabama, or did he go there for a job? I'm submitting to you he fled to Alabama after he killed this child. Olisa was a child. Denise was the primary caregiver. She would be soiled and dirty when she left her. It was been reset when she brought him over. She was soiled and dirty. He was not the primary caregiver for this child. She has been gone as of Saturday for 41 years. And the other acts evidence, the substantial violent propensity towards women and children violence that we have here. And we're going to talk about that. Last person to be seen with Olisa. Elizabeth Reed saw her at the hospital in Ann Arbor multiple times and at her house. He then, at the end of July, takes the defendant to the bus station. No luggage, no Olisa. The defendant resided in the state of Ohio. His mother was sick and dying based on the testimony of Liz Reed, and was dead by September, by her funeral, September 2nd. Why did Isiah Williams suddenly flee to Alabama with no luggage and no time? It was into the court because he had killed the child at that point. Verna Williams Anderson, Kimberly McGrath, children were defendant. They also saw that child at the house. None of these people, none of these women ever saw that child again in 41 years. After the defendant left that home with that child. We're talking early July 9th or 10th, a couple of weeks before Verna's birthday, July 22nd, when the defendant goes to Alabama. So within a couple of weeks, she's gone, never been seen again. Betty Peters also saw the child in the state of Michigan in Washington County. She was a nurse for U of M Hospital. She also saw the child with her brother. The defendant never saw the child. The defendant has told Denise, as well as other parties, Olisa died of a fever. That was disputed by Denise checking all the local hospitals, no record of a child dying of a fever. I gave Olisa away. You heard from Detective Irish said the death was looked into multiple ways in the investigation. Hundreds and hundreds of tips. Nobody's ever come forward with Olisa. Olisa's across the water. Doesn't make a lot of sense, but nothing really came from that. Olisa was taken from a park while I slept. This is one of those false exculpatory statements. The legal father was caring for this child. She was abducted from your car, and you never reported it to the police. That is inconceivable. I think it was Molly Reno that incredulous. And then I killed him. He said this multiple times. He admitted he said this to Elizabeth Reese. I told Denise this. I was just trying to torture her or mess with her. I forgot what the exact language was. But he also made this specific threat to Elizabeth. I killed the woman. I killed the baby. They never found the body. And he's doing this while he's strangling her. And he's telling her, I will kill you too. More statements that he made. Think back to that September 1982 assault at the motel. He thinks to Denise. I'll tell you where I was at. He has no intention of turning over that child. That child's gone by September 1982. The charging date on the information or complaint rather is the year 1982. But I'm submitting to the court by September of 82 that child. Give me money and I'll give them this back. Many witnesses testified money is an impetus, jealousy is violence. Many are violence. But that grew up to a violent assault where she had to jump from a second story window to get away. His admissions of guilt are huge, Judge. He told Denise he killed Elise, told Mary he killed her baby. She didn't think anything of it except her life was being run. She didn't even know he had children at that point. And then he threatened Elizabeth regarding her grandmother, ending up like that baby. False exculpatory statements. The case law is pretty clear on this, Judge. There's got to be, at least a record, and I think we did very much make more than probable cause of a record here. That the statements that he made are false, even by circumstantial nature. This Island Park abduction story is false. His close head injury and lack of memory, whether you are to understand it by poisoning, car accident, or a chip implanted in his head, which I've known he said to you several times, Judge, throughout these proceedings. He has said them several times that those are racist memories. We have to look at the totality of the circumstances, whether the statements are false. people in Jackson. The testimony at court as evidence of false statements, that's the Wackerman case. You will see from those court documents that I know the court reviewed the exhibits already. There was a February 1st, 1983 contempt proceeding where this man testified on the record about the false abduction story. Judge Ross Campbell subsequently put him in jail for contempt of court. That tells you about the credibility of that statement. And you can use that as substantive evidence of guilt as rapidly as it did. Consciousness of guilt. Inference of incrimination only from the words and actions of the defendant. So we've got many different versions of what happened to Olisa. If you gave her away, stick to that story. If she died of a fever, take us to the hospital where she's at and have a funeral for her. Why are the stories continually changing? That is the inference of incrimination. The abduction story that was never reported. The admission of Olisa that he killed her and made her body. False statements to Elizabeth about Denise, right? Where's Denise? Elizabeth asks. Well, she's in Ohio. She's here. She's here. It's fine. We know when he goes to Alabama, he tells Elizabeth Denise has her. But we know Denise did not have that baby at that time. It's another consciousness of guilt. Where's the baby? Olisa Williams said that. He fled to Alabama in July of 1982. He did not have Olisa with him. Why did he flee? Talk about that. The story about not having any memory and his multiple reasons why he can't even keep track of how many versions about why he doesn't have a memory. What I'm going to submit to the court is he kept telling people one version. Then he told people the abduction story, but it was so ridiculous, it's so over the top that he realized nobody was believing that. Not his siblings he was telling, not his children, not his ex-wife. That suddenly it dawned on him when he went to prison in 1984 for abusing Elizabeth Reed's memory. I'm going to just shut it down by saying I don't remember what happened. I don't know her. I don't know you. I don't know. The fleeing to Alabama. So he brings Olisa to Elizabeth and her daughters in early July, 9/14. By the end of July, the day after Verna's birthday, he's suddenly on a bus to Alabama. The testimony of Elizabeth support that, and the statements in the affidavit, all in the court documents. They are purporting a statement of the defendant, affidavits filed by his attorney. He resided in Ohio. His mother, Elizabeth Reed, said he was very close to his mother. Why is he leaving right then when his mother is dying? They have no knowledge of close family in Alabama, not Betty Peters, not Elizabeth Reed, not Denise. And then Detective Iverson followed up on that. Nobody in Alabama had that child. Nobody was close enough for him to give that child. And he didn't have her when he got to her. He didn't even have luggage. Why would he suddenly up and leave to Alabama? She was killed before he left. He only came back to Michigan because his beloved mother died and he had to attend her funeral. I would say to the court that's the only reason he returned to Michigan where he killed Olisa. And let's look at the criminal jury instruction 4.4. And again, this is going to be a question of fact. Should this be gone over for the jury? There's evidence that the defendant either tried to run, hide, did run and hide. That could be innocent, right? We all know it could be innocent. Could he have gotten a job there? The evidence supports that he did not get a job there, based on Detective Iverson's testimony, and all the circumstances. But a person may also run or hide because of consciousness of guilt. That's what I submit to the court we have here, a consciousness of guilt. He took off after killing Olisa. Olisa before was a healthy child who saw the immunization card. She's updated on her immunization. Denise was the primary caregiver. You, as the judge presiding here, can look at the credibility of Denise Ridgevando on whether she was a good primary caregiver for that child. She was 8 months old when she was taken, completely dependent on the care of the defendant who took her from her mother's arms. We are not talking about a 25-year-old woman who decided to go off to Europe and start a new life. This is a baby who was completely dependent on that man. And who last had custody and control of that child. She did not go off and start a new life. He killed her. It has been 41 years. Look at the timing of the taking of the child in conjunction with the testimony, the general testimony of Holly Rose. Denise had already tried to divorce the defendant one time before. That document is in evidence. It was dismissed because the defendant could not be found to be served. Denise had already moved out. She was leaving. She said she was intending on divorce. She lived with Diane Taylor. The defendant had assaulted her the day before and locked her in the closet and would not let her out. CPS had to get involved because she couldn't even get back to Olisa. He was losing control of her. He takes her to punish Denise, to control Denise, to torture Denise. Did he premeditate the killing at the time he took her? I don't think the court even got to look at that. He took it to control her because he wanted to control Denise. He flees to Michigan where Denise follows him with filing for legal separation and he gained custody of Olisa. So now he flees, and by June, she verified the documents to tell him, I don't care what you've done. I'm still leaving you and I'm taking my kid. It's at that point that she's probably thinking about child support, and which we know is a hot button issue with him based on the testimony, and that sets him off. He has to get rid of this child. So quickly, the timeline, and I will focus on this too much, what is really paid very close attention to testimony. But let's look at back in Ohio, April 29th, 1982. She's last seen in June, July of 82 in the state of Michigan. By the end of July, he's gone in Alabama and not back here in September. She was killed here in the state of Michigan. The evidence points to it happening here in Washington County. The suspect claims this closed head injury. I was in the other acts. This is an open murder case, yes. This is an open murder charge, yes. But make no mistake about it, it's a domestic violence case. This was his legal child, which he shared a residence with, he shared a home with. That is a domestic violence case, and that falls within the domestic violence definition, causing attempting harm, whether it's physical or mental, to a family member or a household member. That is sexual assault, Leslie Bryan, terrorizing, threatening, intimidating. We heard that from multiple witnesses. This is physical harm to his family members, the DV case. Denise's other facts, specific evidence of premeditation, deliberation, motive, and intent here. And the statute in which all this evidence comes in under, along with the prop case, which is the seminal case on this, Montgomery, Brandon, etc., is that this man had a propensity. We can use it for propensity. He had a propensity of violence against not only women, but partners. And Kimberly, we know that the evidence is that he admitted to losing it because his child was crying and pushing her down the stairs, causing multiple broken bones. So we've got abuse on Denise, Elizabeth, Mary, and Kimberly. All of these acts happened before, contemporaneous to, and even after the kidnapping had done. It's a consistent and ongoing propensity of violence by this man. Even if you consider coming in for non-propensity, shows to do what he did, shows his opportunity, his intent, his motive. It shows that there was not a mistake. It was a very purposeful act, much like what he does to all the other like twins. It shows his trying. I'm not going to belabor all the testimony, all the testimony of all of these women, the women that he abused, Denise Freedom Daniel, Elizabeth Reese, Mary Leslie Bryan, his children, Vernon, Scotty, Kimberly. They all talked about, two of them talked about asking Melissa, but they all talked about this false exculpatory statement, not just of the kidnapping, but of this alleged brain injury that's just not so. Betty Peters testified. Sarah Krebs testified extensively. As of last night, searching for the remains, we have not found the remains. That has not stopped these investigators. Dan Iverson and Holly Rosen testified as DV dynamics. So if there's ever any concern for anybody reading this record as to why Denise did not leave, or why Denise stayed, or why she kept bringing this child back, I hope that those concerns would be quelled by the testimony of Holly Rosen. It also seems to put out an explanation of why would this man snatch up this child and kill this child? I think Holly Rosen's testimony puts out a perfectly understandable explanation. He could no longer control Denise. He took what he could control. The child that was legally his, he was on the hook for on that birth certificate, but biologically not his. Holly said it perfectly. Batterers are no longer the center of attention. Isiah Williams was no longer center of attention. And so he took that child. The exhibits the court went through, the medical records were just put into evidence. See from looking at those records, that lack of memory, that amnesia, that is just not so. It's just not corroborated by the records. The family court documents, the birth records, marriage records, and all those documentations are deleted. But those specifically show you, Judge, that in the last 41 years, she has not stopped looking for her child. She has not stopped sending the pictures, the information, social security number. So the idea that Olisa could be out there alive, just living her beautiful, perfect life is inconceivable based on even just the effort of his niece going out there, putting all this information out there. Hundreds of tips and nothing proof. She's not out there alive. Isiah Williams, he is born 10/23/46. He's not the biological father. He's got a propensity of violence against women. He said he killed her. That is an admission and a confession in which this court can look to and use along with all the rest of the evidence. When that is no longer working, I just don't know. I just can't answer your question. I just don't know who you are. These are false and self-report statements and consciousness of failure are the material pieces of evidence that I would ask the court to look to in this case and finding the defendant over on one count to further and reiterate that the lack of a body is just one factor here and one that I believe that we have sufficiently overcome beyond probable cause at this stage. Thank you.
Respond. I would expect to mind over. It does include a level of premeditation that I don't think is even a question of fact here. We have heard from numerous witnesses and we have seen a number of exhibits. The only thing that was established at a probable cause standard is that Mr. Williams is a bad guy. He's done some bad things. He's been very abusive towards women. He's made threats towards them. He's terrorized them for money. But there was no evidence or no testimony about his abusive behavior. In fact, it was the opposite. Ms. Bryant testified that when the baby came over to her house, she and her two daughters took care of cleaned the baby up, did the baby's hair with pictures. She noticed no signs of abuse. The baby didn't seem to be uncomfortable around Mr. Williams. She left. She also indicated that he had given her several stories throughout the year, but she didn't believe it. No one believed him because he's known to be a liar. Liars make up multiple reasons and multiple excuses for a lot of different things. We do know that Mr. Williams was money hungry. He had no problems beating up the women in his life in an attempt to get money. So who's to say he did not give the baby away to someone for some money? We don't know, and nothing has been proven, even at a probable cause standard. If this is bound over, I think it's bound over strictly on character evidence of Mr. Williams being abusive. So because he's an abusive person, he must have abused his child. I don't think that's a proper standard. So I will object to find it based on that.
Just briefly, Your Honor,
Yes.
ever considering that there needed to be premeditation, both the people B. Johnson, 427 Mission 8, 7, 9, 1986 case, people B. Law, B. 43 Mission F, 1, 37, 2000 case, no certification of canon of the murder charge. I would also say, as far as Mr. Williams being a liar, that is just more as consciousness of guilt. You cannot keep a story straight. Where is Williams if she is alive? And if you throw out all the other acts, if you separate sitting services, not Denise, Denise is part of the case. I will submit that it's not specific acts. Throw out Elizabeth Gleason abuse. Throw out Mary Leslie Rifle. If you can, you can separate the strangulation from the confession, which I don't think you can. It's part of the case in chief. But if you throw that out and just look at everything else, I would submit to the court there's still beyond probable cause to believe that she died at the hands of the defendant. She died of unnatural causes of homicide, that she is not alive. Your Honor, there is no, I don't know how we can hang our hats on an infant didn't seem uncomfortable or having bruises in the early weeks of July. That's not when he's still dead. When we have that he had wanted to keep our Kimberly of a similar age.
The court will, let me just say a couple of things before giving my decision. And I think it's worth noting And I think it's important. The court was listening very carefully, and my mom raised me a little bit different, but I'll just refer to them as Denise, Elizabeth, and Mary. It's, as I listened to their testimony about what they went through, let's first of all say that I don't think for one moment that they were exaggerating, trying to make something that was horrible seem worse. I looked very closely when they couldn't answer something specifically. They said, but they were very specific about what they went through. I've been doing this for 23, 24 years. And I'm always impressed, certainly, by witnesses. The stories were hard to hear, certainly. It would be difficult for them to tell. I don't, certainly can't think of any more credible testimony that this court has heard and any more courageous testimony. Particularly, one of the things that was remarkable about their testimony, particularly with regard to Denise and Elizabeth, and you'll excuse me for using their first names, but everything they did and what they put up with at some point was really for the protection of their children. They were almost willing to sacrifice themselves for that. It was not a hard stretch for this court to figure out why did he stay, particularly after the point in time that Olisa was born. She stayed. A lot of ways to try to protect Olisa. She dealt with him because I think in her mind, and I think in terms of what she was saying, there was a great fear that he was going to do something. But if I keep in contact, if I appease him in some way, my child will be okay. Breathe that same thought process. And I don't, sometimes when you're up here hearing these cases, your mind can't sort of hold it all, but you leave certain things behind. But the testimony of Miss Reese when she was talking about being in that speeding car, not knowing what it was going to happen, what was going to happen, hoping and praying that the door wasn't going to open so she could extricate herself from that vehicle while it was moving. She knew she had to get out. And don't forget her words. It was almost as if she wasn't really trying to save herself, but she was trying to send a message to her daughters. I had to let them know I tried to do something. Going through all of that, Mr. Williams, I don't know that he deserves that title. Ends up hitting her in the head with a G-bike because she tried to get away. I start with their testimony because, quite frankly, I realize this is a probable cause here. The case goes way beyond probable cause in what you're shown to me here today. I don't know for sure. I haven't seen it all. But
The cases I've seen. I'll be honest with you, I've not seen a monster like this ever. And what he did to people. I take to heart what defense counsel's arguing that. Yeah, he's abusive when he's does this, but that he isn't necessarily abusive to children or whatever. Listening to this case as it was going on, I thought about that. Well, at the very beginning, the things that Denise was describing, and then also Elizabeth were describing the initial part of Miss Reese's testimony. Because he does all of these bad things, does that make him a murderer? Nothing at that point in the testimony had shown that he had necessarily done anything to a child. And you heard the testimony of Elizabeth, about Elizabeth, or about Kimberly, excuse me. While I was trying to keep the date straight and freely admit this, I had one question for the prosecutor because it didn't come up during the course of the testimony. But the end of questioning Mr. East, she looked back regarding testimony, and then Detective Iverson knew, and he knew that one thing had not come up, and that was the age of the child. And then the question was asked, and I will be honest with you, I thought in my mind maybe she's 6, 7, and she's 2.5. And in somebody's care with broken bones. And that happens while that child, and he doesn't take the child to the house. He does nothing. Now, Elizabeth got there, thank God. Child received medical. I have a whole lot of feelings about the case, but not feelings that cloud my judgment as to whether or not probable cause has been established. I think probable cause regarding charge of open murder has been clearly established by the people. And just in terms of certain facts, you're right, he couldn't have Denise, he couldn't control Denise. So what does he do? He finds her, pushes her down, and takes the one thing that he knows is very precious to her. He takes Olisa. April 29th, 1982, took her. And that was a mom that never saw her daughter again. Because in this court's mind, and based on the evidence, that poor little baby didn't make it to September of that year. Others who were mothers who came into contact with the child, Elizabeth, and they were trying to get him to go away because their intent was to try to get that baby back to his mother, her mother. It didn't work out. He left with the baby. There are these others looking to get back. Others are beginning to ask questions about this baby. They see this baby. They see the baby at the hospital. They see the baby at the home. And they know. And he's giving a story about where Denise is. That doesn't make any sense. Doesn't fit in with where Denise actually was. And he's just making up stories, lying about why he has the baby. Regrettably, we knew that it was going to have a tragic outcome because
is evidenced by his care of Kimberly. He doesn't have the patience to be able to deal with a child. Kimberly had 2.5, ended up with broken bones because she cried. Imagine what he must have thought of Lisa. And then his unexplained trip. And I recall the testimony very clearly because he didn't have bags, he didn't have anything. He just said he had to go to Alabama. He just left. He had to go. And he took him out. No baby that he had been sort of crowding around with carrying. He also then ultimately ends up back here and people begin to question him. And again, he can't keep his life straight. And his children testified to, his children that he had with Elizabeth testified to, when they asked, he just says, he gets agitated when they asked about Olisa. He gets agitated and says he can't remember. Ask about the abuse, he can't remember. All of those horrible things he did, he just can't remember. But yeah, that wasn't good enough. The prosecutor's right, because at some point, he wants to stop being asked about it. So he feigns these various stories of implants in his hip, in his head, and some loss of memory from a car accident, which are not going up, updating medical records, visits to places in Alabama to deal with that frankly don't exist for the purposes of medical treatment. And all of those things, he just keeps saying. Then as I listen to Detective Iverson, when they start to get close to him, and he's no longer really, I think, beginning to fool people because now I'm dealing with police. And sometimes they don't want to talk to you, sometimes they don't want to do this. He decides his best bet and his way of sort of putting it into the questioning is to just say, not only does he not know Alyssa, what happened to her, but he doesn't know his wife, his former wife. He doesn't know any of these people. And he thinks that's going to do it for him. Incredibly for him, at least as it sits here today, that didn't do it for him. Certainly I could go through, I rely upon all the testimony that the court heard. I could go through all of the issues that the prosecutor has gone through regarding the consciousness of guilt. That is overwhelming here in terms of what he did, his stories. He can't even keep consistent, as the prosecutor indicated, to one story. He's making it up. It's like he's throwing these things up against the wall to see what sticks, what people will buy. What he was doing. The last person that he was with, now, baby Alyssa was with, was the defendant, who through right or for wrong reasons was in charge of her care. And then nobody sees Alyssa at some point. He then, outside of the consciousness of guilt of all of his lies and everything, he confesses. It is no doubt in my mind that his statements about the killing of a baby or having killed a woman and a child, having killed a baby and can't find them, is his confession. And so for those reasons, I just want to make it also very clear that I don't look at this certainly on a probable cause standard. And as I've said, I think the evidence is well beyond that of probable cause that the defendant committed the offense of homicide against baby Olisa.
and that he did so in the year of 1982. So for those reasons, the court would find that the people have indeed sustained their burden of proof in this case. I would find the defendant over to stand trial on the offense of open murder. Thank you. Yes, and we probably should have that in there. I will also, for purposes of the record, the defendant filed numerous motions, some of which I dealt with. I've reviewed all of those motions. I would just indicate that each and every motion filed by the defendant on his own, even though he was represented by counsel, is denied, so that the record is clear regarding that. Defendant having been found over on the single count. As to the circuit court.
You're acknowledged to receive the information you stand mute.
Defendant having waived from a reading standing mute, court will enter a not guilty plea at this time. Pre-trial in this matter will be set. Yes, I have. Yes, investment.
So May 17th at 1:30.
May 17th, 2023, 1:30, before Judge Conlon. Bond will continue as denied.
Is that in person? Or is that...
It is likely that that will be, well,
It's in person.
Conlon is in person. I don't know whether or not they will attempt to try to transport him or not. You might want to check with the court on that. Thank you, folks. 14A stands adjourned.
Court does call the case. People State of Michigan versus Isiah Williams. Counsel, please state your appearance for the record.
Good morning, Your Honor. Danielle Roosevelt, Assistant Attorney General on behalf of the people.
Alex Peterson on behalf of the people.
And good morning, Your Honor. Danny on behalf of Mr. Williams. However, as the court is aware, Mr. Williams wishes to represent himself, so I am merely standby counsel for Mr. Williams this morning.
Well, I don't know that I did.
I am prepared to proceed, Your Honor. I am prepared. I just know that Mr. Williams was found competent and he is adamant about representing himself. So I am prepared to assist him in terms of being prepared to proceed, Your Honor. I want to be clear about that. I just don't want to offend Mr. Williams' desire to speak for himself. That's all.
Mr. Williams?
Yes, I'm Williams, yes, I wish to represent myself. I feel as though that the Holy Spirit has directed me to stand, and so I wish to stand.
I understand, I think that part. You are sure that you want to represent yourself?
I am confident that you are.
All right. You understand, Mr. Williams, that you are facing charges that could amount to life in prison.
I'm fully aware that you are.
All right. You understand also, sir, that there's great difficulty in potentially representing yourself that you may have, because I would make you abide by all of the procedures and rules of the court, and I would show you no deference. You would have to know those rules and abide by those rules the same as the people. You understand that?
Yes, I do, Your Honor, and definitely fully aware, and that's why I stand, because the Holy Spirit has inspired me, you understand, that God said, for me to stand. The Holy Spirit spoke to me and said, it's for me to take a stand before this court. The accusation that's been brought against me, it requires me to take and give the answer. I don't think no one else can. And I'm just asking.
Well, but Mr. Williams, you understand that Miss Woodson would not be answering. She'd be consulting with you, but making sure that anything that you want done is done in an appropriate fashion before the court. You understand that that's her role? And to advise you as to how you should proceed in the case.
As I, said, Your Honor, I believe that for me to take a stand, and I would have to take and be willing to whatever the court has demanded me to do. I'm fully aware of the courts. And from what I've been given, as a matter of fact, the Holy Spirit was telling me this morning that it is for me to abide by the court. You have been appointed by God to represent the law, and I'm here to take a stand and represent me as a person accused of the law, and that I think it is required for me to answer any questions that the court has in regards to this matter. And I don't think that Mrs. Attorney Wilson or anyone else can speak on my behalf other than myself.
Okay, but do you understand what this proceeding is?
I thought it was going to be our hearing that I've been asking for a year.
Okay, but-
This is what he finally have come to, who to finally present me with a hearing. Because
Okay,
it's what
but
I've
do
been
you-
asking for a year.
but do you know what this hearing is about?
Well, it is my understanding that they had a witness that they was bringing forth.
No,
before the court.
no, hold on. There are going to be a number of witnesses.
Oh, good, because I counted the witnesses that I had, that the prosecutor had brought against me was over 87 witnesses. And I hope that all 87 witnesses are here because I wish to take a cross-examination.
Okay,
Yes.
Mr. Williams, you understand that this is not the trial in the case if it gets bound over to circuit court.
That is my understanding, yes. Your
Okay,
Honor.
what do you understand is going to happen today?
Well, I hope that the court would have been presented with grounds that feel as though that the charges against.
Hold on. Mr. Williams, hold on. Maybe I asked my question inartfully. What do you think can come out of this proceeding?
To determine whether or not as the court has enough grounds to take the whole me over for trial.
Okay. And you understand how that occurs?
I hope that because you're going to adjudicate this matter, that we bring this around.
And you understand that if you decide that you understand you would have a right to cross-examine the witnesses.
Yes, I hope that would be permissible.
All right. And you understand that the standard is not beyond a reasonable doubt in this case. You understand that, sir?
Clarify a little bit more for you said.
Well, what do you believe that the standard this court's going to apply to the evidence that the people are going to offer? What standard of proof?
I would think, and don't quote me, but I believe that it would be that it has shown to the court that what is represented is to show that the claim of death has been shown and that I am the perpetrator of the death. And you feel as though that enough has been presented here before this court to claim that that has been done. Now, if I'm incorrect, please correct me, please.
Well, you understand, sir, that I am not here to offer you any legal advice. That's one of the reasons that you were appointed an attorney. So that if you don't understand something, it won't be up to me to educate you as to that.
Oh, excuse me if I gave that impression that I was looking for you to do that. No, I was only asking that you provide what you've been appointed for. That's all I'm asking from you. I didn't think that I was asking anything else. Now, if I maybe need to reiterate what I was saying to make it more plain, that I'm willing to understand you're taking a deal here, whatever you do has been acceptable in the court because you have been put in that position. And the Holy Spirit tells me you've been appointed by God, so I know you're going to do God's will. I claim that. Now, I'm not going to ask you to take and give me the law or teach me. I'm just asking you to take and do what you feel is yes. And I'm gonna stand here and listen and.
Okay, well, Mr. Williams, in listening to you, what if I felt that the just thing to do would be to make sure that you had an attorney representing you? What would you say to that? And that you get every opportunity to consult with Ms. Woodson to make sure that all of the questions that you want asked are asked. What if I said that was the just thing to do? What would you say to that?
I was taking that into consideration, and as I stated, I don't believe you would want to go against God's will. Because I believe you to be a man of God because you was appointed by God. Now, if God wanted me to stand as my own attorney, I'm quite sure you would not go against God's will and tell me that you don't want me to stand as my own attorney. That's how I stand.
But what if I felt the just thing to do in this case would be to have you be represented by Ms. Woodson?
Then I would say that you're going against God's will.
I see. And Mr. Williams, you really feel that you can represent yourself?
No, God didn't tell me I was going to represent myself. God told me to stand, and He said the Holy Spirit will give me the word to take and say before the court. So I stand.
All right, but Mr. Williams, you understand that you're asking me to allow you to represent yourself, not just stand, but to represent yourself.
Yes, I'm for that.
Okay, but you just told me that you were told not to represent yourself.
No, I don't think I was saying that. I said that the Holy Spirit, when I was informed, would give me the word to say to address the court. Now, that is my desire to take and do the will of God. And I feel as though that God is capable of answering the court and addressing the court in the manner it should be addressed. I don't have no doubt in my power of my Heavenly Father. And He has already understand that we know that He's capable of doing what I need to be done. So I don't have any fear, not at all. And I don't think you would have any fear toward God's power. Thank you, Your.
Well, that I don't have any fear of His power. What I do have fear of is that you're not clear on how to represent yourself before a court. And that because of that you won't get a just hearing. Because that's my job. My job is to make sure that the hearing is a just hearing and a fair hearing. And that you understand what you're doing. And I'm unclear right now as to whether or not you fully appreciate that.
Try to take it, make it a little more plain, that I'm not making you feel comfortable. And
well, I don't.
You're being represented at the Spirit lead me. I'm not saying that I'm going to take and come forward and say that I'm going to be standing here mute, waiting for the Spirit to speak. No, I'm here as a voice to take and iterate what the Spirit gives me to say. And I will be challenging everything that I feel as though the court is going against the law that was given by Moses and Jesus Christ, His grace, to take and represent, you understand, the derogation of that law. So I'm only, you understand, standing here saying that I don't have any problem, and I'm not feeling as though that I'm confident or incompetent. I'm feeling as though that all I need to do is have you feel comfortable to know that I don't need Attorney Wilson because I wouldn't be happy with her because I'm going to get in. Maybe I should explain to you why we want to have Attorney Wilson. Excuse me, let me see the score, please. I asked Ms. Wilson for a copy of the motion for discovery. I feel as though it was paramount in my case for murder that I have a copy of the motion for discovery. I have asked
The
two
motion,
others, you don't mind, let me
the-
finish.
no, Mr. Wilson, that's gonna be part of our problem here. Because this is my court.
Oh, excuse me, oh, forgive me,
Yes,
forgive me.
I will this time. So are you telling me that you don't have discovery?
No, I've been begging for it.
Your Honor, may I address that? The law is clear. It's by and through his attorney. January 24th, 2022, his first attorney had every bit of discovery. By and through his attorney, he has this discovery.
Thank you.
Your Honor, I could speak behind her. She took a statement before the court, the prosecuting attorney stated, you know, in the last time I was here on March 23rd. Oh, we gave him the motion for discovery. We gave him the police report. Your Honor. you
Okay,
know the
but
police report is
Mr. Williams, you're using words and that's what troubles me. You're saying a motion for discovery.
Yeah.
Are you talking about the motion for discovery or are you talking about the actual discovery?
The motion for discovery has a requirement for the court to present to the defense attorney to prepare their case. And this has not been done.
Whoa, stop for a moment. You started to address me saying you asked for the motion for discovery.
Yes.
So are you asking for the motion for discovery or were you asking for the discovery itself? And do you understand the difference?
Well, now, you have to clarify that because
No, I don't. That's the problem, Mr. Williams. I don't have to clarify that.
Oh,
You have to make your argument to me.
okay.
You started your argument just now about the motion for discovery.
Yes.
I'm telling you there's a difference between the two.
Okay. then.
And so I'm wondering which one you're talking about.
Oh, well, that means.
No. I don't need to see any papers. I need to know which one. No, just listen to me. Which one are you talking about?
I believe it's the United States Supreme Court, goes in Rule 412. Motion for discovery. That's why I was looking here to make sure I'm correctly the statute for the motion for discovery. And I was gonna look here in regards to what it states, and it states here, what she stated, this prosecuting attorney stated in October, March 23rd, that we given him part of it, we gave him the police report. But that's, first thing it states, the first sentence states, motion for discovery, it's what? It takes the state, and it would be divided in what? The names of the witnesses against the prosecutor. The prosecutor's a witness against the defendant that he may have had time to address the matter before the court. And I'm here trying to take a deal here, but they got me all tied up here with this here because I guess they think I'm gonna run away or something of the sort. They feel that I must be bound now like a threat to the court. So let's see if I can reach in here and find that motion for discovery and what it says, because I don't want to take and be here before the court and wasting your time.
Well, too late.
Well, Mr. Williams, look for that briefly approach.
Please. Can I have white noise, please? Yes, sir.
This is the first paragraph of the station, the name and last known address of persons whom the state intends to call.
What are you reading from?
Together with the relevant written and records, statements, moral, it says here, and containing, you understand, substantially the verbatim, you understand, reports and their oral statements And a list, you understand, of, and I don't want, this is basically what it is. He was asking me, what am I talking about? And I'm saying, this is what I read, and it says here, to allow the defense attorney to adequately address the court. And this is what they have not been willing to convey. And I went here not once, not twice, but 3 times, have provided to the court and to the prosecutor asking for permission for discovery. I've asked, not this attorney, but even attorney, you understand, did they give you before? And every one of them say, I got it. I got the police report. I don't need nothing else. Now, I know I'm illiterate. And I stand, you understand, gladly being illiterate. But I'm not going to sit here and tell me you want somebody to represent me and don't feel as though they don't need a motion for discovery to know everything, you understand? that it requires.
Sir,
I don't
Mr.
need it,
Williams,
sir.
Mr. Williams. As I'm to understand, the motion for discovery, to the extent there was one, already has been done. The discovery has been provided. So I'm not sure what you're talking about at this point.
Would you like for me to get this in here to the, and this to the judgment, please?
What are you trying to hand to me?
The motion for discovery?
There already has been the motion for discovery. It's already been provided.
This has been provided to you, and they have given that to the defense.
They've given the discovery to the defense.
Everything that requires in the motion for discovery, they're giving it to the defense.
That they have, that everything is required. They've given it.
Oh, I guess then I must be in another world somewhere because I'm not here before you, because I don't know, I don't have it. They keep telling me I have a copy of it. Well, here's the ticket, and please tell them to give me a copy of this, if they have already given me everything to me.
So, Mr. Williams, how are you going to represent yourself?
As my own counsel, please.
No. How are you going to represent yourself if you're saying that you don't have the discovery, which I understand, certainly from Mr. Feaster, who was before Ms. Woodson, that you had been provided?
And I said to the court, and I tell the court, that it's not adequate. It's not what the law required. And as you, the judge, you are bound to what? Support the law.
I am.
And I'm asking you, do you feel as though they have given me?
Sir, I don't know what they've necessarily given you. I'm not supposed to know.
And well, then that's why I'm explaining to you, they have not. They have not given me what the court required. Not according to the rules and regulations of the law.
All right. Sir, anything else you want to say to the court before I rule?
That's all I have to say then. Thank you.
Ms. Woodson, anything you want to say to the court regarding this?
No, Your Honor, I leave it to the court's discretion. I think that Mr. Williams has made enough of a record for the court to make a very just and wise decision.
Anything else in the people?
Your Honor, I think you've made a record under People v. Russell that, we have to inquire as whether this request is unequivocal, knowing, voluntary, intelligent. I think you've asked the questions. I don't know if the answers rise up necessarily, but I'll leave that to the court's discretion. However, under People v. Daniels and MRE 611A, I believe it is, there are certain witnesses that will be called that Mr. Williams is just not entitled to cross-examine himself. We have to cross-examine him through counsel, specifically Denise Fraser Daniel, Mary Leslie Bryant, Elizabeth Reese. These are all other tax victims, and one is the mother of the victim in this case. There are allegations and evidence that will be coming in of domestic violence, physical violence, and sexual violence. And under the case law, he is not entitled to question those victims. And so I'd ask if the court ultimately lets him represent himself at this stage, that he be not allowed to question those witnesses specifically.
Do you understand that part, Mr. Williams?
I understand what the prosecutor has said, and I can understand the prosecutor's actions because they probably understand too, already understand that I have protected him because I filed actions against him of obstruction of justice.
Mr. Williams, listen closely to my question.
Yes.
Do you understand that there would be witnesses that the people would put on, that if you are to represent yourself, you could not, nor would this court allow you to question them?
And I could not understand why not, that the court would take it to the zone that they.
And Mr. Williams, that's where we run into our problem. There seems to me to be a lot you don't understand about how this would work. I can't, in good conscience, given what you've said today, come to the conclusion that while your waiver might be unequivocal, at least at one point you equivocated on it, but even if I were to say that, I can't say that this waiver of counsel in this case is knowingly being made, is understandingly and intelligently being made. I will say that I think to an extent it's voluntary, but I think I need all of those characteristics to allow your waiver to go forth, particularly on a charge such as this one of open murder. So without anything else, your request to represent yourself in this case, the court having made the finding, is denied. Ms. Woodson will represent you.
Then I'd like to address the court and let the court know that this here is what you have stated before the court, and it is final, and that it will go so that the matter has been adjudicated here in your court, that I will now take it to the United States Supreme Court. I'm going to go to the federal court in Detroit with your denial, and ask that the court provide me with a copy of your denial. Or I can address it as the matter has been adjudicated here before you. You gave me leave to take it to a higher court. That's all I have.
Your request in all of that I at least could garner, your request for a stay for leave to appeal my decision is denied. We will proceed today.
Thank you, Your Honor.
Swinton, you are prepared to go forth.
Yes, sir. May I just have a 2-minute break?
You want to talk to him? Oh,
Can we just have 3 preliminary matters before we take a quick break that I wanted
Sure.
to ask about? We've had witnesses here since 8 a.m. They have asked me about what the schedule will be for the court today. And additionally, just for me, does the court wish me to question at the bench or the table, or the podium or the table? And I'm going to ask for a mutual sequestration order with the exception of detectives Rougeau, Iverson, and Special Agent Fox.
All right.
Those are my 3 preliminary matters.
No objection, Your Honor.
to the sequestration order? Okay. Witnesses are hereby ordered sequestered. As to scheduling, as my days go, I start out looking at it one way and then it turns into something else.
Just because I think we have some we could probably release for a break early, since we won't get to them probably.
Yes, and I don't know what order you're going to call them in. I do have something that I have to take care of between around 12 to 12:30. And so I was looking to have the lunch at that point, try to take care of my other matters, and then proceed into the afternoon. I will go as late as anybody wants to go. The people, in terms of the order that you're going to call the witnesses, to the extent you want to want some of the witnesses to leave and then have them on call, the court's going to have, given what's happened this morning, no objection to that whatsoever. Okay. Was that all 3 things?
Podium or table, do you want me to question the witnesses?
You can, with our fancy new system here, you can do either. So wherever you are comfortable, and when you're questioning, unless you feel comfortable, I'm not going to require that you even stand when you're questioning. So I don't have a problem with that. All right. And so you wanted to talk to him. Okay, so we'll take him back and let you have a private conversation. Court will stand in recess.
All rise. District Court for County of Washington, State of Michigan is now back in session. Honorable Judge David Simpson presiding.
Thank you. You may be seated. Yes, bring the defendant out, please.
Mr. Williams, back in the seat, please.
What would you identify and said no? Just saying. Is that Miss Wilson behind? Are you gonna have a seat? Here. Thank you. We're back on the record in the case of People State of Michigan versus Isiah Williams. I was informed on the recess, counsel is present, and I was informed during the recess, Ms. Woodson, you had something that you needed to state on the record.
That's correct, Your Honor. As the court is aware, the court gave me a break and an opportunity to speak to Mr. Williams. During that break, our communication was not very effective, and Mr. Williams has informed me that it's not so much that he wants to represent himself, he doesn't want me representing him.
And to the extent it requires an answer, I would just indicate that Mr. Williams, because of the court's ruling, gets an attorney. He does not get an attorney of his choice. So understand the record. Are we ready to proceed? All right.
Ready as well, Your Honor.
All right. You may call your first witness. Ma'am, please come forward, be sworn.
Take your seat, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Have a seat. State your first and last name and spell it for the record, please.
Daniel, DENISFRAZIDR-DEN.
Thank you. You may inquire.
Thank you. May I call you Denise? Yeah. Okay. Denise, tell me your full name. Were you once known by the name Denise Williams? You know the defendant Isiah Williams. How do you know Isiah Williams?
I was married.
Okay. How long were you married to him?
About 4 years, 4 or 5 years.
Do you see Mr. Williams in the courtroom?
Yes.
Can you point him out, please, and describe what he's wearing? Your Honor, let the record reflect that Ms. Frazier Daniel has identified the defendant.
Without objection, record shall so reflect.
Your Honor, may I approach?
You may.
Denise, I'm approaching with what has been marked People's Proposed Exhibits 1, 2, and 3. Can you take a look at these pictures and tell me if you recognize them, please?
Yes.
Exhibit 1. Who is in Exhibit 1?
My daughter, Olisa.
Okay. What's Olisa's full name?
Olisa Susan Williams.
Okay. About how old is Olisa in that picture?
She is developmental.
Okay. How about Exhibit 2?
Olisa.
About how old is she in that picture?
Around 8, 9 months.
Who's in exhibit 3? Is that a younger picture of Mr. Williams, what he looked like several decades ago? Okay. I'd ask, Your Honor, that exhibits 1 through 3 be admitted to evidence.
Any objection or voir dire?
For exam purposes only.
All right. Exhibits 1, 2, and 3 are admitted.
Denise, what is Olisa's date of birth?
August 10th, 1990.
Were you married to Isiah Williams at the time of her birth?
Yeah.
Okay. Is Isiah Williams her biological father?
No.
Is he her legal father? Was he on her birth certificate? Your Honor, may I approach?
You may.
Denise, I'm handing you People's Proposed Exhibit 9. Do you recognize what's in Exhibit 9? What is that? Okay. Whose birth certificate is that? Okay, it has your name and Mr. Williams' name as the parents on that birth certificate, correct?
Yes.
Your Honor, I'd ask that People's Exhibit 9 be admitted.
Could Mr. Williams put the bag on the floor?
Mr. Williams, is there a problem with the bag, sir?
No, hold on a minute. Your Honor, you might have to take me back to the bullpen, but it's here the force and the executive out of order. And so if you want to do this here, do it, get it out of my ears. Thank you, bye, let's go.
No,
Take me back to
no, you will have a, Mr. Williams, Mr. Williams, you will have a seat. You will have a seat. Sit down. Now, sit down. You will stay there. Please remove the bag from him so that he is not disrupted. Counsel, you may proceed.
Thank you. Denise, I have to ask, but what year did you meet Isiah Williams?
76.
What he just displayed in the courtroom, is that the Isiah that you know?
Yes.
Okay. How was Isiah during his treatment of you during your marriage?
Abusive.
Physically abusive?
Physically abusive. I ended up in the hospital.
Objection as to relevance.
This is all in the other acts evidence. This was all filed a year and a half ago, Your Honor. Not only is it directly related to motive, premeditation in this case, given the death of her daughter, but again, this is all admissible under 768.27B, propensity of violence against women.
Objections overruled. You may continue.
When you became impregnated with Olisa, was Isiah incarcerated at that time?
I believe so.
Okay. Were you two separated but still legally married? When was the last time you saw your daughter, Olisa Williams?
Oh, she was 9 months old at the time.
And she was born August 10th, correct?
Yes.
You've been interviewed, it's fair to say, by police many times over the last 41 years, correct? Do you recall giving the date of April 29th, 1982?
That sounds familiar.
Okay. Let me ask this. What state were you in when you last saw your daughter, Olisa Williams? Okay. Was that in Ohio?
Yeah.
What city in Ohio? Were you living there at the time? Okay, who were you living there with?
I was living with my friend Diane.
At that time, if you were living with your friend Diane, were you separating yourself from the marriage of Isiah Williams?
Yes.
Were you planning on leaving Isiah Williams?
Yes.
How did you meet Isiah Williams?
He lived next door to my parents.
Did you eventually begin dating him?
Yeah.
Okay, how did the relationship start out?
Started out good.
Okay. Tell me when it was not good.
Was after we had moved in together.
Okay. Do you recall approximately when that was?
Probably about around 77.
When you moved in together, where did you and Isiah Williams live?
On the Plymouth Road in Ann Arbor.
In the city of Ann Arbor?
Yeah.
Is that here in Washtenaw County?
Yes.
Did you have another child at that time when you first were dating and living with Isiah Williams?
Yeah.
Who was that child? Did Elizabeth continue to live with you?
She lived with us, yes, for a time.
At some point, did she not continue to live?
Yeah.
Tell me about why that was.
She had witnessed the abuse that I made it. So my mother had custody of it.
When you're living with him in the city of Ann Arbor, you're not married yet, correct?
Right.
Okay. Tell me how he's physically abusive to you. Tell me what is happening to you.
I've been slapped and choked, and I've been choked till I passed out. I've been beaten.
Did you ever call the police on him?
I have not.
Have you ever gone to the hospital because of your injuries?
Yes.
Have you ever, before you even married Isiah Williams, did you ever leave him because of this abuse? How many times do you think you left him? Tell us about and why you would go back with Mr. Williams.
He would claim that he wouldn't use me anymore and always bring out the term.
Your Honor, may I approach?
You may.
I am approaching with two documents. Both of them are Exhibit 10. Do you recognize these documents, Denise?
Yes. I'm here.
Okay, the first page is the certificate, correct? What's the second page?
Second page is when our marriage life.
Okay. What date and what year were you married to Mr. Williams?
And January 23rd, 79.
1979? And in what state were you married?
Yes, Ohio.
Okay. Your Honor, I'd ask that Exhibit 10 be admitted as a two-page document.
Any objection of voir dire?
No objection for exam purposes only, Your Honor.
Exhibit 10 is admitted.
Tell me about, well, where were you living at the time you got there?
We were living in Michigan.
Tell me about why you and Isiah Williams got married in the state of Ohio.
It was a quick way to get married.
Whose decision was that?
Mutual.
Okay. When you came back to Michigan, did the abuse continue?
Yeah.
I'm going to take you back to Valentine's Day of 1979. Were you living here in Michigan at that time?
Yes.
Were you living with Isiah Williams?
Yeah.
You were legally married to him, correct?
Correct.
Was there an assault that happened to you at that time that involved a weapon?
Yeah.
Tell me about that.
I was beaten with a rifle, and I was trying to conceal myself, and I ended up with a broken arm.
Do you recall if Mr. Williams ever fired that gun at you?
Yes.
Tell me about that. Tell the court what happened.
Shooting at me as I was running, and I really grazed my top of my head.
Well, it did not hit you though, correct? Did you report this incident to the police?
Yes.
Was a warrant actually issued for Mr. Williams' arrest?
Yes.
Do you remember whatever happened to that case? Did it ever go to court?
No.
Why did it not go to court?
I don't know.
May I approach, Your Honor?
You may.
Denise, I'm handing you two documents that is Exhibit 24. These are some court documents. Do you recognize what these are regarding?
And this is when I filed for divorce.
Okay, when did you, the first time, when did you file for divorce the first time?
That was in 1980.
Are you pregnant with Olisa yet? Okay, so you tried to divorce Mr. Williams before you were pregnant with Olisa, correct? What happened to that divorce?
It was dismissed.
Do you remember why it was dismissed?
He never responded.
It wasn't served or didn't respond? Right. So the court dismissed it? Your Honor, I'd ask that People's 24, a 2-page document. It's a docket from the court as long in a court order dismissing the divorce pending.
For exam purposes only, Your Honor, no objection.
Exhibit 24 is admitted.
Why were you trying to divorce Mr. Williams at that time?
I didn't want to be here anymore.
Was the abuse continuing? Approximately, if you bring it back to May of 1980, did you said the divorce was dismissed, but were you separating yourself from Mr. Williams physically at that time, staying away from him? At that time, when you talked just a few moments ago about him being incarcerated, did you have a relationship with somebody else?
Yeah, I don't understand.
Okay. And did you become pregnant with Olisa?
Yeah.
At that time, were you working?
Yeah.
Where were you working? Okay. How long did you work at the University of Michigan?
I worked there from 80 to 81.
Were you still working there January 27th of 1981?
Yeah.
Okay. I'm going to bring you back to that date. Do you recall an incident where you were working that day when Mr. Williams contacted you?
Yeah.
Okay, tell us about what happened that day.
He had contacted me, saying that he wanted to talk to me. And I had, it was on a payday. It was on a Friday. And I had already cashed my check and I had put it in my desk. I worked, on campus, so I was working in the office, and I put it in my, locked it in my desk. And he, because I know how he is.
Okay,
So,
explain a little more. Why were you locking your money up?
because then he would ask for it.
Okay, was that common?
Yes.
Okay, go ahead.
So I, so when he puts me out in the car was all tagged and stuff. And I asked him where was he going, and he said that he had to get away. And that's when we ended up in the day.
Denise, let me ask you, was it your intent to move with Isiah Williams to the city of Cincinnati in January of 1981? No. Okay. Tell me what happened in that car to you on that day.
Well, he had picked up a hitchhiker and he told me not to say anything. And I had said something, I don't remember what it was, and he called off and slapped me. And so then he had me get down on the floor of the car.
The floorboard of the car?
Yeah.
Okay. Did he tell you where you were going?
No.
When you ended up in Cincinnati, Ohio, did you just end up there? You didn't know where you were going? Did you have any of your belongings?
No.
And I think you testified already you had this job at U of M, correct?
Right.
Did you notify them you were moving to Ohio?
No.
Tell us what happens when you get there to Cincinnati, Ohio.
We ended up in ended up renting a place together, and he had and then he noticed that I was getting bigger, and then we went and had a physical done, and that I was pregnant. But
The day you got in his car in Ann Arbor in January of 1981, did you yourself know you were pregnant at that time?
No.
Okay. When you got to Cincinnati, Ohio, did you know anyone there? No friends or family? Did Mr. Williams allow you to call back to your family here in Michigan?
Not right now.
Okay. Tell us about that. How is he stopping you from doing that?
I did have access to a phone and together.
Did he control what you could do?
Yes.
Did he ever threaten you?
Yes.
What would he say?
Would say that but I called my parents that he would take me.
And he had beaten you before, correct? Is that something you were afraid of?
Yes.
Did you lose your job back here in Michigan ultimately because of this?
Yes, when I finally called them, of course I had lost my job. It was like 2 weeks later, no show. And I had so I told my supervisor to unlock my drawer and get my cash. And send it to me.
When you get back to Cincinnati, and I know you were, I'm gonna jump back a little bit, you were talking about how you discovered you were pregnant with Olisa. Before you discovered that, did Mr. Williams continue to physically abuse you? What would he do when you moved to Ohio?
He would just, punch me and choke me.
Did you ever seek out any services there in Cincinnati, Ohio to help you from any agencies?
And I went to the women's shelter.
When you went to the women's shelter there, would Isiah ever show up? Find you?
Eventually, yes.
Did you go back with him?
Yes.
Tell the court, kind of take us through why you're going back with him. Did you feel like you had a choice?
Well, we was always saying that it would be better and, it's always on the pretense of, that, it would be good and then that, he wouldn't be beginning anymore.
In that moment, would you believe him?
Yeah.
He could convince you?
Yeah, he convinced me that he loves me and.
You said that you started getting bigger, so you went to a clinic?
Yes.
Tell us about that. Tell us how that happened.
Well, he was with me at the doctor's office and when I realized that he probably wasn't father, I got beaten and poked with a stick. Like with a broomstick and I felt that he was trying to make me a fool.
Where was he specifically assaulting you on your body when he found out you were pregnant?
Kicking me in the stomach area. I ended up with a fractured rib.
In the following months to him finding out, one, you're pregnant, and two, him discovering he can't be the father, did he ever talk to you about having an abortion? Do you remember? At that time, when you moved to Cincinnati, Ohio with him, did you have a job? Were you able to make any money for you?
I worked at a temporary service.
Did Mr. Williams ever demand or order you to go make some money for him in other ways?
Yes, he did once.
What did he say?
Well, that was back in 79, Valentine's Day.
What did he say?
He told me to go and make money. This was during a blizzard. And at that time, I didn't realize that this was after the fact that my arm was broken. And he wouldn't take me to the doctor. So when I left, I wrapped up and started walking.
Denise, a few weeks before Olisa's born. So Olisa's born August 10th, correct? Is that 1981? Okay. So I think, do you recall telling the police you went back to Michigan around July 24th, maybe a few weeks before Olisa was born?
Yeah.
What was your purpose in going back to the state of Michigan?
Going back to Michigan?
Yes.
Family.
At that point in Ohio, is Mr. Williams still abusing?
Yes.
And you're pregnant with Olisa, correct? Is that a yes?
Yeah.
Okay, I'm just gonna remind you to use words so that the record's clear, okay, Denise? When you went back to Michigan, were you intending on leaving Isiah at that time?
Yes.
How did you get back to Michigan?
I took the Greyhound.
Did you go stay with your parents?
Yeah.
Where were your parents living at the time?
Yeah. In Ann Arbor.
Where did you deliver Olisa on August 10th?
At St. Joe Hospital.
Did you see Isiah Williams at that hospital?
No, not until later.
When did you see Isiah Williams after giving birth to your daughter?
He had came to my room. Again, he had a wedding ring. I had, I don't remember how to the first one, but he had a wedding ring saying that, you know, things would be good and that he would raise as, you know, his child.
But at that time, Mr. Williams, did he acknowledge he knew he wasn't the biological father, correct? Told you he would raise Olisa as his own, correct?
Right.
At that time, are you still legally married from him, or married to him rather?
Yeah.
But he showed up with a ring, correct? Is that a yes?
Yes, I'm sorry.
Oh, was he asking you to get back together with him?
Yeah.
What was your state of mind at that time?
I wasn't sure. I was staying with my parents again and, going back and forth, I guess, in my mind, but to go or not.
Were you conflicted? Did you eventually decide to take Olisa and go back with Mr. Williams and say married to him? Did you move back to Ohio?
Yes.
How old was Olisa when you took her and moved back to Ohio?
She was about around 6 months.
Now we're in, what, maybe late 1981, early 1982. Does that sound fair? Okay. When you get back to Ohio, is Mr. Williams living up to his promises? Is he being good to you?
For a minute, yeah.
Okay. So when that minute is over, what happens? Is it physical abuse that you've already described, the punching, hitting, choking? What would trigger the abuse on you?
Anything.
Anything?
I mean, when he was gone, I was fine, and then, I hear him coming in, I get, then he goes, because I never know what's going to trigger me.
Would you ever, during this time period, Olisa's about 6 months old, say is beating you, would you ever leave and go to shelters like you stated you had done before?
Yeah.
How many times do you think you did that when you lived in Ohio?
Probably about twice.
I think, Ms. Denise, you had told the police that at that time, you believed Isiah had other women in your home, correct?
Yes.
Did you ever confront him about that?
Yes.
What would he tell you?
It was that it wasn't true, but I knew it was.
Was it to your benefit to continue confronting him, or did you just leave it alone? Tell us why.
I didn't get another beat down.
Back when you're living on Ohio with Lisa and Isiah, are you the primary caregiver? So when you go back to Ohio, are you working still temp jobs?
I will work 10 jobs, yeah, right now. Yeah.
Would you ever leave Olisa with Isiah when you would go to work?
Yeah.
Okay. Tell me about his care of Olisa when you would leave her in his care.
Yeah, she would be 30. She have dirty diaper.
In your opinion, did he care for her properly? In December of 1981, do you recall Mr. Williams contacting your mom and telling her to take you back to Michigan?
Yeah.
Tell me about that.
Well, my parents had came to see about me, and when they left me, they said I should have went back with them.
What did you inquire what he meant by that? You should have gone back with them. What did that mean?
I don't know. I didn't want to get rid of them.
Did you at some point have to write a letter to your rental office, to your home, to take them off that property? Can you tell us what that was about and why that happened?
He said that we had to leave and that he wanted me to sign the affidavit saying that I was that I'm taking off the lease and that Olisa was dead.
Why did you
make me sign it and had it notarized?
Well, how can he tell me? How can he make you sign that? What did he do?
He was just, saying that I don't remember exactly.
Would he ever threaten you?
No.
And did you actually type out that letter to take you and Olisa off the property, take away any of your rights to that property?
Yeah.
Okay. Your Honor, may I approach?
Yes.
Denise, I'm handing you People's Proposed 23. Is this the letter that we're talking about?
Yes.
And is that the letter that you typed December 6, 1981? I see some signatures on that. Whose signatures are on?
You signed it and I signed it in the I had it written signed it.
Your Honor, I'd ask that People's 23 be admitted.
Objection or voir dire.
Objection for exam purposes only.
Exhibit 23 is admitted.
Denise, can you tell us what the purpose of this? What I don't want to say it. What Isiah Williams gained from this?
Objection as to speculation, unless she knows.
If you know, what was the purpose of signing this letter? Had he expressed to you that you should leave with
Objection,
Olisa?
she said probably.
Well, I'm trying to ask.
Yes.
To get it.
I'll sustain the objection, but I'll let you rephrase.
Had Mr. Williams actually said to you that he did not want you at that time in December of 81, you or Olisa living with him?
Yeah.
Did you and Olisa actually move out at that time? Okay, where did you go?
I went to a friend.
Did you ever go back to Michigan during that period of time to see your family? Or to see your other daughter? Okay. Do you remember how long you stayed in Michigan before you came back to Ohio? Did you think about staying in Michigan at that time and not coming back to Ohio? I thought about it. Tell us why you ultimately came back to Ohio.
About the promises. And that I wanted, I really wanted the marriage to work.
Back in Ohio around March of 1982, did you file for a separation at that time? Okay. Where were you living at that time?
And I believe I was with my friend.
Is that the friend that you mentioned earlier, Diane?
Diane, yeah.
Diane Taylor? Okay. How did you know Diane?
We met at work.
When you're staying with Diane, is that also in the city of Cincinnati? Are you staying and you have Olisa with you?
Yeah.
Are you still her primary caregiver?
Yeah.
At that time, when you're staying with Diane, is Isiah seeing Olisa and is he visiting? And at that time in March of 1982, if he's not visiting with her, it's fair to say he's not taking care of her on his own, correct? the end of March 1982, did you have contact with Mr. Williams in which he physically assaulted you again?
Yes.
Do you remember what happened that time?
And at that time, we were at Diane's mom's house, and we had knocked on the door, and he took me and took Olisa and drove off.
I'm not talking about April, I'm talking about March. Was there an incident maybe a month before that where you found your belongings in the hallway? Do you remember that incident?
Yeah.
About how much time before Olisa is taken did that happen? If you can remember. I know I'm talking about 41 years ago, but was it a long time, a short time?
It was a short time.
Okay. Tell me about that. Found your belongings in your hallway.
He had packed our stuff and put them in the hallway, and wouldn't let me back into the apartment.
In April of 92, you're still living with Diane? Okay. Are you still working at the temp jobs at that time? No, okay. You already talked about the dates of April 29th. So about 2 days before that, April 27th, 1982, did Mr. Williams contact you from jail?
Yes.
Okay, tell me about that.
He said that his brother was going to be wiring some money, and he wanted me to. I guess it's coming Western Union. He wanted me to bring it to him, and I used it to get him out.
So you got him some money to get to bond him out, bail him out of jail?
Right.
Okay. Was there an argument ultimately about that money?
Yeah, because he was going to use the whole money to pay his rent.
Did you use some of the money?
For transportation.
To get to the jail, correct? Okay. And was Mr. Williams upset about that?
Yes.
What happened?
Got into altercation.
Tell me about that altercation. At that point, during the physical abuse, where are you at when this is happening? Well, location-wise, I'm sorry. Are you at his apartment or at Diane's?
It was at his.
Were you able to get out, or did he lock you in there at some point?
He had locked me in.
Tell us about that. How did that happen?
He had said that I wasn't going to go anywhere, and he had locked me in a closet.
Who had Olisa at this time?
Diane.
About how much time had passed before you were still locked in Mr. Williams' apartment? Had a lot of time passed?
Yes.
Okay, so what happened ultimately?
They ended up calling child protective services.
Is that because ultimately you didn't show back up at Diane's?
Right.
Where were you when you didn't show up at Diane's? Okay. Was that voluntarily at his place? Were you able to get Olisa back on April 29th, 1982?
Yes.
That was from CPS?
Yes.
Denise, let's talk about the date of April 29th, 1982. Were you again at Diane Taylor's apartment?
Yeah.
Was it an apartment or a house, I should ask?
It was like a townhome.
Townhome? Was Diane home at the time, or was it just you and Olisa?
Just me, Olisa, Diane.
If I'm doing the math correct, I think Olisa would have been about 8, almost 9 months old at that time. Does that sound about right to you?
Yeah.
Did Isiah show up?
Yeah.
Tell us what happened.
That's when he showed up, and yeah, when I opened the door, I had Olisa in my arm, and he really didn't say anything. He just said that he was here. I told him that he couldn't see her, and he knocked me down. And he took my daughter.
Do you need a break? Are you sure?
Ma'am, if you want to take a break, you may. If you- Pardon?
Denise, do you remember if Isaiah said anything to you when he knocked down your daughter? There's some water for you there, Denise. When he knocked you down, did you have Olisa in your arms?
Yeah. He had taken her then when I fell. And he ran up and got in the car and went off, and I called the police. And they said they couldn't do anything because they found her certificate.
He was her legal father, correct?
Right.
This is 1982, correct? Yeah. Denise, have you seen your daughter Olisa since that date, April 29th of 1982?
No.
That would be 41 years this past Saturday, correct? Is that true? You got to answer out loud.
Yes.
When you called the police, what police department did you call?
Cincinnati.
Was Mr. Williams eventually arrested either that night or the next date?
Yeah.
Okay. Do you know if he had Olisa with him at that time? Okay. Did you see Olisa at that time?
No.
Did you go to court to see the defendant when he got arrested?
Yeah.
Was he asked about where Olisa was at that time?
No.
When he got out of jail, would he tell you where Olisa was? Did you ask?
Yeah.
Did you actually speak to him the day that he was let out of jail, April 30th, 1982?
I have to rewrite that report. And they didn't want there.
In the state of Ohio, at that time, did you go to court and get sole temporary custody of Olisa?
I did.
Did you also get a personal protection order against Mr. Williams at that time? Application. Your Honor, may I approach?
You may.
Denise, I'm going to show you 7 pages that's been marked as People's Proposed Exhibit 25. Do you recognize those documents as it relates to what we're talking about with the PPO, the personal protection order? Okay. What is that?
This is the
You can go through all the pages. For the record, Your Honor, there are 7 pages to this document.
All right, thank you.
or temporary custody.
When were you ordered? Does the document reflect when you were ordered temporary custody?
May 19th. Final judgment.
That's the judgment indicating that you, at that time, the court in Ohio was giving you sole custody of Olisa.
Right.
Was Olisa in your custody or did you have her at that time?
No.
Your Honor, I'd ask that People's 25 be admitted.
Objection or voir dire.
No objection for exam purposes only.
Exhibit 25 is admitted.
Did you know at that time in May, at the time you were granted sole custody of Olisa, whether or not Isiah was in the state of Ohio or somewhere else? Were you trying to contact him?
Yeah.
Okay. Were you having any luck connecting with him or having any conversations with him at that time?
No.
Before we go over the next few weeks and months of time, tell me about Olisa as a baby. Was she physically healthy? Did she have any underlying health conditions that you knew about at that time? Any underlying medical conditions that would make her ill or anything like that that you knew about?
No.
Was she up to date on her immunizations, her shots that she should have had at that age?
Well, so that time.
Was she being breastfed at that time still? But you were the sole primary caregiver, I think you testified, correct? So you were the one to care for her and feed her, correct? Your Honor, may I approach?
Yes, you may.
Denise, People's Proposed 8, do you recognize what that is? What is that? And that's from the clinic is that in Ohio? Okay, and does that reflect her immunization card that you recall as far as what she was up to date to? When you last saw her? Your Honor, I would ask that People's 8 be admitted.
No objection for exam purposes only.
Exhibit 8 is admitted.
The next few weeks that go by between April 29th, I should say June of 1982, are you still in the state of Ohio at this time?
I had came,
Did you come back to Michigan in June?
I think it was around June.
Okay. At that time, did you know where Olisa was?
I assume that she was with him in Michigan.
You had, at that time, had you seen her?
No, I haven't.
When you were still in Ohio before you came back to Michigan, did you make any efforts to try to put out the information to the public to try to find her?
Yeah, but ad in the newspaper.
Did you also put a missing poster together?
Yeah.
Did you do that in Michigan or did you do that in Ohio? Okay. Your Honor, may I approach?
You may.
Denise, do you recognize what proposed exhibit 4 is a copy of?
Yeah.
What is that?
And I put the paper, anyone knows more about Isiah.
Okay, was that the Cincinnati Enquirer at the time, or was it a different local paper?
The vote.
Okay. What was your purpose in putting out this information?
If anyone that may know him or know of her.
Your Honor, I'd ask that People's 4 be admitted.
Objection of voir dire.
No objection for exam purposes only.
Exhibit 4 is admitted.
People's, I should say, it should be 6 and 7. They're the same things, they're just different organizations. Denise, People's Proposed Exhibit 5, is this the missing poster of Olisa that you put together yourself?
Yes.
Okay, and you put that together in the state of Michigan?
Yes.
Okay, what was the purpose behind doing that?
I had joined up with the the National Center for Missing and Exploited Children. And that was one thing that had me do a post rubber. And I had to visit Sergeant Canada, who was the person over the case at that time.
Sergeant Canada was the officer in charge of the case back in 1982 from the Ann Arbor Police Department, correct? Okay, so the missing poster indicated information on who should be contacted if someone saw Olisa, correct?
Correct.
People 6 and 7, were these also missing posters that were done by other organizations?
Correct.
Did you provide that picture of Olisa to these organizations? Your Honor, I'd ask that 5, 6, and 7 all be admitted.
Objection of voir dire.
No objection for exam purposes.
5, 6, and 7 are admitted.
Did you also, Denise, contact multiple? I know you already said that you were involved with the National Center for Missing and Exploited Children. How were you involved? What did you actually do to get Olisa's information out there to try to find her?
I had contacted them and also other agencies as well. Child Find Incorporated.
Child Find, you said Incorporated?
Yeah.
Did you write letters to news organizations?
I wrote letters to news organizations and to Carmen Harlan, who was doing missing children of Michigan, and she was connected with Child Find.
Did you write letters also to Domino Pizza?
I did.
Tell me what the purpose behind that was.
I believe at that time they were putting photos of missing children on the cart.
In terms of your communications with the National Center for Missing and Exploited Children, did you provide Olisa's picture and information to them so they could distribute it to corporations and news organizations all over the country?
Right.
Okay. Did you have a stack of letters from them to and from them that you provided to Detective Dan Iverson?
Right. They sent me a letter.
Do you have correspondence from them that dates from about 1985 through 2014? Again, these were all efforts to getting Olisa's information out there to find her one way or another?
Right.
You also provided your DNA to the National Center for Missing and Exploited Children, correct?
Yes.
What was the point of that? Do you remember?
That was through, I think it was Venus. I think it's called. They, whenever they have a a child is blind or deceased or alive, they can find out who they are through DNA.
Did you also contact the Adam Walsh Resource Center at that time?
Yes.
Again, this is another organization you provided Olisa's picture and personal information to.
I contacted several agents.
At that time, did you have any idea where she was?
No.
Your Honor, I have a stack of exhibits at this time. I don't know if I can just have counsel go through them and then we could see if there's a stipulation to them for exam purposes. This is just her impression photo. This is her letters to the news organization to get Olisa's information out there. This is her letter to the YWCA. That's one page there. Your Honor, I think there is a stipulation for exam purposes only, and I'll read through what these exhibits are. Exhibit 15 is, Exhibit 14 is a letter registering Denise with Child Find Incorporated. People's Exhibit, and that's a 2-page document. People's Exhibit 15 is a letter from Denise to Child Find of America Incorporated. People's Exhibit 13 is a letter from the YWCA regarding Miss Williams at that time, Fraser Daniel now, and her daughter Olisa being residents of the shelter at that time in Ohio. People's Exhibit 12, which is 16 pages, is what Miss Fraser Daniel testified to, her multiple letters to news organizations at that time. People's Exhibit 11 is a 2-page document. They are age progression photos of Olisa Williams from the National Center for Missing and Exploited Children. There's 2 different ones. People's Exhibit 17 is a 68-page document. Your Honor, those are the letters from the National Center for Missing and Exploited Children from 1985 to 2014. People's Exhibit 16 is a 6-page document. The letters to and from Domino Pizza, Mr. Tom Monahan. Again, Ms. Fraser Daniel testified to that as well. People's Exhibit 18 is a 5-page document notifying that Ms. Fraser Daniel has provided her DNA to be tested against a database for missing children from the National Center for Missing and Exploited Children.
Excuse me, counsel, I just want to make sure the 68-page document is Exhibit
That is Exhibit 17, Judge. Sorry, I'm a little
17.
order.
It's okay. And then the 6-page document that followed that was exhibit.
The 6-page document to Domino Pizza
Yes.
is 16. That's 16.
Gotcha.
And then the National Center, the 68-page document is 17.
Thank you.
The DNA document is 18. That's 5 pages. People's Exhibit 19 is, again, a letter to a news organization on a Western Union mailgram. And then People's 20 is the letter to Ms. Williams from the Adam Walsh Resource Center. I'd ask at this time all those be admitted with the stipulation only for exam purposes.
That's correct stipulation, Your Honor.
All right, exhibits, looks like it's 11 through 20
Yes,
will be admitted.
thank you, Judge. Denise, at some point, Dr. Thomas would have said you come back to Michigan to find Olisa. Yeah, I think you already testified, you believe that was around June of 1982, correct? Did you retain an attorney at that time? Yeah. Who was your attorney at that time? What was your point in giving yourself an attorney then?
For divorce and to get custody.
And did you do that through your attorney, file all those documents in the Washtenaw County Family Court?
Yes.
And were those documents, did those begin to be filed in June and July of 1982, if you remember?
Yes.
Did you also get a restraining order?
Yes.
One of the other things, Ms. Frazier, I know we talked about, did you write a letter to the U.S. Department of State?
Yes.
What was the purpose behind contacting the U.S. Department of State?
So, it wouldn't take police out of the country.
So you tried to stop Olisa's social security number from being used to get a passport, correct? Were you successful in doing that and contacting the U.S. Department of State? Okay. You provided them some information and they were able to at least take that information to stop her from getting a passport. And did you also sign a waiver of attorney-client from Ms. Reno so that she could speak to both the news and to speak to Detective Dan Iverson?
Yes.
Okay. That's two waivers in there. Oh, two different waivers, and this is just to the U.S. Department of State. Your Honor, I believe there's a stipulation for admission just for exam purposes only.
That's correct, Your Honor.
Those exhibit numbers are again?
That is 21 and 22. 21, Your Honor, is a 4-page document
Yes.
from the U.S. Department of State regarding Olisa and not having a passport. 22 is a 2-page document. Those are 2 waivers of attorney-client privilege.
Gotcha. 21 and 22 are admitted.
When you came back to Michigan, you talked to Isiah Williams by phone. Did you ever talk to him in person, outside of court, or did you always talk to him by phone?
By phone.
Did you ask him, where is Olisa?
Yeah.
What did he tell you?
He always gave me different stories each time. He was saying if I had 5,000, I could get her. And he said that she was across the water.
What does that mean, she's across the water?
Yeah.
You said he told you if you had $5,000, you could get her back?
Yeah.
Did he also tell you that she had died?
He said that died from a high fever or something like that.
Did you subsequently call any of the local
I
hospitals?
called hospitals, even Barrow and Lansing. I was just calling all over.
Were you ever able to confirm that Olisa had died of some medical condition? Did Isiah ever tell you in any of these phone calls or any of your conversations with him when you came back to Michigan that he killed her? How many times did he tell you that? Did he tell you how he killed her? But he told you that more than once. Back when he told you that, at that time, Did you believe that? Tell us why.
No, I just thought that she was still here. Just to look at her.
Since then, since Mr. Williams has been charged in 2021, have you gone forth with proceedings to obtain a death certificate for Olisa?
Yeah.
And tell us about that.
Hard to do.
Tell us why. Tell us why you, I don't want to say waited, but why you waited to do that for 40 years.
That's when I heard that she was no longer here. This was wonder about it.
Is it difficult to do that, to move forward with proceedings like that, like taking that certificate?
Yeah.
To now we're in a timeline of September 1982. The document is about you haven't seen Olisa. Talk to Isiah. Correct? He's told you these multiple different stories, correct? About September 2nd, 1982. Did you go to a funeral?
Yeah.
Whose funeral? Whose mother's? Tell us about it.
I said, okay, that I see Olisa.
Did you see Olisa there? Did you see Isiah there?
Yeah.
Did you notify the police at that time that Isiah would be there? And that they should go there? Okay. You know of anybody?
No.
A couple weeks after that, did Isiah contact you about Olisa?
Yeah.
Okay. What happened? Tell us about it.
He said that he was going to let me here. Then,
Do you remember what date that was? If I was to show you a police report, would that help refresh your recollection of the date?
Yeah.
I'm not gonna admit it.
Yes, you may.
Anticipate. Please, I'm showing you a copy of the City of Inkster Police Department incident report. Does that look familiar to you?
Yeah.
Okay. Is there a date reflected on that report?
September 28th.
Does that refresh your memory as to this incident we're talking about now? The incident with Inkster Police Department, did you go meet Isiah in the City of Inkster regarding Olisa?
Yeah.
Why did you go to Inkster? What did he tell you?
He said, if I met with him, that I would be able to see Olisa.
And did you meet him at a motel, a Mona Lisa motel? Okay, tell us what happened when you got there.
Oh, well, it never.
Olisa was not there?
No.
Was Isiah there though?
There.
Just tell us what happened after that.
He was stipulating that I was having an affair with his brother, which was totally untrue. And he started meeting me. This time it was really worse. It was bad.
Why was it really worse? Why was it bad?
My face was all bruised up and my eye was all bloody. And he told me to go into the bathroom and clean up. And I went in the bathroom and closed the door and I jumped out the window.
What floor were you on?
The
Did you contact the police?
manager did.
And was Isiah Williams ultimately arrested? Was he arrested?
I don't think he was at the time. He was gone.
He was gone from the hotel when the police got there? Say yes?
Yeah.
Eventually, was he arrested though? Okay. Did you go to court for that?
Yeah.
At that time, are you able to talk to Isiah and ask him any further information about Olisa or where she's at? Does he tell you any additional information? Let's talk about the Washtenaw County Family Court proceedings. You've already testified that Molly Reno, your attorney, filed the documents on your behalf in June and July, correct? Did she file for divorce for you? What about child custody, for you to have custody of Olisa too? In about February of 1983, February 1st, 1983, do you remember court proceedings where Isiah testified?
Yeah.
Was he ordered at that time by the court to bring Olisa forward, to produce her, to bring her to court, to bring her forward? Do you remember that? Okay. But in the hearing in February of 1983, did Isiah talk about in court about ultimately where Olisa was?
He saying that he was at Island Park, passed out in his car or whatever, and when he came to, she was gone.
Is Island Park in the city of Ann Arbor?
Yeah.
And that's in Washtenaw County, correct? Do you know if there's a body of water that goes through Island Park?
Yeah.
So Mr. Williams in court claimed that he was passed out in his vehicle. Am I hearing that? And that when he awoke, Olisa was gone, correct?
Right.
What about Olisa's belongings? Did he ever indicate her belongings were still in the car?
He did.
Did Mr. Williams say whether he reported this mysterious disappearance of Olisa to the police?
No.
And I should have asked that better. That was a terrible question. When you say no, does that mean he did not report it or he didn't say it?
He didn't report him.
Was Mr. Williams ultimately arrested in court and held in contempt of court?
Yeah.
Did you go to see him during that period of time in jail to try to ask where Olisa was?
Yeah.
And what did he tell you, if anything? Nothing? Would he even answer you at that time?
He wouldn't talk about it.
Divorce was finalized June 2nd, 1983. Sound correct to you? Who had custody of Olisa at that time? Who was granted custody of her? By that point, we're talking June of 1983. You had not seen her for a year, correct? When Mr. Williams was released from jail for those contempt proceedings, would he call you?
Call him, after me.
What does that mean?
And either he will call and say that, I asked him about Elise, and he will always say different stories.
And again, are any of these same stories he told you before that you testified to? Any of them ever different? Any different versions of the events that he ever told you in those calls?
No.
When he was released from jail, did he ever tell you again that he killed her? Did he tell you that before he went to jail? Denise, do you know of any close family members of Isiah that live in Alabama? You have no knowledge of any of these people?
No.
If they exist, correct?
No.
Let me ask this. When you contacted the police here in Michigan, you went to the Ann Arbor Police Department, correct? Yeah. What made you go to Ann Arbor?
Yeah, I've been there.
Okay, all right. Had Isiah also, at that time, told you about Island Park?
Yeah.
Okay, and did you know at that time Island Park was a park that was in the city limits of Ann Arbor? Yeah. Okay. Did that also play into your decision to go to Ann Arbor Police Department? Or had you gone to them already?
I think
Okay. Is that where your parents lived at the time, Ann Arbor? Do you know if Mr. Williams was also, when he came back to Michigan, residing in different locations within Washington County? Okay. I don't have any further questions. Thank you.
Cross-examination.
Thank you.
Did you need a break, ma'am? Ma'am, are you good? Okay.
Good afternoon. You stated that over the years, when you would talk to Mr. Williams about Olisa, he gave you multiple answers, correct? And you didn't believe any of them, correct? You thought he was hiding her from you? Okay. And you stated that you also submitted your DNA to one of the missing and exploited children database in case a DNA hit happened when they recovered a missing child or a deceased child or something like that, correct? You never got any DNA hits, correct? And you're not aware of exactly who his relatives are in Alabama?
I never heard of it anyway.
Okay, so you don't know if he has relatives there or not, you just aren't sure? Okay, you've never investigated that, correct? Okay, no further questions.
All right, any reader?
Just briefly.
Yeah.
When you said you didn't believe any of his stories, is it because he told you so many different stories?
Yeah.
At that time, we're talking about 1982 and 1983 when he's making these statements. Is that fair?
Yes.
And so we're talking about 6 months to a year after Olisa disappeared, correct?
Yeah.
It's now been 41 years since you've seen her, correct? What do you believe happened to your daughter?
She's gone.
She's deceased. In terms of giving your DNA, back earlier in the investigation, you have to search some remains of a baby in New York. Do you remember that?
Yeah.
Was that Olisa? In terms of your DNA that you've been given to other people who have come forward saying they might be Olisa, has any of that ever produced Olisa? I have no further questions.
You good?
Is it fair to say that Mr. Williams terrorized you for the time of period that you've known him, correct? You never witnessed him terrorizing Olisa though, correct?
Not probably, no.
Okay, no further questions.
Ma'am, ma'am, you may step down. Thank you. Maybe I know what I needed to do, but
You need to take a break, Judge?
well, I do, and I don't know if the folks in the courtroom are hungry or want to take lunch.
I excused most of them and had them come back at 1 anyway, so most of my witnesses have taken a break.
Oh, okay, fantastic. But I don't need you guys falling out either. So why don't we do this? Why don't we take about 45 minutes for lunch? I can take care of my business and then do that. So we'll. Court does call the case of the People's State of Michigan versus Isiah Williams. Counsel, state your appearances, please.
Daniel Russo Bennett on behalf of-
Good afternoon, Your Honor. Daniel Woodson on behalf of Mr. Williams, who is seated at the fence table to my right.
All right, very good. Before we call the next witness, during what I'll call Mr. Williams' episode with the paper bag, Exhibit 9, there was no response. I think I heard the prosecutor ask to have it admitted, did not hear a response from you because of what was going on.
For purposes only, Your Honor, no objection.
So for the record, Exhibit 9 is admitted.
That was the first.
Yes. All right, you may call your next witness.
People call Mary Leslie Bryant.
All right.
Take your seat, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Go ahead and have a seat. State your first and last name and spell it for the record.
Mary Leslie Bryant, MARYLESLIE, BRYANT.
All right, you may be seated, ma'am. Thank you. Before you inquire, Ms. Bryant, are you from Ann Arbor? Are you from Ann Arbor? Okay, all right, then it's not who I'm thinking it is. Go ahead.
Thank you, Judge. Ma'am, may I call you Mary?
Yes.
Okay. Mary, do you know someone by the name of Isiah Williams? How do you know Isiah Williams? Okay. He was someone you dated, your boyfriend?
Yes, someone dated.
Okay. Do you see Mr. Williams in the courtroom?
The mask on.
Your Honor, let the record reflect that Miss Leslie Bryant has identified the defendant, Isiah Williams.
Without objection, record shall so reflect.
Mary, Miss Leslie Bryant, have you been interviewed about this case a couple different times by the Ann Arbor Police Department?
Yes.
Okay. Does 2011 and 2017 sound about right to you as to when you were interviewed? Okay. I'm going to bring you back to the fall of 1994. Tell us how you met the defendant, Isiah Williams.
In a temporary place that a lot of people go and get work. I've been down there.
And were you coworkers at that time?
We didn't become co-workers, because whoever gets there first gets the job.
Okay.
But then after that, I'll go to the same thing, little job site. So we all, a group of us to stay together.
At some point, do you begin dating Mr. Williams? Okay. Tell me about how the relationship starts off. Is it good?
It was good. He told me that he was a paralegal, told me that he was looking for a full-time job. And after that, we went out a couple of times. And it was all right.
At some point, did it change?
It changed after I went to my daughter Danielle's house because she had a barbecue. And he accused me of my oldest son, but he didn't believe that was my son. He got very angry, upset, and said, "Let's go." He took me by the arm and said, "That's it." So we went.
And did it escalate from there in the relationship? Did things get worse?
Beat the hell out of me, get worse, yeah, I got worse.
I think I would, Miss Leslie Bryant. Okay, so can you tell me about what beating the hell out of you looked like? Can you tell us what that means?
One time he took and pulled my hair out my head. I took my clothes and dragged me down the steps and left me in a hallway. And then he just came down the steps, took me by the arm and dragged me right back up there and just started hitting me again.
How many times do you think this happened?
4 or 5 times.
Did he ever give you any pills or anything like that?
He gave me drinks, and it made me feel like I couldn't move, and I couldn't say anything, but he did what he wanted to me.
What does that mean?
Laid me on the bed, stripped me, put his hands and stuff inside me. He just did his thing.
Could you, after taking this drink that he gave you, could you stop him? So you already said you couldn't move, correct? Is that yes?
Yeah.
Okay. During one particular physical assault, do you recall him strangling you?
Yeah.
Do you recall him telling you some statements that bring you here to court?
Yeah.
Tell us about what you remember Isiah Williams telling you while he was strangling you.
He got mad about something, and he started choking me. And it was like I was going in and out. And he said, you know I killed a woman. Don't you know I killed a baby? I'll kill you. I couldn't breathe. I couldn't breathe. He just kept on choking me. And when I woke up, he was just sitting in his chair over there. And he acted like nothing happened.
These statements that he made to you about, I killed a woman, I killed a baby, did he make that to you one time during an assault, or did he ever say that to you again during an assault? Okay. Did he specifically say he killed a baby? Did he say what he did with the baby's body?
He used, I'll beat you up. I'll kill you as a way of keeping me from getting out of there. I did not want him to hurt my grandkids. I did not want him to hurt my children. So I stayed away.
You said he threatened to kill you after he made these statements, correct? Based on those threats, did you initially tell anybody about these statements he made? When the police came to you, did you tell them?
No.
Okay. And eventually, did you tell them?
Yeah.
Okay.
They found out where I lived at.
They came to talk to you? Were you worried about talking to the police?
No, because I thought after all this time, he had gone about his business just like he didn't do anything. The police didn't go to and here to get him. They wouldn't come to Cincinnati to get him. It was like they were just letting him do what he wanted to do. And it went on for so long, I just said, well, forget it. They're not going to do anything. Let it go.
At the time he made these statements to you about I killed a baby, did you know he had a baby that disappeared?
I didn't even know that he had children to almost end our relationship.
Okay.
Because it was Easter time and I got baskets for all my grandkids. And he was upset because I got them something. And I didn't get his grandkids nothing. And I got something for grandkids.
So at the time he made these statements about this baby, did it even register that he had a baby for you to be even really concerned about?
No.
Okay.
I didn't believe him. I thought it was just another way to make sure that I stayed crazy in my mind. That's how I felt about it.
That you were feeling crazy about the situation. Okay. You mentioned Easter time. The statements that he made while he was assaulting you, did it happen around Easter time? Okay. About how much time passed before he was assaulting you again and making these statements about the baby?
But
How long did you and Mr. Williams date?
until the final time he took it he was beating me. And because I wouldn't cry, he had this remote control and he was beating me on my right foot. And I just said, let him go on and do it. And then he started, it started really hurting. So then he tried to pull me and I got the bottom of the bed, try to get him off of me. But then he just drug me across through the bedroom and right there. Then he just got up and went in there and sat there looking at me. And when I got ready to get up, this scar right here was on my head. Had some scars on my face. And that was it.
Was that the final straw? You said that was it. Was that the last assault that you recall?
Yeah.
Mary, was that approximately September? Excuse me. I'm going to show you some pictures. Was that approximately May of 1997, if you remember?
Approximately.
Did you go to the hospital for your injuries?
Yes.
Okay. Did you actually file a police report?
Yes.
Did you have to go to court for this?
Yes.
Did you also get a personal protection order against Mr. Williams at that time? Okay. Your Honor, may I approach?
You may.
Mary, I'm going to first show you people's exhibit 60 through 67. Can you tell me if you recognize those pictures? Who's that in exhibit 60? Okay, is that a picture of, do you have any injuries in that picture?
All right there. I know.
Scar in the middle of your forehead and in your nose?
On my arm.
People's exhibit 61, is that a bruise on your arm? People's exhibit 62, what's that?
Why stitches?
Is that from the assault that you've been talking about with Isiah?
Yeah.
And from the hospital visit that we've been talking about? People 64, what is that? Is that from the same assault we're talking about? Here it looks like in people 64, 65, 66. Looks like the back of these Polaroid photos of your injuries. Is that the hospital information? Okay, is that where these pictures were taken of you, of these injuries that we're talking about today?
I was supposed to make an appointment to go here. And I said I wasn't going. I said, because they couldn't make him, they couldn't find him. They couldn't get away from him. So I just stayed home. I went to the clinic and talked to these people up there. So then,
So you said because you were afraid to go out and see him, you actually missed a follow-up appointment. Did this happen during this final assault that we're talking about?
you because I was waiting.
Okay. People 69 are these Franciscan Health System of Cincinnati. Do you know where that was at?
Western Hills Hospital.
Okay, is that the hospital you went to for your medical treatment that we've been talking about for these injuries?
Yeah.
Okay, and they've got your name and your information in them? Mary, you indicated that you got a personal protection order after this assault against Mr. Williams. Giving you what's been marked people 68, 5 pages. Do these documents look familiar to you? Did you have to fill these out?
Yes.
Is that the paperwork you had to fill out to get your personal protection order? Was that granted, Mary? Did you actually get the order from the court? Okay. Eventually, you did get a personal protection order against him, correct?
Yeah.
Was that in the city of Cincinnati in Ohio?
Yeah, it was the last time I was supposed to go to court. And we got sitting here and they caught everybody that came. And I was still sitting here. And the lady came and said he didn't about to come to court. So that's when they told me, go back to the shelter and stay in there And they'll let me know when they catch him. And if they catch him.
They never caught him. You had a personal protection order on you for about 20 years, is that right? Okay. Your Honor, I'm going to ask that people 60 through 69 be admitted.
Any objection or voir dire?
No objection for exam purposes only, Your Honor.
Exhibit 60 through 69 are admitted.
Mary, you said that when the police came to you first, I think you told them Isiah made a statement to you about killing a woman, but you didn't mention the baby part. Do you remember that? Was there some concern with why you didn't mention it was a baby until the second time they came and saw you? Do you remember why you felt more comfortable the second time?
He wants about your grandbabies, your grandbaby. And I don't care. I was not gonna let him hurt my grandkids. Okay, make your credit, do what you wanna do, but you're not gonna hurt my grandbaby. And that was all it was.
Tell me about that. You said he made these statements, your grandbabies, your grandbabies. What would he tell you he was going to do to your grandbabies?
Sometimes he be choking me. It's like going to another little world and all of his own. He accused me of working for the FBI one time. And I kept telling him I did, and he said, you want me to hurt your grandbaby, don't you? And he just kept talking to me. I said, no, I don't work for the FBI. I never worked for the FBI. And it didn't matter. So I just waited until he got through with his little stuff. And I like, hey, you do what you want to do. There wasn't any time. There wasn't anybody to help me. So I just had to bide my time and help myself. That's what I did.
These statements that you say that Isiah made about killing a baby and killing a woman, other than the police, did you tell anybody else about these statements that Isiah had made to you?
No, because you know how you would know. When somebody tells you over and over again that this is what happened and this is what happened, but then you remember he's telling you, so maybe he's just saying to scare you worse. You don't believe it. I didn't believe it until they came and showed me a picture of a little baby.
And at the time these statements were made, you didn't know there was a baby named Olisa Williams that had been missing, correct? Okay. When was the last time you saw Isiah Williams before you're seeing him here in court today? How long's it been?
He showed up in court and they told him that he had to go to jail. Gave me my next court appointed time to come to court. And he didn't come.
That was in 1997, correct?
Yeah.
And has it been that long since you've had to see him, since 1997?
Yeah.
Okay. Did Isiah Williams ever tell you that he had a closed head injury that caused him to have amnesia or have lack of memory in the years that you knew him?
He said, and he had been in a car wreck. And I looked at him and went to work with everything normal. So I said, just don't say nothing, man. Just don't. Because if you tell him the truth, you tell him the truth. If he's not, there's not going to be another point for him to whip my ass. Excuse me.
No, it's okay, man. You got a right to say what you want.
So there was no reason, and you can correct me if I'm wrong, no reason for you to confront him and risk getting hurt. Okay. Did he ever say that after this car wreck, he didn't know who he was or didn't have any memory of anyone in his life? Did he ever tell you anything like that?
No.
Okay. One moment, Your Honor.
Yes.
No further questions. Thank you, Mary.
Okay, hold on just one moment. Cross-examination.
One moment.
You know what happened?
You might want to remember your microphone. Yeah, it goes green if you're not being picked up, but go ahead.
Good afternoon. You said that when Mr. Williams made threats about killing people, it was during the course of time that he was beating you, correct? And he didn't make those threats or those statements outside of that, right? And that's why you thought he was just saying them to scare you, correct? And outside of his interaction with you, did you see him be violent or abusive towards any children, like your grandchildren or anything like that?
I didn't see anything else that I mostly, for a while, I was in the apartment. I could not go nowhere. I was right there in the apartment.
Okay. So it's fair to say the only person you saw him be violent with was you, correct? And you said that he would repeatedly tell you that he had killed a woman and that he had also beaten another woman with a group of kids and left that woman for dead? Or was it preacher's daughter? I'm sorry.
Gang rape a girl, the preacher's daughter. That's what he said.
So you said that he okay. And he told you that he had killed another woman, correct? But he never killed you, correct? Okay, no further questions.
Very briefly.
Yes. Go ahead.
Mary, did you ever leave your grandchildren alone with this man? Did he ever watch them or babysit them or have them in his care and custody?
No, because I made sure. I went over there. Dion and the kids would be upstairs, and I would be outside the house. The only time I went over there, and he came over there, was when he pulled my hair out my head. And that naked me, that was the only time.
So he never was alone with those grandbabies, correct? Okay. And when you were asked about the statement that he made about gang raping a preacher's daughter, so you had no reason to doubt that particular story since he had treated you that way, correct? Okay. Thank you, Mary.
Anything else?
No, Your Honor, thank you.
Ms. Bryant, thank you very much. You, all right. Brian, you take your time.
Thank you.
You're welcome. Thank you, ma'am. Brian, you just take your time. I got all day. You take your time and get there, okay?
Thank you.
You're welcome. You call your next witness.
People call Elizabeth Reese to the stand. I think she's coming in.
All right. Very good. Hello, Miss Reese. Miss Reese, will it be easier for you either to be in the chair or you want to sit on your?
I'll sit down here.
You'll sit in. Okay. All right. Very good.
Where you sit down, you raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Then have a seat. State your first and last name and spell it for the record.
And then you got it. He's better than me, so
We're good. Okay. Okay.
E-L-I-C-A-D-H-R-E-E-S-E.
You ain't quiet.
Thank you, Judge. Ms. Reese, good afternoon. Good afternoon. Case that brings you here to court, is it fair to say you've been interviewed by Ann Arbor Police many times? Many times. If I tell you you were interviewed in 83, twice in 2011, once in 2014, and once in 2015, would you have any reason to dispute that? No. How do you know somebody by the name of Isiah Williams? Okay. How long were you married to him? About 11 years. Do you have any children with Mr. Williams? I have 3. Okay. What are their names? Verna Williams, Kimberly, and Scott. Does he go by Scotty? Scotty. Do you see Mr. Williams in the courtroom today? Yes. Okay. Can you point him out, describe what he's wearing or what identifies him? He's over here. He has a t-shirt and a mask. Your Honor, let the record reflect that Ms. Reese is identified the defendant.
That objection shall so reflect.
Ms. Reese, is it fair to say that back in 1983, your memory was probably the freshest and the best that it was back then? Yes. Were you honest and truthful with the police back in 1983? Yes. Since 1983, have you had any injuries that have caused you to have significant memory loss? Yes, I've had 2 strokes and being disarmed. Yes. Okay. Were you also physically assaulted in 1980? Yes. Who physically assaulted you? Isiah Williams. Okay. And in that assault, which we will talk about, did that cause you any sort of head injury or memory loss? Yes. Okay. So as we go through the dates, I'm going to try to refresh your memory. If there's things you don't remember, just tell me you don't remember. Okay. Is it fair to say you were married from the defendant from 1966 to 1976 and divorced in 77? Yes. Okay. Tell me about your marriage, your relationship with Isiah. Probably the first year maybe probably was pretty good. The second year he started to physically assault me. Go ahead. On a regular basis. When you say he physically assaulted you, can you tell us some of the things that he did to you? He slapped, knocked, hit, whatever. Did he ever physically assault you when you were pregnant with any of your children? Yes. Okay. Which children? Kimberly's. When you say he assaulted you, what did he do to you when you were pregnant with Kimberly? He threw me on the floor. He kicked me in my stomach. When you separated in 1976, tell me what finally causes you to go to separate. Well, off and on he would assault me, and then in 76 I decided that enough was just enough. And when you left, you moved away from him, did he still continue to contact you? Yes. Okay. Did he ever continue to assault you times that you separated and were preparing to divorce? Yes. Can you tell me about a time you remember that happening? I had left him, and I remember one time he saw me again, and my mother came get me, and I went to her house, and it was someone there at her house, and all my children were there at the time, and my sister and my brothers were there too. They were afraid, and my mother finally, I'm not sure what year it was, but she came to the door, and she told him, she said, well, if you come in now, I'll do that. This axe, she put axe to the door,
And so he knew, he said, I remember the words he said, you're a crazy woman. And she left.
Any of these physical assaults, or separated from physical assault advice, were they ever over child support or him having to pay child support?
I don't remember fight necessarily, but I remember he did tell the judge that he wasn't going to pay child support. That he would pay, that the judge could not tell him what to pay the children, that he would pay what he wanted to.
We've actually gotten a personal protection order on him since that 1984 assault, correct?
Yes.
Well, actually, correct. Your daughter, Kimberly, back in the 1960s when she was about 2, maybe 3 years old, did something happen to Kimberly?
Yes.
What happened to Kimberly?
I was at work. I came home and Kimberly was acting a little strange, a little uneasy. So I asked her what had happened to her. And I, tried to find out in little child's words. And she really couldn't tell me what happened. I asked her older sister what had happened. She was a little older than her, so, but she couldn't tell me either what had happened.
Let me ask this, at the time, Kimberly's home, is your older daughter Verna?
Yes.
Who was there with the children when something happened to Kimberly? Who was watching?
The dad, Isiah.
Okay, all right. So when the kids don't tell you what happens next?
Kimberly was just kind of really sore and to the touch almost. And so she finally, I called his mother and she came over and we took her to the hospital.
Did Kimberly have any injuries?
She had, I know it was 1 broken leg, I think it was 2, and a broken arm or 2 broken arms and a leg. I know it was 1 broken leg.
With these broken bones, did you ask Isiah what happened to Kimberly?
Yes, I did.
At that time, what did he tell you?
He said that she had fell into the bushes that were in her yard.
Did CPS become involved?
Yes, they did.
Okay. Did Kimberly actually leave the home for a period of time?
Yes, she did.
For about how long?
Probably 2 weeks or 3 the most.
Was Kimberly in a cast?
Yes, she was.
At that time, do you remember if Isiah was interviewed by CPS as to what happened?
Yes, he was.
Okay, do you know what he told them?
He told them the same thing that he had told me.
To fast forward, maybe 1972 or 73, do you remember Mr. Williams sending you a letter asking you to come see him in prison?
Yes, he was in prison on a narcotics charge. And my mother and his mother were asked to come to the prison to see him.
Did all 3 of you go and see him?
Yes, we did.
You were still married to him at the time, correct?
Yes, yes, I was.
So when you came to see him, what, if anything, did he tell you?
He said he wanted to talk to us. He really just wanted to be honest. He felt God, and so he really wanted to tell us what happened. And so he told me at that time that he had assaulted Kimberly and had thrown her down because she wouldn't stop crying. She would often cry with him mostly all the time. She never connected, she never bonded with him. And he tried to stop her from crying, she wouldn't stop, so he pushed her down. He threw her down. Excellent.
When you say he threw her down, did he indicate where in the house he had thrown her down?
I don't remember where in the house, but on the outside of the house, it was the back instead of the front.
In the time that you separated from him until your divorce was granted in 1977, did you get some restraining orders, some personal protection orders against Mr. Williams?
Yes.
Did they ever keep him from contacting you?
No.
Your divorce was granted, does July 7th, 1977 sound about right to you?
That's correct.
Had you ever seen the baby Olisa Williams?
Yes.
Did you know Denise, now Denise Frazier, Denise Williams?
Yes, I did.
Okay. How did you know Denise?
I'm not sure how I was thinking about it. I'm not sure how I met her, but I had talked to her often. I had warned her about Mr. Williams being such a violent man. When I found out he was sick, I think I found out through the visitation of my children with him. And I had told her that, you know, she really didn't need to connect with him because he was a violent man. And so that's really how I got to know her.
Elizabeth, it's been 41 years. You and I had a chance to talk before this hearing, correct?
Yes.
And have you had a chance to review your prior interviews as far as a little bit of the dates and the times?
Yes.
Does it help you remember the timeline a little bit, given that it's been 41 years and you've had some medical issues?
Yes, a little.
Do you recall talking to Detective Iverson and actually Sergeant Canada back in 1983 and recalling that it was July of 1982 when you last saw Olisa?
Yes.
Okay. When we're talking about Olisa, may I approach your honor?
You may.
This is People's Admitted Exhibit 1. Is this who we're talking about?
Yes.
Okay, that's the baby that you saw in July of 1982?
Yes.
Back in 1983, when your memory was fresh before your injuries, do you recall telling them, you recalled it being July 9th that Mr. Williams actually brought the baby to your house?
Yes.
Okay. Now, before that, had you seen Olisa?
Yes, I had seen her at the hospital.
Tell me what hospital you'd seen her at.
I think it was University.
Do you remember about how much time, was it a long time before he brought her to the house or a short time that you saw it at the house?
I think it was a short time. I had seen her at the hospital when I visited his mother.
Tell me about that. Why were you at the hospital visiting his mother?
They said that his mother was very, very sick and that she may not live. I was very close to her. And so I went to see her many times, probably 4 or 5 times.
When you went to the hospital, how many times did you go to the hospital? Let me ask that.
I'm thinking probably about 4 or 5 times.
How many times do you think you saw Olisa?
At least 4.
Who was she with?
Yeah.
How did she look?
She looked fine to me. I mean, she was a pretty baby.
She looked healthy to you?
Healthy to me.
At that time, did you, when you first ran into Isiah with the baby, did you know he had a new baby?
No, I didn't.
Did you ask him about having the baby?
I think first I asked the sister, Geraldine, who's deceased now. I asked her who would say he was. And she said, well, my brother said it's his child.
And now did you ask now Isiah who the baby is? What does he tell you?
He said it was his child.
At that time, did you have any concerns at all about why the baby was with Isiah and not with Denise?
Yes.
Tell me about that.
I remember asking him where was Denise. She was the mother of the child. Well, where was she?
What did he tell you?
He said he at that time told me that she was there in the Ann Arbor area. She wasn't at the hospital, but he was keeping the baby.
He said he was keeping the baby for her?
Yes.
Okay. He didn't tell you that he took the baby from her, did he?
No, he did not.
So at that time, you had no reason to know that anything potentially criminal had happened?
No, the third time I think I asked him. I was a little curious, but I just didn't think the mother wouldn't be at the hospital without a child.
And does this suspicion cause you to do anything?
It caused me to call her mother, I think. I'm not sure how I met her mother, but I called over to the Frazier house and told them that I had seen Isiah with the baby. What was the need? I wanted to see her. And so said, her mother said at that time, she did not know. Denise was not there.
Denise was not with her parents in
No,
that number.
no, she was not at that time.
And Isaiah had told you she was here in the area.
Yes, he had.
Did that cause you any concern?
I was a little concerned.
After you'd seen the baby several times at the hospital, on July 9th, how is it that Isaiah brings the baby? Tell us what you remember happening.
Actually, it was getting close to my daughter Verna's birthday on the 22nd of July. And so we talked about that a little bit. The baby seemed a little dirty, which was not like Isaiah for a child or anyone else to be dirty around him. And so I asked him, I had a motive in mind when I asked him about could we clean up the baby and comb her hair. And so my motive was to call Denise and tell her I had the baby. Tell the parents after, well, this was after they had found out about Denise had been beat up in Ohio. And she had come there. She had come back to her area.
So you were trying to keep the baby there so you could get the baby back to Denise?
Yes, I was.
Okay. And you said it was getting close to Verna's birthday on the 22nd, correct?
Yes, it was.
Was Verna a teenager at the time? Around that age?
I think she was going to be 16.
Now you said that you noticed the baby was dirty. Did you notice anything about her clothes?
Her clothes were not clean.
So you and your girls cleaned her up, and did you actually take this picture of her?
My daughter Kimberly did.
Oh. And this was when she was at your house,
Yes.
July 9th, 1982?
Yes.
And just for the record, Your Honor, I was holding up exhibit 1.
Yes.
Did you try to get Isaiah to leave the baby at the house?
Yes, I did.
Did he leave the baby?
No, he would not.
Did he say why he would not leave the baby with you?
He didn't say, he just wouldn't do it.
How long did he stay there approximately before he left with the baby?
I don't remember how long he said, it was long enough for them to clean her up, put her clothes on, and comb her hair. Kimberly combed her hair and Vernon dressed her.
Did you see what kind of car Isaiah left?
No, I don't remember right.
Did he leave with the baby? Just him and the baby?
The baby, yes.
Did he have any of the baby's belongings, a car seat, anything like that that you remember?
I've never seen a car, no.
Fast forward a couple weeks, you mentioned Verna's birthday, July 22nd, correct?
Yes.
Do you remember telling Sergeant Canada you went to Detroit with Isaiah around her birthday, July 22nd?
Yes, the 21st.
The 21st, the day before.
Yes.
Do you remember why you and Isaiah went to Detroit?
I'm not sure why we went to Detroit, but he wanted to, well, we initially went the 21st, the 22nd, I think he wanted to catch a bus.
Tell me about that. You said he wanted to catch a bus. Where was he catching a bus to?
From Detroit.
Okay, to where?
To Alabama.
Did he ask you to take him to the bus station?
He did.
Okay, and did he tell you why he was going to Alabama?
He said to see some relatives. I had known him for many years and didn't, I mean, I knew they probably maybe had some relatives there, but I had never met any relatives from Alabama. All of his brothers and sisters, except for him and his younger sister who were born in Alabama, but I had never met him.
So you didn't meet anybody that he was allegedly going to see, correct?
No, I didn't.
He didn't tell you who he was going to see.
No, he didn't.
Did he have any luggage with him?
No, I don't remember.
Did he have Olisa with him?
No, he did not.
Do you remember telling the police that Isaiah told you he had to get out of town?
Yeah, but so, yeah, he did tell me that a couple of times.
And again, was this around Verna's birthday at the end of July? And at that time, was it your understanding that Isaiah lived in the state of Ohio?
Yes,
But he was going to Alabama.
yes,
Did you actually witness him get on the bus and leave?
yes, I did.
Did you ask him at that time where Olisa was or who had Olisa when he left at the end of July to go to Alabama?
I did ask where the baby was. He said the baby was with, her mother.
That's Denise.
Yes,
You've come to since learn that is not accurate.
that's true, yeah.
At some point, does Isiah come back to Michigan?
He came back for his mother's funeral. She did die. He came back for her funeral.
Was that in September of 1982? Do you recall?
Yes.
He did not come back, or you did not see him before then?
No,
Did you have any conversations with him by phone between that time period of end of July and September?
I may have had a conversation with him on the phone, but I don't remember.
Let me ask this. In the time period that Isiah is gone, did you have conversations with Denise at that point?
Yes, I did.
Did you learn that Olisa was missing?
Yes, I did.
When Isiah came back, did you ever ask Isiah where Olisa was?
Many times, yes.
Tell me about one of the first times you remember asking him and what he told you.
He told, I don't remember exactly when it was. He told me that, but he said something about she's across the water or something.
Did you know what that meant?
I did, and he didn't explain it.
So did you continue to ask him over and over what happened to Olisa?
Each time and every time I saw it, I asked him.
Tell me about other things he would tell you.
I remember one time he told me he had met someone, when he was in prison, when he was in jail or something. He had met a couple, a man, and the parents of this young man wanted a little girl. And so he said, he had told me about that.
Did he ever admit to you that he had told Denise that he killed Olisa?
I don't think he said that right then, but he said that in my mom.
Remember how much later on he told you that?
I think he told me that when I learned about her at the motel in Inkster or some area that she had to jump out the window. I asked about that then, and that's when he told me that.
That he had told Denise that he had.
Yes.
Did you ever inquire further about him killing her, whether he did that or not?
And he said, well, I was just making a joke of it. I really didn't do that. I wouldn't do anything like that.
But at that point, had you seen Olisa since?
No.
The house that you were living in when you last saw Olisa in July, early July, where was that house?
On Oakville Watts in Carlton.
What county is that?
Wayne County.
Let's talk about his mother's funeral, or actually before his mother's funeral. In August or September of 1982, was there a time that you found something in your garage?
Yes.
That didn't belong there? Tell me about that.
I found a new shovel in my garage. And so I asked my children about it. My boys are very young at the time. My girls, I asked them about the shovel. And their cousins come over to the shovel. And they said no. So I called the police department and told them that the shovel had appeared in my garage. And I'm not sure what happened, but at that time, Carmen Highland was working for Channel 4, and she came out and did a story about the shovel, and I said, no.
I know what found you. Is this the same house that Isiah brought the baby to?
Yes, yes, it was.
Did Isiah have access to this house? Did he have
No, he didn't have a key. Okay.
But he could come on the property, correct?
He could come on the property.
And so you saw this shovel. What prompts you or what concerns you enough to call the police?
because I know I didn't buy it, and, it was in my garage.
At that point, did you know Olisa was missing?
Yes, I did.
Did you also tell the police that Mr. Williams was an avid hunter as well?
Yes, I did.
Did you disclose and tell them some of the places that he was known to go hunting in Michigan, Carlton and Highland area, northern Ohio?
Well, he would go hunting a lot, different places. in that area. Because he hunted a lot.
Tell me about the funeral on September 2nd, 1982, when Isiah returned back from Alabama. Did he have the baby?
No,
Did you see Denise show up? Did Denise have the baby?
no.
Anybody asking Isiah at that point where the baby is?
I'm not sure what anybody else is doing, but I had asked him about it.
And is it those same stories that you told us?
Same story.
Did Mr. Williams ever tell you a story about being in Island Park in Ann Arbor? The baby disappeared.
I think I heard that from someone else, and then I asked him about that same story. He said that, I'm not sure whose car he was driving, but he said the baby was with him in the car, and he fell asleep. He had been smoking marijuana, and he fell asleep. And the baby was in the car seat at the time he went to sleep. When he woke up, the car seat was not there, the baby was not there. There was a box of diapers was not there. And he wore kind of expensive boots that were called dingo boots. They were not there.
The boots, the baby, and all the things were gone according to Mr. Williams.
Yes, he said it was at Island Park. I bought some nursing hospital.
In Island Park, across from the University Hospital, that's in the city of Ann Arbor, correct?
Yes.
Mr. Williams, if you know, did you report this to the police that at the time that the baby was taken?
Not as I know of.
This story about baby being taken from Island Park, did he tell you this after he told you about giving the baby away or the baby being across the water? Was this before or after he told you the stories?
After.
Let's fast forward to February. Remember something happened to you?
Yes.
Tell me what happened.
I'm by my job and we're talking about and she was graduating from school, I think it was. We were talking about different things, and so he said he wanted to drive my car. In fact, he was driving my car, I think. And so he picked me up at work. We began to go down Devonshire, Vinewood area over there. I had worked there. I had done some domestic work there, so I kind of knew that area a little bit. And he got faster and faster and faster. And at that time, I had a blue, I think Fairmont or something like that. I just figured that first of all, when I got in the car, he asked me for $50. I told him I didn't have $50. I was taking care of his children.
How did he react to you not giving?
He got upset.
What happened after that?
He started to slap me and hit me. I decided that he got faster and faster in the car. I decided that I needed to jump out of this car. But I was, I'm a woman of faith, and I believe in prayer. And I prayed and I said, God, please let this door open. Let me get out of this car. Because I wanted my kids, my girls especially, to know that I at least tried to do what was right and what that I felt I needed to jump out of the car. So I opened the door. The door was stopped a little before that because Kim and Vernon, I think Kim and Vernon started driving and they were arguing over who could drive the car out of the garage. And, so that's the reason why I prayed and asked God to please open that door open. I opened the door and jumped out of the car. He was driving the car still.
It was still moving when you jumped out?
Yes, it was.
What happened next?
I ran to the closest house I could see. And I was going to the back of the house. At the time, there was a lot of lumber in the driveway. I wasn't sure at the time about what happened, but they were building a garage at the time. So I ran to the door, the back door. It was a big kind of mansion type house. And so it just so happened that there was a pilot that lived in the house. He was there. He was only there because his wife was having a baby. So when I was knocking on the door, he didn't hear me because he was on like the second or third floor of this house. So I knocked on the door, and Isiah got in. He was still in the car. He ran the car into the other 2 or 3 cars that was parked in the driveway.
He crashed into
And
the car.
crashed into it. So that was made the attention of the man knows of the house. And so he looked out and saw what happened. He in return told the court that he called the police. And when he came to the back door, I was there. Isiah had got to the back of the door and picked up a board and hit me in my head.
So one of those boards you were talking about, the lumber,
Yes.
building the addition over there,
Yes, it was 7 feet long.
7 feet long, he picked up a 7-foot board. Where did he hit you with that board?
Well, he first started with my head. I covered my head with my hands like this. And he began to hit me with my hands. I had started on both of my arms with that. And my hands just went down because I heard the crack when it cracked. By that time, the gentleman from the house came outside.
And did he stop him?
He said, please stop. He said, she's leaving. And Isiah said to him to go in the house and get some towels. The man of the house came with the towels. He thought he would, of course, try to take care of me himself. Isiah wanted to do that himself.
So did Isiah start putting the towels on you?
He started putting the towels on.
Did the police come to that scene, to that house?
It was one officer at the time.
Did they arrest Mr. Williams?
They did.
And was Mr. Williams charged with assaulting you?
Yes, it was.
Did he go to prison?
Yes, he did.
We talked a little bit before that this assault has caused some memory issues for you.
Yes.
Tell me how it affected you.
So affected me more these years. I was told by my neurologist, please do not fall. You have a lot of concussions already. And those concussions came from Isiah.
From the assault?
From the assault, yeah. And that's one of the reasons why the doctor said I had a head stroke.
Causing from the injuries from your assault?
Causing injuries, yes.
When Mr. Williams got out of prison, did you continue getting a personal protection order to keep him away from you?
Yes, I did.
Right. Your Honor, may I approach?
You may.
Ms. Reese, this is people's proposed 56. Does this look like the paperwork that you had regarding one of your personal protection orders, 1997 and 1990? Looks like 1997. Got it.
Yes.
Does that accurately reflect the paperwork that you had to fill out and that came from the court at the time?
Yes.
Okay. Your Honor, I'd ask that people's 56, which is 7 pages in length, be admitted into evidence.
Any objection, what dear?
No objection for exam purposes only, Your Honor.
Exhibit 56 is admitted.
Ms. Reese, did the defendant ever claim to you that he had a close head injury at any point that caused him to not remember who he was or who you were?
He didn't say that to me. I got my information after that I didn't communicate with him. I got that from my daughter.
He's never directly said that to you. Let me ask that. Was one of your sons passed away?
Yes.
Is that Deshaun?
Yes.
Did you call him Sean?
Yes.
Was there a state hearing regarding some money for Deshaun in 2004 or 2005 timeframe?
Yes, it was.
Did Mr. Williams show up at that hearing?
Yes, he did.
Did he testify at that hearing?
Yes.
Did he testify as to be Deshaun's father being entitled to some of that money?
He did.
Were you contacted in around 2008 or 2009 to give Isiah some money?
Yes.
Okay. Were some threats made to you from Isiah about what would happen if you didn't give him that money?
Yes.
What did Isiah tell you?
It was a threat about, he was in the building where my grandmother lived at the time.
What was your grandmother's name?
Woman Robinson.
Okay. He was in that building. What did he tell you?
Well, he told me that she was baking rolls, and I knew she was a baker, and he knew exactly where she was at the end of the hall. That's where she lived.
Did he tell you something that would happen to her? You didn't give him regarding what would happen to her?
He said, on the phone, you remember what happened. Something could happen to your grandma. And he knew I was very close to her.
At that time, did you have a granddaughter, Simone?
Yes.
Okay. Did he make a statement to you about Simone disappearing like that baby? Do you remember telling the police that?
Objection, meeting. Sustained, but you rephrase.
Let me ask this. Did you give some information to the police that in 1983, 2011, 2014, and 2015 regarding all of your knowledge on this case?
Yes.
Okay. Did you give the police some information at that time about some threats that Mr. Williams had made to you regarding his bail?
Yes.
You've already talked about some threats that you're telling your friend, correct?
Yes.
Did he make some threats regarding Simone?
I believe so. It was in comparison to, from Simone to the baby that was missing.
When you say comparison, tell me what you mean by comparison.
I don't remember him saying directly that it's about the baby, but it was about comparing one to the other.
Okay. You don't remember his exact words?
No, I don't.
Was this around the same time that he'd been asking you that money that we've been talking about?
Yes.
Do you have any current relationship with the defendant, Isiah?
No.
Have you always cooperated with the police in giving your statements?
Yes, I tried my best to.
Have you always been truthful and upfront with the police?
At that particular time, I was. Yes.
Ms. Reese, do you recall approximately how old Kimberly was when she got these injuries, broken leg and broken arm?
About 2.5.
About 2.5 years old?
Yes.
I don't have any further questions. Thank you, Ms. Reese.
Okay, hold on, cross-examination.
Good afternoon. You said Mr. Williams is an avid hunter. So did he move around to hunt? Like, did he go to different locations to hunt?
Yes.
Okay, so it wasn't unusual for him to be out of town or on his way out of town?
In the area, but not out of state.
Right, but it wasn't unusual for him to travel, correct? Okay, and you said that he did have family from Alabama?
Yes.
Okay. And at the time that he was leaving, his mother was sick, correct? She died like 2 months later, right? Okay. He was close to his mom, right?
Yes.
Okay. And when you saw Olisa at your house in July, you said that she was dirty and she had on dirty clothes. When you guys washed her up and changed her clothes, you didn't notice any bruises or scars or anything, correct?
No.
Didn't notice any signs of abuse, did you?
No.
Okay. And when you initially started hearing rumors about Olisa being missing and Mr. Williams' possible involvement, you initially didn't think anything of it, correct?
When you asked me, my worst heard about.
When you first started hearing rumors and speculation about Olisa being missing and about Mr. Williams possibly having something to do with that, initially, you did not think that he had harmed the child, correct?
Initially.
Okay. In fact, initially, you thought he was with his sister, Geraldine, or someone like that.
No, him or not the baby. I thought the baby was with her mother.
Okay. But again, you didn't think anything was wrong with the baby, especially not based on your last observations or interactions with the baby and Mr. Williams, correct? Let me phrase it this way. When you saw Mr. Williams with the baby, did the baby seem to be scared of Mr. Williams? Okay. Did the baby seem to want to stay with you guys and not go with Mr. Williams when Mr. Williams was leaving?
Judge, I'm gonna object to how she's gonna be able to answer what infant was seeming to want to do at the time. I think that's speculation.
Okay, I'll rephrase. When Mr. Williams was getting ready to leave with the baby, did the baby seem to cling to you guys, or did the baby seem to go with Mr. Williams with no problem?
When was the William?
Okay. And although Mr. Williams was coming around during this time, you were still somewhat afraid of him, correct? Because of his past? So it's fair to say you were trying to get him out of your house as quickly as possible, yes?
Yeah, yes.
Okay, so you weren't trying to walk him out to check out the car or see what was in the car in terms of belongings for him or the baby, correct?
No.
So when he walked out the door, you just let him go with the baby, right?
Yeah.
Okay, no further questions.
Right.
Ms. Reese, you said, I noticed when you were asked that last question, you said him, yes, I'm trying to get him out.
Yes.
You were trying to keep Olisa in, correct?
Yes.
Why were you trying to keep Olisa in the house without Mr. Williams there?
Because I wanted to notify her mother that I had her with him.
You wanted her to be with her mother. And you were asked about rumors of Olisa being missing. As far as rumors, you've never seen Olisa again in the last 40 years, have you? Okay. And you said you initially did not think he harmed her. What do you think now?
I think he did.
And you were asked about him hunting, and you said he hunted in state, correct?
As far as I know, I'm not safe.
When you took him to Alabama, he didn't tell you he was going there to hunt, correct?
No, he did not.
Okay. And you talked about him being close to his mom. You were close to her as well, correct?
Yes.
And when Isiah left to go to Alabama at the end of July, was she still sick?
Yes.
She was dying, correct?
Yes.
And Isiah went to Alabama, correct?
Yes.
I don't have any further questions. Thank you.
Good for you. You don't like Mr. Williams, do you?
Not that I don't like Mr. Williams. I don't like what he does and what he's done to me.
Okay. You don't hold him in high esteem, correct?
No, I do not.
So if someone told you something negative about him, it's fair to say you would believe it versus not believe it, yes?
No, I wouldn't.
Okay. Does Mr. Williams strike you as the type of person who stays to deal with difficult stuff, or does he tend to run when things get a little difficult for him?
Objection as to speculation.
Sustained.
You were married to Mr. Williams for over 10 years, correct?
Yes.
You had 4 children with him?
Yes.
even after you guys separated, you still saw him from time to time, even if the interaction was mainly around the children, correct?
Yes.
During the time that you knew him, is it fair to say that he's the type of person who, when things get difficult, he tends to run if he can't argue or fight his way out of it? Is that fair to say?
Yes.
Okay. He doesn't handle stress very well, correct? And he was stressed about his mother dying, correct?
Yes.
Okay, thank you. No further questions.
I don't have anything.
Okay. Ms. Reese, thank you very much. Here. Next witness.
Scotty Williams.
All right. All right. Here, please come forward. Is this him? Oh, please come forward to be sworn. And that's fine.
Take your seat, raise your right hand. So I swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. See. State your first and last name and spell it for the record, please.
Scotty Williams, SCOTTID WILLIA.
All right. Thank you. You may inquire.
Thank you. May I call you Scotty? Is that the name you go by? Okay. Do you know somebody by the name of Isiah Williams? Do you see Isiah Williams in the courtroom? Can you point him out and describe something he's wearing?
White shirt.
Okay. Your Honor, let the record reflect he's identified the defendant.
That objection record shows so reflect.
How do you know Isiah Williams? Okay. Is your mom Elizabeth Reese?
Yes.
Formerly Elizabeth Williams, correct? Okay. Did you give a statement to the police, to the Ann Arbor police in about May of 2021? Does that sound about right? Okay. Did the police come to you and talk to you about being an emergency contact for your father while he was living in Chicago? Being his emergency contact.
I didn't know.
Okay.
I was an emergency contact, yes.
Did you learn it from the police? Did that surprise you? Do you have any relationship with your father? Okay. Do you, at the time that you were interviewed by police, were you even in communication at that time with your father?
I wasn't. He was writing letters, but I didn't contact.
Okay. You are how old today?
46.
Okay. You would have been about 5 or 6 years old when Olisa Williams disappeared. Does that sound about right? Okay. Do you have any memory of her at all? Just pictures. Okay. Have you talked to your father back when you still spoke to him about his life in the 1980s and the 1990s, the earlier years when he was married, after he was married to your mom?
Yes.
Okay. Does he talk to you about the good times? Would he talk to you? Okay. Did he have a good memory of who you were?
Yes.
Did he seem to have a good memory of his past?
Yes.
Was there ever a time that you would bring up, for instance, the abuse on your mom?
Yes.
How does he respond to that?
He doesn't remember anything like that ever happened. It's all been told.
Okay. So has he talked to you about his time being incarcerated in the 80s?
Yes.
Okay. Does he talk to you about his memory of that, him actually remembering that?
Yes.
Okay. But when you bring up your mom, you said he says he has no memory of that. Is that correct?
Correct.
Does he tell you why he has no memory of that?
It's been a few different stories. One story is when he was incarcerated, he was supposed to have something planted in his teeth. The other time is it's like brain trauma from life.
Did he ever tell you he was in a car accident and had a closed head injury?
He didn't tell me, but I heard it.
But he never directly told you that. Okay. Did you ever ask your father about Olisa Williams and what happened to her?
At one time, did.
Okay, at the past when you would actually speak to him, is that fair to say? Tell me about what he would tell you.
Blocked out memory, didn't have anything to talk about.
He said he had blocked all memory and he doesn't have anything to talk
No,
about.
he didn't say.
Okay,
But he just said he don't remember anything.
okay. Would your father at the same period of time talk to you about you guys as children, kind of happy childhood memories? Okay. He talked about your siblings, your older siblings, correct?
Yes.
Okay, because he was in their life more than he was in yours. Is that fair to say?
Yes.
But when you bring up Olisa, he says he doesn't remember, correct? Was there a few years back where you were ill?
No, he doesn't remember.
I apologize. Was that, no, he doesn't, does he, when you ask him, he says, no, he doesn't remember. Is that correct? He has no memory of her.
No, he didn't say that.
What does he say?
What he said, time when I asked him was that he didn't remember what had happened and he didn't want to talk about it.
He didn't remember and he didn't want to talk about it. Okay. Some years back, was there a time when you were ill, you were suffering some health problems?
Just sick.
Okay.
Like a cold or something like that.
Did your dad come and see you?
Yes.
Was this another time that you were prompted to ask about Olisa and what happened to Olisa?
That was the time.
Okay. Is this the time that he told you he didn't remember and not to ask? Did he get upset at you for asking about that you remember?
Yes. Well, he was already upset because I had asked him first off about my mom, what happened between my mom. And then that's what it led into me asking about what happened to my sister.
So you asked him about, when you say you were asking him about what happened with your mom, were you speaking specifically about the abuse?
Yes.
And what was his response to that?
And he doesn't remember anything. That's all they told to him what happened.
So if I'm understanding, that prompted you to then go on and ask about Olisa. And you said he was already upset. Did this make him more upset?
I would say, yeah, in the conversation.
Well, hold, I just want to make sure I'm understanding your testimony. Because you said there was a conversation about your mom. And then I think you said your sister.
Olisa, I refer to her as my sister.
Okay, that's what I want to make sure. Okay.
And this all happened in the same event, these two, the conversation about your mom and the conversation about Olisa, it was all in the same, sitting down, the same situation. Okay.
I don't have any further questions. Thank you.
All right. Any questions?
Good afternoon. You said that when you ask him about certain periods of time, he has memory loss? Or he says he doesn't remember?
Yes.
Okay, and that's when he becomes agitated and upset? Okay, and the follow-up questions about other events around the same time period that he says he lost his memory? Okay, so he says he lost his memory from one period of time to the next period of time. In other words, a certain span of a number of years, he has no recollection, correct? Or that's what he's told you over the years, correct? Ask about incidents during that period of time and he doesn't recall, he gets agitated, correct?
Correct.
Okay, no further questions.
I also asked you if you would ask your dad about memories of specific period of times. Is it specific periods of times or specific memories in those periods of times? Does that make sense the way I asked it? Let me ask it this way. So you would ask about your mom, right? How he treated your mom during a specific period of time. Is that fair to say? Okay, and he would get agitated and upset about that, correct? Okay. What if you asked your dad about a positive memory, not about the abuse of your mom, but positive memory about, for instance, your sister's childhood or something like that? Does he get agitated about that?
No.
Does he answer about what he remembers for that? Is that a yes?
Yes.
I don't have any further questions. Thank you.
Nothing else? All right, you may step down. Thank you, sir.
The people call Kimberly now. She's coming.
Ma'am, if you could please come forward to be sworn.
This one?
Take your seat, raise your right hand. Solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Go ahead, have a seat. Last name is spelled for the record.
Kimberly Webb, Kimberly.
And you may inquire, counsel.
Thank you, Your Honor.
May I call you Kim or Kimberly? Kim's fine, okay. Do you know someone by the name of Isiah Williams?
Yes.
Who is Isiah Williams?
My
Okay, do you see Mr. Williams in the courtroom?
Yes.
Can you point him out and describe something he's wearing?
White shirt.
Your Honor, let the record reflect Ms. Webb has identified the defendant.
Record shall so reflect without objection.
Let me ask this. Do you currently have a relationship with your father?
No.
Do you speak to him at all?
No.
Okay. You are how old now?
55.
Okay. What's your date of birth, Kim?
11/21/1967.
Did you ever witness any abuse on your mom at the hands of the defendant?
Yes.
What did you witness?
I witnessed him hitting, slapping her, knocking her down.
Was that when your dad lived in the same home with you?
Yes.
Okay. At some point, did your dad not live in the same home with you anymore?
Yes.
Okay. Did something happen to you when you were maybe 2.5, 3 years old? Do you have, let me ask that right away. Do you have any memory of what happened?
No, just the only memory I have is that, that something did happen.
Okay. Did you ever see pictures of yourself injured?
Yes.
What pictures did you see of yourself?
I saw a picture with, I was just a young child with crutches and like a bandage on my arm.
Do you have any sort of lingering medical issues now with your knees or your legs?
Yeah, I have issues like when I go to bend down, like my knees pop and stuff.
Were you interviewed by the Ann Arbor Police Department back in 2014?
Yes.
Did you provide all the information that you knew of to the best of your memory back then?
Yes.
Okay. Back in the summer of 1982, so July of 1982, was that if your birthday is November 21st, was that the summer before your 15th birthday? Is my math right on that? 1982, okay. At that time, where were you living?
I was living out in Simpson Township on Upper Walks Road.
Who were you living with?
My mom.
Was your dad living there anymore at that time? Okay. At some point, did your dad come over with a baby?
Yes.
Okay. And was that baby Olisa Williams?
Yes.
All right. Had you seen Olisa before? Do you remember?
I think I had seen her maybe one time before that.
Just so we're clear, in People's Exhibit 1, is this who we're talking about, the baby that your dad brought over?
Yes.
Okay. Who took this picture?
I did.
You took this picture?
Yeah.
Okay. What do you remember happening when your dad brought the baby over to your house?
Yes, I remember him bringing the baby over, but I don't remember him like staying. I remember him leaving at some point in time. So the baby was there, and so she wasn't like dressed. She basically she looked like she needed to be like cleaned up and stuff. So we cleaned her up and dressed her. We found some clothes and stuff for her, and so I put the clothes on her and stuff, and then I did her hair. After I did her hair, I was like, oh, she looks so pretty. And so then that's when I took the picture of her.
At some point, did she leave with your dad?
Yes.
Was it in the night or the early morning, if you remember?
Yeah, I don't remember.
Okay. When your dad left with Olisa, have you ever seen Olisa since? We're talking 41 years. You've never seen her once in 41 years, correct? Okay. And who did she leave with when she left your house in Sumter Township? When you did speak with your father, did you have any conversations with him about what happened to Olisa or where she was?
Yeah, over the years, I would ask about, what happened. And, so originally he would say, that, he said that, someone had taken her. And then later he would say he didn't remember.
Let me ask you, let's back up a little bit. Do you recall a time when he was in Jackson prison and you took your daughter up to see him?
Yes.
Okay. Do you recall asking him about Olisa back then?
Yes.
Do you remember what he told you back then when he was in Jackson prison?
At that time, he, said he didn't remember.
Do you remember what year that was?
Let's see. It would have been, I don't think a year, but my daughter at that time was about, wasn't that old, she was maybe about 2 or 3 years old. So she was born in 1980.
So this would have been the 80s that he had told you he didn't remember. Correct?
No, my daughter was born 1990, so.
Got it. There we go.
1990.
There, that helped me. And so was this before your dad was released from prison for the assault on your mom, if you know?
Yes.
Okay. The indication that someone had taken her, do you remember when he told you that?
That was like early on. He said he was in the park and fell asleep when he woke up, she wasn't there.
Do you remember what park he told you that happened at?
I don't recall him ever giving like a specific location.
Okay. Once your dad actually got out of prison in the 1990s, did you then again ask about Olisa and what happened to her?
Yes, a lot of times when I have to see him, I would ask him, so I did remember asking him again. And at that time, he said, didn't remember, and he said that, he didn't remember, he said that the state had implanted a chip.
And that's when he had gotten out of prison, correct? All right, let's talk about that. Has your dad ever told you that he was in a car accident and that caused him to have lack of memory?
No.
Did your dad ever tell you he was poisoned and that caused a lack of memory?
No.
But your dad has told you that he has a lack of memory and doesn't remember what happened to Olisa, correct?
Correct.
And please tell us again, what was his reasoning to you as to why he can't remember where Olisa is or what happened to her?
Yeah, he said that I guess while he was in prison, they implanted a chip in his head and erased his memory.
And that would have been when he was incarcerated for the assault on your mom in 1984, correct? Okay. Let's talk about, aside from asking your dad about memories about Olisa, have you ever asked your dad specifically about memories of him assaulting your mom?
Yes.
Does he talk about remembering that?
Yeah, he always says he doesn't remember that.
When you did speak with your dad, so specifically, let's talk about when he got out of prison in the 90s, did you talk to him about the good times, your childhood?
Yes.
Now, does he talk to you about that? Does he exhibit having memory as to that?
Yes, he would remember a lot of those things.
Is he able to, when he talked to you back in the day, talk to you about his own childhood and his past?
Yes, I don't think we really talked a lot about his own past, during that time.
Okay. But he is able to talk about your past with maybe you and Verna, your childhood.
Right.
He exhibits a memory as to that.
Right.
Okay. Kimberly, do you know of any close family relatives in Alabama close to your dad that lived in Alabama in 1982?
No.
Do you know of any close relatives even there now in Alabama?
I've got a cousin that lives there.
Okay. But that wasn't in 1982, correct? Okay. Tell me about how your dad, his demeanor, how he acts when you confront him with either memories of your mom or memories of where is Olisa? How does he act towards you? You've already told us he says he doesn't remember, but how does he act? What's his demeanor?
Yeah, a lot of times he just tries to, you know, talk about something else or, get off the subject.
Have you ever confronted him before about his ability to recall certain things, but not recall about Olisa? Have you ever actually confronted him on that?
Yes, we've talked about
Tell me what you said and what was his response.
yes, I've told him that a lot of times, you know, he seems to remember some things, like, you know, he remembers things about like the law. He remembers, you know, things about, you know, our childhood, but then, you know, so it's kind of a selective, you know, what he chooses to remember.
One moment, Your Honor. You mentioned that you haven't spoken to your dad in quite some time. How long has it been since you've spoken to your dad?
And probably at like, I think the last time I'm thinking it was probably the family funeral. I'm trying to remember who passed away, but it's been 2 years.
What decade would that have been in?
Probably at least maybe 7, 8 years ago.
Okay. And why don't you have any contact with him?
You know, because I told him, you know, until he, you know, lets us know kind of what happened, and then he remembers the hurtful things that he's done to my mom, that I didn't want to have a relationship.
Thank you. I have no further questions.
Cross-examination.
No questions, Your Honor.
No question? All right. Ma'am, you may step down. Thank you.
We'll call Molly Reno. I think she's our relation.
Okay. Please come forward to be sworn.
Take a seat, raise your right hand. Do you solemnly swear that you're about to give no truth and nothing but the truth, so help you God?
I do.
State your first and last name, spell it for the record.
My name is Molly Reno, MOLLY RENO.
All right. Before you begin, counsel, I let the Attorney General know that, and I think Ms. Reno had let the Attorney General know that I do know Ms. Reno. We haven't seen each other probably in 20 years, maybe? Probably a little over 20 years. We used to practice against each other. I will tell you that she was the only one that beat me. No, but I haven't seen her in all that time nor had any communication, but I wanted you to know that I do know of Ms. Reno. All right.
Thank you, Judge.
You may inquire.
Thank you. Ms. Reno, what is your?
I am licensed as an attorney and I practiced law until about 10 years ago.
Are you licensed here in the state of Michigan? Yeah. What kind of law?
I practice a variety, civil rights law, landlord tenant law, divorce law, something law.
And were you interviewed by the Ann Arbor Police Department as part of this case?
Yes.
About how many times do you think you're interviewed?
I think 2 times in person, and then I might have had 3 phone calls. I'm not sure, it's been a while.
You, prior to coming in here, did you review some court filings from the Washtenaw County Family Court?
I did.
And were many of those filings that you had filed in the family court case?
Almost all of them.
Okay. And were they also filings that you responded to in terms of an attorney for Mr. Williams? So you had to respond to those filings?
Yes.
Okay. Your Honor, I have already shown people's 26 through 55. I believe there's going to be a stipulation to the admission of these for just exam purposes only, and there's just going to be, I'll allow the court to have an opportunity to review all of them, but there's just going to be a few I'll highlight, I think, for being more expedient.
All right. Is there going to be any objection to exhibits 26 through 55?
No, not for exam purposes only.
All right. Exhibits 26 through 55 are admitted.
Yes, Your Honor, thank you. Ms. Reno, you were able to have a chance to, it had been what, 41 years since you filed these documents. Is that fair?
40 and 41.
Okay. So you had an opportunity to go through these and review these before your testimony today, correct?
Yes.
And you also put together a chronology of your memory based on reviewing those documents and your involvement in this case, correct?
Yes. And it was a chronology based upon the documents.
Okay. That helped you refresh your memory as to
Yes,
how
exactly.
everything happened. Okay. Were you contacted back in 1982, about June of 1982, by a then Denise Williams?
I was.
Okay. Were you retained by Miss Williams?
Yes, I was.
Okay. In what capacity?
She wanted a divorce and she needed a domestic violence restraining order.
Did you initially get going in June and July and filing those requests for Miss Williams?
I did, and I had to file for what's called separate maintenance because she didn't meet the jurisdictional requirements for divorce.
And again, that is going to be, Ms. Reno, People's proposed, Your Honor, may I approach?
Yes, you may.
People's, not proposed, People's Exhibit 26. Is this the complaint for custody and separate maintenance? You're going to have to help me because I don't do any civil. Is that what we're referring to?
Yeah.
Okay. Is that because Ms. Williams and Mr. Williams at that time were residents of Ohio?
She was a resident of Michigan, but she hadn't been a resident of Michigan for the time period required for a divorce, which it might have been 180 days that you needed to have jurisdiction to file for divorce.
And Ms. Reno, it looks like you filed a couple different personal protection orders for Ms. Williams, People's 27 and 28. Looks like one was filed and docketed June 17th and one was July 15th. Do you remember why there were two different, were they just different court dates or different filings?
The first one is what's called an ex parte restraining order, although maybe it was temporary restraining order. And because the defendant hadn't been served with the paperwork, it was just for a short period of time, then to allow me to serve him with the paperwork so he could come in and object to the restraining order and to the custody order if he wanted to. So that time period expired. And so then I had to file again for another restraining order.
I think that, let's talk about People's Exhibit 29. There was an order for temporary possession of the minor child. Who were we talking about in question there?
Olisa Williams.
Okay, and was custody given that at that time, temporary custody to Denise?
She was given an order of temporary possession, temporary custody, yes.
At that point, what's the date on that?
The date the date is July 30th, 1982.
At that time, had Olisa Williams been brought before the court?
No.
Had Isiah been brought before the court? Had he been in court yet?
I don't think so. I think he was served and he failed to appear.
But he was served, you indicated.
Yes.
Okay. You filed multiple restraining orders for Ms. Williams, now Ms. Fraser Daniel. I believe there was a 5-year injunctive max order. What was that? Explain what that is.
Yeah, at that time, the maximum period of time that you could have a restraining order was for 5 years. And so at the time of the divorce, I asked for that 5-year restraining order and the judge granted it.
Was that common
back in the 1980s, around 1982, to be able to get a restraining order of 5-year adjunctive max?
It was just starting to be available. It was,
Ms. Reno, it looks like you also, according to the documents that we admitted, filed another restraining order in April of 1983, October of 1983, and November of 1983. Would that have been the issues with service again? Same issues that you were talking about, making service, Mr. Williams could object if he wanted to?
yes.
What's a writ of habeas corpus?
Well, at that time, Mrs. Williams, Denise Williams, told me that Mr. Isiah Williams had knocked her down and taken the 10-month-old child, Olisa. Maybe she was 6 months old at that time. And I was trying to get him before the court so that the court would order him to answer questions about the whereabouts of that infant, Olisa. And so a writ of habeas corpus was an attempt, well, it actually worked. It was an order for him to bring Olisa Susan Williams before the court.
And in looking at the documents that we've already admitted, we have People's Exhibit 31, and we have People's Exhibit 33. We've got the writ of habeas corpus and the order for writ of attachment. What's the difference between that? What's the order for writ of attachment?
The order for writ of attachment is akin to an arrest warrant in a civil case, because Mr. Williams did not comply with the first order, which was to bring that minor child before the court.
Ultimately, was there an arrest warrant for contempt of court issued by the judge in this case?
Yes.
Who was the judge at that time?
Judge Ross Campbell.
And looking at People's Admitted 35, is that the warrant for arrest for contempt?
Yes.
What's the date on that?
October 7th, 1982, signed by the judge and filed with the court a few days later.
At this point, had Mr. Williams brought the child to court yet?
No.
He had not produced the child, correct?
And I believe that there was also an order to show cause for Mr. Williams to come before the court and answer as to why he beat Denise Williams. And so when you asked me earlier about the order to show cause, I should have looked at it to see whether that was for the violation of the domestic restraining order when he beat her and choked her and put her in the hospital for 2 days.
And did you as her attorney get an opportunity to not only talk to your client, but review police reports with respect to that particular assault? Was Mr. Williams convicted of anything with respect to that?
I believe that he was convicted of felonious assault. He was charged with assault with intent to commit murder, and I believe that he was convicted of felonious assault.
What would be a referral to the friend of the court? Why would a referral to the friend of court happen during these proceedings?
Every time there's a divorce case, or at that time a separate maintenance case, and there's a minor child, there's a referral to the friend of the court to do an investigation to decide which parent is where the custody should be. Should it be with one parent? Should it be joint between both parents? So they make a recommendation.
Was that done here?
Yes, it was.
And is that some of the documents reflected in People's 37 and 40, the referral and the preliminary friend of the court file? Yes.
I reviewed them, and what was the question?
Did that take place with their preliminary recommendations from the friend of the court as to who should have custody of the child?
Yeah. Mr. Williams did not appear, and they awarded custody
Still at this point, have you or Denise seen the baby? Had the baby been brought to court
No,
by Mr. Williams or anybody else?
nobody else.
At some point, it looks like you filed a petition to amend the pleadings. Was this to change it from separation to a divorce?
That met the jurisdictional limit by having resided in the state of Michigan for the required period of time. And what she really wanted was the divorce, in addition to the protection against domestic violence and possession of the child, Olisa Susan Williams. So I was able to amend it, and the judge granted the order to amend.
Is this the copy, People's 39, is that a copy of, ultimately, I should ask, was the divorce granted?
Yes, the divorce was granted.
Do you remember when the divorce was granted?
Not off the top of my head.
Is that a copy of the divorce record
Yes.
confirming the divorce between Mr. Williams and Ms. Williams was
Yes.
ordered? Okay. Now, Ms. Riedel, it looks like there was a new order for writ of attachment in January of 1983. Had Olisa been produced for the court yet?
No.
Is this why there was a new writ done?
Yes, this, because he failed to bring Olisa before the court. And yes, that this was a writ of attachment, which in effect was an arrest warrant.
And so now this is now the second, essentially, not essentially, this is the second arrest warrant in the court file for Mr. Williams for failing to bring Olisa Williams to court.
I believe so, yes.
And then on January 24th, yes, absolutely.
Yes, this was for his arrest for failure to bring Olisa before the court.
Ultimately, it looks like Judge Campbell ordered a new ex parte order to Peter on January 24th, 1983. Does that look accurate to you? To the best of your memory of the filings?
Yes.
And in that document, and this is People's Exhibit 44 for the record, it does indicate that Isiah Williams was ordered before the court in January to tell the court time and place where he last saw the minor child and name of persons to whom he entrusted possession of the minor child. Is that correct?
Yes.
Ultimately, was there a hearing held for this very purpose, February 1st of 1980?
There was a hearing held, and I believe that is the date.
We're going to talk about that hearing, but let's talk quickly. Well, let's actually talk about it. Let's just talk about it. It's on my mind to talk about. Were you present on February 1st at that hearing?
I was.
Okay. And at that time, was Isiah Williams present at that hearing?
He was.
Was that in front of Judge Ross Campbell?
Yes, it was.
Was Denise there as well? At that time, did Mr. Williams take the stand and testify?
Yes, he did.
Okay. Was he sworn under oath, if you recall?
Oh, I recall. He was sworn. Oh,
What did Mr. Williams say with respect to Olisa Williams and where she was?
he said, Mr. Williams said that he had Olisa, I believe she was 10 months old at that time. He said she was in the car with him and that he drove in Ann Arbor and he drove and parked very close to Island Park, which is over near the U of M hospital. And he fell asleep. And she was in, as I recall, the backseat of the car, but someplace in the car. And he fell asleep, and when he woke up, he said she was gone.
Was Mr. Williams, well, let me ask first, you said Island Park in Ann Arbor, is that correct?
Yes.
Is there a body of water that runs through that particular park?
Yes.
What body of water runs through that park?
It's a stream, and it might be the Huron River.
Okay. And Was Mr. Williams asked if he reported this taking of Olisa to the police?
Yes, I found it, it just didn't seem credible to me that a 10-month-old could get out of the car on her own while he was asleep. And so I asked him, well, if she was missing when you woke up, did you report this to the police? And he said no.
So Mr. Williams' versions of events is that he fell asleep in the car and that he woke up and she was gone, correct?
Correct.
He did not report to the police, correct?
Correct.
Did he indicate to you whether she had any possessions in the car that were also taken or whether they were still there?
I don't recall that he said one way or the other, and I want to add that I also asked him, did you report this missing infant to any other authority other than the police? And he said no.
And when you say any other authority, what were you referring to?
I just thought he should have reported that any responsible parent would report a child who's missing to the police or to anybody else, but any other authority. I didn't have a particular authority in mind, but I just wanted to cover all the bases.
Yep.
Who did you tell?
And did Mr. Williams indicate if he told you anybody that this disappeared, that he told anybody about the disappearance of this child?
And I asked him, did he tell his sister, who he indicated he was living with off and on that summer? Did you tell her that Olisa was missing? And he said no. And then he also indicated he was living with an ex-wife that summer. And I said, did you tell her that this 10-month-old was missing? And he said no.
Speaking of where he was living, his attorney filed some documents. His attorney was Andrew Fanta, is that correct?
Correct, yeah.
He filed some documents listing on there some information about where Mr. Williams had lived, correct?
Yes.
I'm handing you People's Exhibit 48, and I'm going into page 5 of that document, the affidavit in support of motion to dismiss for want of jurisdiction. Was that a document you recall being filed by Mr. Williams' attorney?
Yes.
Okay. Did it indicate at that time the residence that Mr. Williams was staying in 1982?
No,
okay.
Yes. In this affidavit, which was signed by Mr. Williams, and it was a sworn affidavit. It states that Mr. Williams was living resident of the state of Ohio and that he returned to Michigan because of his mother's illness in June of 1982. And he temporarily resided with his brother in Pittsfield Township in, it says Ann Arbor. Oh no, Pittsfield Road, Ann Arbor. And that he also resided in the Paradise Hotel on Ann Street in Ann Arbor. And that then he left for the state of Alabama during the month of July 1982. And it says that Mr. Williams in this affidavit is stating, swearing, that during the months of July and August 1982, that he worked at a maintenance department in Sherfield in Alabama.
And it said Sherfield, Alabama?
That's what this says. Sherfield.
So that document confirmed 2 locations in Washtenaw County, correct? That he had been residing in, and one in Inkster, Wayne County, correct?
Yes.
And then confirmed, go ahead,
I'm sorry, 2 or 3 in the Ann Arbor area.
And it also confirmed that in July of 1982, he left the state of Michigan to go to Alabama.
Yes.
After Mr. Williams made these statements on the record in front of Judge Campbell, what did Judge Campbell do?
Judge Campbell put him in jail for contempt.
Did Judge Campbell also order a psychiatric evaluation for him?
Yes, he did.
Those are confirmed, that's confirmed in the documentation that you reviewed as well, correct?
Yes.
Okay, and that's the record, that's going to be exhibits 45, order for psychiatric evaluation, and exhibit 47, order for diagnostic commitment of defendant. Do you recall approximately how long Mr. Williams was incarcerated for contempt of court based on the statements he made in court?
I think it was for 60 days.
Eventually, did you go back to court because they were going to release Mr. Williams from jail?
Yes.
Did you file some documentation to try to prevent that from happening?
Absolutely. I was very upset that he could make such contemptuous statements, such unbelievable statements about the whereabouts of that child, and then be released from jail. And so I was attempting to persuade the judge to keep him in jail until he told the truth.
Is this People's Exhibit 49?
Yeah.
That's your opposition, plaintiff's opposition to release from jail?
Yes.
Ultimately, was Mr. Williams released from jail?
To my great disappointment, he was released from jail. Yeah.
Was he required at that time to give any further statements as to the whereabouts of Olisa Williams?
I don't recall that he was.
Did he ever bring Olisa Williams to court with him?
No.
You've already testified regarding some additional restraining orders, the 5-year restraining orders that you filed on behalf of Miss Williams, now Fraser Daniel. Is this one such order?
This is the prosecuting attorney, and the prosecuting attorney appears on behalf of, at that time, minor children and divorces, and it gives them an opportunity to place an objection on the record if one is warranted. And it's kind of a pro forma thing.
Okay. And this is whether or not at this time it would have been Mary Carroll, who's the assistant prosecuting attorney, would have objected to the divorce on behalf of Olisa, and she did not.
She did not, yeah.
Was it ever established on the record, if you recall, during these contempt proceedings or the divorce proceedings or the child custody proceedings, that Isiah Williams was not biological father of
I would have to refresh my memory with the documents. Okay. I do recall that he was not a biological father, but I don't remember if that was placed on the record or not.
Back in 1982, 83, was there a legal presumption of a defendant being a father that you'd have to get past if it wasn't placed on the record or something like that?
There was a legal presumption that if a couple is married, that the husband is the biological father of every child born to the wife during the marriage. And that could be challenged with paternity absence. But in the absence of that, it's the husband presumes.
Back when you were representing Denise Williams, now Fraser Daniel, was Denise indicating at that time that she wanted child support or anything like that from Isiah Williams?
She did not. She wanted him to stay away from, yeah.
What was her purpose? What did she want from these hearings?
Well, what she wanted was her child back. She wanted to know where is the child, and she wanted possession of the child as she had been awarded both by the Ohio court and the Michigan court.
And in terms of your filings from separate custody and maintenance over to official divorce proceedings, did Mr. Williams, through his attorneys, continue to contest the divorce?
No.
They did not contest the divorce?
No, the attorney contested jurisdiction for the divorce. And the judge ruled that she had been in the state of Michigan long enough and was entitled. There was no other contesting of the divorce.
I have no further questions. Thank you, Mr.
I had one thing. The attorney, Andrew Fanta, entered an appearance solely for the purpose of contesting jurisdiction.
Okay.
It was not a general appearance.
And that appearance he filed, correct me if I'm wrong, with that affidavit that we just talked about, where you laid out the addresses for Mr. Williams and all that.
Right.
Okay. Thank you, Ms. Reno.
Cross-examination.
One moment, Your Honor.
Yes.
I'm sorry, good afternoon. Was the biological father ever involved in any of the court proceedings?
No, not that I recall.
Was he ever named at all?
All of his name, but it might have been.
And to your knowledge, were any of those residences that were listed in the affidavit ever investigated or followed up on?
Mr. Williams' residences, yes.
The out-of-state ones as well?
It was the out-of-state residence that was investigated. But I only know that by looking at paperwork. It wasn't part of the divorce case.
Okay. So when you say paperwork, you're not talking about the filings that happened in 82, 83. You're talking about subsequent stuff that happened like 20, 30 years later.
I have to look at the paperwork to tell you how much later, but it was not part of the divorce proceeding.
Okay, so in 82, 83, when the divorce proceedings were going on, the residences that were provided by the attorney who only appeared to establish jurisdiction, they were not investigated at that time, is what you're saying, correct?
You're asking investigated by whom?
Anyone?
I wouldn't know.
Okay, so to your knowledge, no.
I didn't investigate.
Okay, thank you.
Anything
No
else?
further questions.
Thank you.
Thank you very much.
People call Betty Peters.
Can we do this? Because we've been going about 2 hours, kind of get my staff a little bit of a break here, about 15 minutes. So if we can reconvene about 4:30. How many more witnesses are you
I
participating?
have 3 today, but I think I'm only gonna call 2. Betty Peters will be very quick. Verno will be very quick. I'm gonna leave Detective Iverson for tomorrow since he's gonna be late. There's
All right, so the next witness is very quick, you think?
I think so.
Let's get him up here then. Let's just do it.
Swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yeah, so state your first and last name and spell it for the record.
You want to spell it? Can you spell it?
Spell it.
Peters. P-E-T-E-R-S.
All right.
Thank you.
Inquire.
Ms. Peters, can you hear me okay? Okay, if I ask something that's confusing, just tell me to repeat it. If you don't understand my question, if you can't hear me, anything like that, okay? Do you know somebody by the name of Isiah Williams? Okay, who's Isiah Williams to you? Okay, do you see him here today? Okay, can you point him out and describe him? Pointed to the table, is he wearing a piece of clothing? Is he wearing anything that's descriptive that you can describe for us?
White top.
Thank you. Let the record reflect that Ms. Peters has identified the defendant.
Without objection, so the record shall so reflect.
Ms. Peters, how old are you today?
85.
What did you previously do for employment?
Nurse.
Were you an LPN?
LPN.
Okay. And where did you work?
University Hospital.
Okay. Is that the University of Michigan Hospital in Ann Arbor? Okay. How long did you work there?
A total of 20 years.
Back in the summertime of 1982, so I'm going back pretty far, okay? Do you remember seeing a baby by the name of Olisa Williams?
Yes.
Okay. Who did you see the baby with? Who did you see the baby with? Who was the baby with at that time? Okay. And is that your brother Isiah? Okay. And just to make sure we're actually talking about the same person, I'm going to show you what's been marked as Exhibit 1. Is this the baby we're talking about?
Yes.
Does that look like the same baby?
Yes.
Okay. Ms. Peters, when you saw Olisa with your brother in the summer of 1982, did he ask you to watch her so he could run some errands?
No,
How did you see her then? Tell me what you remember.
he was just showing me the baby, showing me the baby.
Okay.
He was showing me the baby.
Did she seem like she was a healthy baby? Did she seem like she was a healthy baby? Do you know about how old she was? Okay. Where were you at when he showed you the baby?
At home,
At home. Where was home back then?
where I live at now.
Okay.
355 Skyville, Ann Arbor.
In Ann Arbor. Did Isiah stay for a while with the baby?
Yes.
Okay. After that time in summer of 1982, did you ever see Olisa again with your brother? Did you ever see her again at all?
No.
Okay. Have you ever asked your brother what happened to that baby?
Not really, no.
When you say not really,
It's dead.
okay, tell me why not? Why have you never asked your brother?
I was more concerned about my family.
Okay, you were worried about your own children, right? Okay. Did the defendant ever tell you about something happening to her at a park? Okay. Do you recall talking to Detective Iverson back in 2011? That would have been quite a long time ago, but okay.
I believe that's him.
Okay.
It was a long time, long.
Been about 12 years, is that correct? Okay. So would you happen to remember telling him that Isiah, your brother, told you that the baby disappeared in a park when he woke up in the car?
I didn't say that.
Okay, so you didn't say that. Ms. Peters, did you or your brother have any close relatives or family in Alabama back in 1982 or 83?
I don't have no families that I can remember that was close to me.
And nobody that you knew that was close to Isiah in Alabama either, correct?
Speculation.
If you
Well,
know.
if she knows. So,
I knew my father had relatives down there, but I was not close to them.
Do you happen to know whether Isiah was close to any of them?
No.
Okay. I don't have any other questions. Thank you, Ms. Peters. But the defense attorney might have some questions for you.
Hold on, we gotta let the other side ask you some questions. Okay, we gotta let the other side ask you some questions, okay?
I don't have any questions, Your Honor.
Okay, thank you.
Thank you, Ms. Peters.
Thank you, Ms. Peters, you may step down. All right, is this our last? Okay, ma'am, please come forward to be sworn.
Judge, real quick.
Yes.
This doesn't affect anything. The mass amount of documents that I admitted through Molly Reno that started with exhibit 26.
Yes, ma'am.
55.
Yes, ma'am.
Section, just make a note that 32 is not admitted. It was a police report that I was not admitting. I pulled it out, but I forgot.
Okay, so 32, we will not be.
Yes, it was refreshed, used to refresh the witness, but it was not in.
Okay. Okay, got it. All right.
I swear affirm the testimony about the given the truth. The whole truth.
Hold on a second, we need a defendant.
Oh, yeah.
I know, I'm ready to roll too, but we gotta have him.
Do we?
That was a good job, Ms. Woodson, objecting that your client. Well, no, that's okay, you know. Sometimes you just need to stand up and be counted, but don't worry about it.
He certainly probably does not want his presence late.
Yeah, certainly, I'm sure he does not.
Sometimes we want things a certain way, and I had peace, right, Miss Woodson? Back on the record in the case of the people of the state of Michigan versus Williams.
Now.
Raise your right hand. Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Have a seat. State your first and last name and spell it with the record.
Berna Williams Anderson, Berna, Berna, Williams, Williams, Anderson, Anderson.
Thank you, ma'am. You may be seated.
May I proceed, Your Honor?
Yes, you may.
Ms. Williams Anderson, good afternoon. Do you know somebody by the name of Isiah Williams?
Yes, I do.
Who is Mr. Williams to you? Do you see him in the courtroom?
Yes.
Can you point him out and describe something he's wearing? Okay, Your Honor, let the record reflect Ms. Williams Anderson has identified the defendant.
That objection record shall so reflect.
Ms. Williams Anderson, some of your siblings have testified about their relationship with their father. What's your relationship like with your father? Do you have one?
Not as of 2 years ago.
Before 2 years ago, did you have an okay relationship with your father?
Off and on.
Okay. What's your date of birth? Ms. Williams Anderson, did you ever witness any abuse on your mother at the hands of your dad, Isiah Williams?
Yes.
Who is your mom?
Elizabeth Priest.
Okay. And what did you witness when you lived with your mom and your dad?
Multiple beating, punches, two knockouts, just multiple beatings.
At some point, did your mom move out or move you and the children out or have your dad move out? Did she separate?
Yes.
Okay. Was there ever a time that you had to intervene in a particular assault? Okay. Can you tell us about a time that happened?
I don't remember all of it. I just remember going to the kitchen, getting a knife, just trying to get him off of her.
Do you remember if they were still together or if they were separated during this time? Okay. Did you ever see somebody by the name of Olisa Williams? Okay, let's talk about in respect to your birthday. You said your birthday was July 22nd, correct?
Yes.
Did you see Olisa anytime before your birthday in 1982? So before July 22nd, 1982. What birthday would that have been for you?
That would have been my 16th birthday.
Okay. Was that a memorable birthday for you?
Yeah.
Okay. And did you see Olisa before that big party, if you recall?
Yes, I believe.
Okay. And how is it that you saw Olisa?
My dad brought her to our house to spend the night.
Okay. And what house was this at that you were living at?
We lived on Oakville.
Okay. And what city was that?
I think it's actually called in Boston. We used to call it Carlsonville, but I think they actually know it.
Okay. And at that time, who were you living with?
My mom, Elizabeth.
Okay. Did you have any of your siblings that were at home?
Yes, Kim, Sean, and Scott. Sean is his season.
When your dad brought Olisa over to the house, was Kim there?
Yes. Yeah.
Okay. And when we're talking about Olisa, I want to make sure we're talking about the same person. I'm going to show you People's Exhibit 1. Do you recognize this picture?
Yes.
Who's that?
That's Olisa.
Do you recognize this picture for any other reason?
I think that's my computer here.
Okay. Was this picture, if you recall, taken the date that your dad brought her to the house?
I know at least one other time.
Okay. How long did your dad stay there with Olisa at the house, if you remember?
I think he just brought her over. I know he didn't stay the night.
Okay. What condition was Olisa in, if you remember, when your dad brought her over? How did she look? Okay. Did you and your sister do anything with her clothing or her hair?
I remember my sister combed her hair. She'd been over a few times, and each time she combed her hair.
Did you and your sister dress her in any different clothing, if you remember? Change her clothing?
I'm sure we did.
Okay. After this time in July of 1982, before your birthday, did you ever see Olisa Williams ever again? With or without your father, did you ever see her again? Okay. Have you ever had any conversations with your father about Olisa and where she was or what happened to her? Your father, well, let me ask this. Is there any particular reason you've not had these conversations with your dad about this baby that was missing?
I think mainly because I wanted it to be a positive outcome. So, and I'm lying. I was probably scared.
Were you scared to talk to him about it?
Yeah.
Okay.
When talking about anything, he just always says he blacks out.
Let's talk about that. You said he talks about blacking out. How long has your dad been talking about issues with blacking out?
He said that when he attacked my mom in 83, 84, that he blacked out. He didn't remember that. He said when people, I guess, asked him about Olisa, he said he blacked out in the park. He said he blacks out a lot. He doesn't.
Has your dad ever told you that he has a head injury that causes him not to have memories of himself or his life? Okay.
Somebody's planting something inside of it.
Tell me about that. What does he say about that?
He said that they're tracking him when he was sentenced to prison for my mom's attack. He was writing letters and said that he was that they put something inside of him. They were tracking him. They were following him.
You said he would write you letters. Would you also visit with him?
Yes, I did.
Would he tell you the same thing about the chip being implanted and not having any memories? Would this be in about 1989 or 1990?
Yes, because I had my first son in 89. I'll take him probably in 90.
Did your father ever tell you about a car accident that he got into maybe in 1994 that caused a head injury and memory loss? Did your father ever tell you that he was poisoned and that was the reason for a head injury and memory loss? You were interviewed by Detective Iverson back in 2014. Does that sound about right? Okay. At that time, I think you had indicated you had seen your father about 10 years prior at your brother's funeral. Does that sound right? You hadn't seen him before that? Or you hadn't seen him since before that time, correct? Okay. You began having some regular phone conversations with him right around that time of your brother's funeral. Does that sound right? Tell me about why.
When he came to my brother's funeral, he had a woman with him by the name of Helena, and they had a child. So I discovered I had another sibling. So I stayed in contact with him with that sibling. After that, they had 2 more children. And so I stayed in contact with them, would go visit them in their home in Detroit and also in Detroit.
And speaking of those children he had with Helena, she's since passed, correct? Okay. Was Helena at the time, if you know, was she the primary caregiver of those children?
Yes.
So if Isiah claims to have been the primary caregiver, would that be true? Okay. Do you assist in helping with those children now? Ms. Williams Anderson, are you aware of any close family or relatives in Alabama, either close to you or to your brother Isiah, or your father Isiah, excuse me, that would have taken Olisa? Back in the 90s, you said you lived on Oakville Waltz, correct? Was that the street?
I didn't live there in the 90s.
80s, I'm sorry. Did you live there in the 80s?
Yeah, up until 84, I went to Kansas City. I've been in Kansas City.
In about 1983, was there an incident that you recall where a shovel came up in the house that nobody knew what it was?
I'm not sure what happened, but I remember they came digging in our backyard looking for information.
Do you recall if anybody of authority, like the police, ever found anything in your backyard? Okay.
I don't have any further questions. The defense attorney might have some questions.
Thank you.
Thank you so much.
Cross-examination. Ma'am, thank you very much for your testimony. You may step down.
That'll be it for today, Judge.
All right, so, and as we're looking tomorrow, then you're looking at 2 witnesses for tomorrow?
3 witnesses, 1 should be very short. And
Okay.
2 shouldn't be that long.
All right, so 3 witnesses tomorrow, 2:00 for everybody else. And then we'll come back and do that. All right, we're gonna stand in recess. Okay, stand adjourned for the day.
At this point, the case is bound over to the 22nd Circuit Court in Washtenaw County, and it is assigned to Judge Conlon.
To some type of cash bonds, we can start to accumulate credit.
Any objection, Ms. Zenda?
No, Your Honor.
All right, I'll adjourn this 2 weeks, then that'll take us to 30th at 1:30, and I will modify the defendant's bond to be a $2,000 cash bond.
Second, Judge.
All right,
Thank you, Your Honor.
thank you.
Number 46, People versus Isiah Williams, 2355 FC.
Sorry. Let me go.
Oh.
Okay, what do we have today? Counsel, your appearances?
Good afternoon, Your Honor. Danielle Russo Bennett on behalf of the people.
Good afternoon. Good afternoon, Alex Pearson on behalf of the people.
Okay.
And good afternoon, Your Honor. Danian Woodson on behalf of Mr. Williams, who is appearing via Zoom.
All right, Mr. Williams, can you hear us?
Yes, Your Honor.
Okay, today's the date and time set for pretrial on this matter. I will just kind of on the record say that the last time we were in court, the defendant requested to represent himself. At that time, we had a brief conference with Ms. Woodson, who said she felt she had a good relationship with him, at least as far as whatever. So I don't know where that stands today. So that's a question. And then I also need to either inform the defendant or Ms. Woodson that there are some motions that have been filed, or at least the motion hearing dates. So they need to be kind of finalized. It's not, I mean, no one's arguing the motions today, but we got to finalize that. So Ms. Woodson, what's your understanding of what's happening today?
Your Honor, the court has to answer the question about whether or not the court is going to allow Mr. Williams to represent himself. He did instruct me to not respond to the motions on his behalf because he wants to represent himself. Although I do have a good relationship with Mr. Williams, I have talked to him. It's my understanding he has represented himself previously in other legal proceedings. He's very insistent on representing himself here. I understand the court may have some concerns about a layperson representing themselves, especially with these charges. So I don't mind being standby counsel. I explained to Mr. Williams that may happen, and if that happens, I'll basically be following what he wants. But, you know, because he's not a lawyer, the court may decide that a lawyer needs to be appointed in advisory capacity. But he is ready, willing, and able to represent himself. There was an issue of competency at the district court level. He did come back competent. I don't have any questions regarding his competency, so I leave it to the court to make the decision.
Okay. I don't know that you really get to weigh in on this, but I'm certainly happy to hear from you.
Judge, I do just want to raise some concerns because we did address this already at the district court levels, and I have been in court with Mr. Williams for a couple years now and have seen some really disturbing, concerning behaviors that really, to me, I would be remiss if I didn't put that on the record, that I have significant concerns about him representing himself. And being cognizant of what the Constitution is and what the case law says. We did address this with Judge Simpson, and
Mr. Williams started to exhibit some understanding and then some clear misunderstandings. And then at one point even said he didn't want to represent himself. He just didn't want his attorney anymore after he had already fired one attorney. So that really caused Judge Simpson some concern that he didn't really want to represent himself. And one of the issues we raised at the preliminary exam is, even if you get to represent yourself, there's case law, People v. Daniels, and there's a rule of evidence that says you don't get to cross-examine, you don't get to question the victims. Your attorney, your standby attorney, will get to the victims or the other acts victims. And that's where things kind of really spiraled and fell apart in district court. And then, much like Mr. Williams tends to do every time we would have a hearing in district court, when he didn't like what he was hearing, he did not like the very first witness who was testifying, the deceased's mother was testifying. He immediately became disruptive, became combative, and then demanded that he be taken in the back and got into a shouting match with Judge Simpson. And so he had to be ordered and yelled at and screamed at to sit back down. He does not listen. He has said on the record that he will object to absolutely everything. So I'm concerned that while he needs to be held to what an attorney would be held to, he's not going to. And I don't know that we'll ever effectively get through any proceedings, because I think his goal is to simply disrupt the proceedings. I think Ms. Woodson is right. He has been representing himself since the 60s on cases. That comes from his family as well, saying he gets in trouble, he picks up a new case, he represents himself. But he's never had a case of this magnitude. Say no body, 41-year-old cold case homicide. And the court saw what I filed already. We've already had an expert witness testify on this. There's a 65-page brief on the other acts. And I think that this is a really extensive, complicated case, and I'm concerned about that. And so the second day of preliminary exam, he simply refused to come out. And we had to wire up the back so that he could watch his preliminary exam, to which he appeared to sleep throughout it. And so my concern is that he does this for show, and he is going to do what he can to disrupt the proceedings, as opposed to be held accountable just like an attorney would. And I know that Ms. Woodson would be there as an advisory attorney and would be there to work with him. But I'm still concerned that what happened at preliminary exam when he was told no will continue throughout these proceedings. I think this is going to be a very lengthy trial. There are a large number of other acts witnesses that have extensive years of abuse with this man. There are many elderly witnesses in this case, and I am concerned that if he's to represent himself, he will be harassing and he will cause undue embarrassment and harassment to these witnesses. I understand what the law says. I understand what the position that the court is in. But if I don't make that record, I'm afraid that we will find ourselves months down the road dealing with the behavioral issues that we've seen with Mr. Williams.
And, I appreciate that. I can't really prejudge him in the sense that he hasn't behaved that way in front of me. So to the extent, Mr. Williams, is it your request today that that you represent yourself in this and until further order of the court?
Yes, Your Honor. I
Okay.
would love to take and stand forth. The Holy Spirit has invited me to stand. I am a spiritual individual, and I believe to be obedient unto the Word of God.
So let me interrupt you, because there's some things that I have to put on the record regarding this. So the authority for the court to allow you to represent yourself in a felony criminal matter comes from MCR 6.005 subsection D. So I have to ask you some questions. First of all, you understand the maximum penalty for the charged offense, which is homicide, open murder, is life imprisonment. You understand that?
I'm fully aware of that, Your Honor.
Right? And that there additionally would be DNA identification profiling samples taken. Understand that?
I don't understand what that last part you said. That
It means that they're going to take some DNA samples from you.
Oh, they did that already,
future cross-checking. So that's another penalty according to the maximum on the charge. Do you understand that?
Yes, they taken the DNA sample of me, but they didn't take one of the biological father.
Okay. Sir, self-representation is almost always unwise, and you may conduct a defense ultimately that's going to harm you, that's to your detriment. You understand that I'm advising you that this is not a good idea.
I understand, Your Honor, and I'm willing to allow the court to take and bring forth anything that they feel is necessary within this matter. I don't have any qualms with it.
All right. You're entitled to and will receive no special indulgence by me. You got to follow all the technical rules of substantive law, procedure, and evidence in the making of motions, objections, the presentation of evidence, voir dire, and argument. So I want to be clear that the same rules that govern an attorney will govern and control and restrict you. So you're going to have to abide by all the same rules that all the lawyers in this room took years to learn. So you understand that, correct?
Yes, Your Honor, I truly do.
Okay, you're going to receive no more library privileges than those available to any other unrepresented party, meaning that you don't get extra time for preparation, you don't get any staff or investigators at your disposal. That comes from a case in Michigan under People v. Blunt, 189 Mishap 643, 1991. So I'm just kind of reaffirming that you're under the same obligations that the lawyers are. And because you don't have a lawyer, you don't get more time, or I don't waive, the requirements for you. Do you understand that?
Yes, I will though, would I be able to use the library at the Washington County Jail?
You get to use the library as you're available to use it, but you don't get to just say, hey, I'm representing myself and I'm going to go to the library 24 hours a day.
Oh.
Whatever your restrictions are in using the library, they remain the same. You can use it when you can use it, but you can't use it extra because you're representing yourself.
I fully understand. Thank you, Your Honor.
All right. The prosecutor is an experienced professional attorney. There are actually two of them who will give you no break or quarter because you don't have the same skills or experience. In other words, they're not going to take it easy on you because you're not a licensed attorney. Do you understand that?
Yes, Your Honor.
All right. And if you can't afford to hire your own attorney, I will represent someone else to represent you. If you can hire an attorney, I'd give you some time to do that. Do you want me to give you a little bit of time to find another lawyer, or do you want me to appoint somebody else, or do you want to represent yourself?
I would love to take and represent myself. As far as an attorney, employing my own attorney, I would ask that the court would order that they would release my $10,000 check to me that they withheld on October the 12th, that they've been had in their custody, and they claim they don't have my money in seed, but my $10,000 check have not showed up. And
well, I personally don't have that check, so I don't know what you're talking about, but I can't order anything like that. But what I can tell you is that I will grant your request and I will allow you to represent yourself. I am going to keep Ms. Woodson as your standby counsel. I know she's explained that to you. So she's going to give you some insight and advice and help you. She's going to be present during the proceedings if you need her and you need her to speak on your behalf. And as you heard the prosecutor say, you cannot cross-examine victims or certain types of witnesses in this case. So she will have to step in on some of those occasions. So you understand that?
I would definitely do not want, you understand, Ms. Wilson to work and on my behalf in no shape, no form, because I've already decided to take and file a suit against her in the court, a motion for illegal, you understand, attorney, as you understand, illegal, inadequate. And so I don't really want her.
I don't necessarily agree on any inadequacy, so I'm not going to go into that right now. Is there a conflict with the public defender in this case?
He had the public defender. He fired Mr. Feaster when we first started this case. This is his second appointed attorney.
Okay, I didn't know which order, but I'm not the first attorney of record here.
I knew that.
Yeah, the public. There was no conflict, but he. I'm not sure what existed or what happened. But once he fired Mr. Feaster, Ms. Woodson was appointed after that.
And I think there was some months or almost a year before.
I did not hire her.
Let's not have this go sideways this early in our relationship. You are allowed to represent yourself, but you must have a lawyer who is what's called standby counsel. Ms. Woodson explained to me that she explained that to you, and the prosecutor also put on the record that there are certain things that you may not do. So you have to have a lawyer representing you. So I'm either going to appoint Ms. Woodson as your standby counsel. B, I'm going to go back to the public defender. I don't know why I allowed them to withdraw, but it wasn't because of a conflict. So I'm going to appoint the public defender to be your standby counsel. You have to have that. So if that's not acceptable to you, then we're going on to the next stage of how this is going to go. So it's your choice right now. Do you want Ms. Woodson to be your standby counsel, or do you want the public defender to be?
No, I do not want Ms. Wilson no way in my behalf, because I find her to be incompetent.
Well, that is okay. I don't, but okay. You don't need to go any further. I will allow her with, I'm appointing the public defender to represent you in the standby concept. Okay? That's what you're asking me to do, right?
You are saying that you would take and go to the public defender and find a standby counsel on my behalf. Is that correct?
Yep, I'm appointing public defender to be your standby counsel, and the public defender's office will assign an attorney to this. You don't get to pick it. So I'm telling you that. So it's your choice. Ms. Woodson or public defender, your call. What do you want?
Go with since I have no other courts, because I can't deal with Mrs. Wilson. I would definitely have to go with the public defender, because she
Enough said. Enough said. Enough said. I will appoint the Washtenaw County Public Defender to be your standby counsel. So
much, Your Honor.
I don't know if that's Ms. Wilson or Ms. Woodson.
Ms. Woodson.
All right, so Ms. Woodson, I am going to.
But if his lawsuit is Ms. Wilson.
Right, I'm gonna order Rawl as his attorney of record, as well as not obligate you to be standby counsel in this matter. I am appointing Washtenaw County Public Defender, the standby counsel. Mr. Williams, let me offer you something else. At each proceeding, I'm going to ask you questions about whether you want to continue to represent yourself. If you do, then the answer is yes, and I'm going to keep reminding you that, you know, it's not a good idea and that you should have a lawyer. But if you continue to say yes and we don't have difficulties with your behavior, then I'm going to allow you to continue to represent yourself with the standby counsel. But I'm going to ask you at each hearing how that's going to go. But because you are currently representing yourself, I am going to require that, well, let me ask you, Ms. Woodson, before you leave today, have you had a chance to share with him the motions that have been filed?
I told him about them, but I have not been able to print it out and physically bring it to him.
All right, so I'm going to ask you before you are discharged to deliver a set of all pending motions to Mr. Williams. So, Mr. Williams, Ms. Woodson or Wilson's final act in your case, she's going to deliver all the papers that are pending. So the prosecutors in this case have filed some motions. I am requiring that you file your answers to those motions on or before September 6th. So that's approximately 3 weeks or so from today's date. And I'm going to order that the prosecutors may schedule those motion hearings anytime, a Wednesday, actually after the 6th, because I need them. So he has until the 6th to file his responses. You can file for the first available or whenever you'd like to schedule them after the 6th of September.
Should I wait until after Mr. Williams files his response? Okay. I will be in trial for 2 weeks in September in front of Judge Slay. So
literally file them whenever you want them heard, but your order is to file your responses by September 6th, 2023. All right?
Your Honor, should I forward a copy to the defender's office?
Yes, please.
Okay.
Yep.
I'll do that.
All right. Your Honor, will you also please ask if the prosecutor office will finally provide me with a motion for discovery that's been over a year that has been filed for a copy of the full.
If you have filed a motion, you need to file a motion for me to do it. This is what I mean. You don't get just to blurt out requests. you are held to the same standard. So if the prosecutor is not doing something they're supposed to do, you need to file a motion and schedule it for hearing, and I will absolutely hear what you have to say. But I also have the right to read everything before we come to court so that I know what you're talking about and I know what they're talking about. So if you want me to consider that, you got to file it, notice it, send them a copy, and we'll be prepared because she'll file a response.
Thank
Okay?
you. Thank you.
Okay. So there's no court hearing pending at this point until you file your notices for those hearings, but you're going to get those motions and you got to file your responses before September 6th. Okay?
Awesome. Now.
All right.
Also, would there
Thank
be
you.
a chance for your court to determine if gotten a bond, as I've not been able to provide a bond since my incarceration?
Right, same deal. You got to file a motion, they get to respond to it, and I will consider it. But we don't just have a conversation when you're on Zoom. I have no idea what you're saying, what you're talking about. I'm not Judge Simpson. I wasn't in those hearings. I have no idea. So you don't get to just ask me to do stuff from the jail. You file your paperwork, and I will absolutely give you the respect you're due, but I have to know what you're talking about. I can't just do stuff sitting here.
Oh, I stand,
All right.
understand, Your Honor.
All right, so you can file what you need to, and I will be happy to hear it, okay?
Thank you.
All right. Thank you. That concludes the hearing.
Thank you, Your Honor.
You have a blessed day, and the peace of God be with you and your family.
Well, I guess what I'll do is I'm going to adjourn the pretrial without a date right now. When you file your motion hearing, when we get a date from the prosecutor, that will be our next pretrial date, and we'll see what we need to do next. Okay?
Thank you, Judge.
Thank you.
Thank you. Have a great day, everyone.
Yes, thank you.
Oh my God.
And last but not least, all right.
I have video from the next hearing, and Mr. Williams is sitting there patiently waiting his turn. It goes on for 20, 30 minutes with him sitting there, and then everything ends. So I'm not sure if they purposefully took his hearing offline or if I just wasn't able to capture the entire hearing. It's hard to know this far after the fact. It's unfortunate that they delete videos, but he was there was a hearing, and doesn't look like much fruitful came from it. Unfortunately, I also don't have video of the 12-6 hearing. I have Mr. Williams sitting there along with Ibrahim, which is so interesting when people name their kids the same thing. Sorry, squirrel. And when it gets to his case, it ends. So I'm not really sure what the point of that is. But now we're going to fast forward to the 12-13 hearing, which is a week later. And as you can see, Mr. Williams sits and speaks to someone in the jail for an extended period of time. I would say it is over an hour, while other people have their hearings. Everything goes on as normal. But then I guess he decides he's bored and doesn't want to keep waiting, because the next thing you know, he is in his cell climbing into bed, getting all cozy. Yeah. This dude's a peach. Like, I guess that's a sign of a real sociopath, is that there is zero empathy for what they are putting the victim through in this process. There is zero remorse for what they did, and they are going to be as difficult and uncooperative as possible because they don't care what they're doing to everybody else. I mean, I could be wrong. I don't have a psych degree. I'm not trying to psychoanalyze anybody, but I think the lack of empathy is pretty obvious. He has tortured this woman for, 40 years now? 30, 40 years. And he's going to keep on doing it at every turn. Like, that's pure evil, in my opinion, of course.
How's your day going, Mr. Feaster?
It's going all right, Judge. It's
About to be getting exponentially better or worse, depending on how you.
Yeah. Hopefully better.
Well, again, depends.
Yes.
Mine's not
All
getting
right.
any better. I don't know if anyone cares about that.
All right, so we are here today on a pretrial. I am going to put a few things on the record for the record. All right. We are here today for a pretrial, and I am issuing a ruling on Mr. Williams' continued self-representation. On August 16th, 2023, I allowed your court-appointed counsel to withdraw after I was satisfied that under the law, you made an unequivocal request to represent yourself, Mr. Williams. Moreover, I explained to you the dangers and the disadvantages of self-representation. At the time, you stated you understood, sir. Since this matter has been bound over, the following disruptions have occurred. On May 31st, 2023, you refused to participate in the pretrial hearing. You have filed motions without properly serving the Attorney General's office. The motions often contain nonsensical statements and difficult matters to distill from me, from the court, what arguments are being advanced, some made with outrageous requests. In a motion in limine filed with the court, for instance, you write, quote, all kinds of animal, birds, reptiles, and sea creatures have been tamed by mankind, but no human being can tame the tongue. It is a rest evil full of deadly poison, more deadly than poison that was given to defendants in 1995 that needed the help of the ABA fathers by his graces and Jesus' mercy. That defendants came back from its coma states, end quote. You demand there is a pretrial ruling on, quote, each and every evidence with no legal authority or cogent analysis. Your motions have either been improperly served or improperly noticed. This is just one snippet from one of the motions you filed. I have previously warned you that this type of conduct would not be tolerated. You refused to participate in the pretrial hearing on December 6th, 2023, and by my observation, you are refusing to participate in the pretrial hearing as of today's date. Sir, there is no absolute right to represent yourself. Under Michigan and U.S. Constitution, your self-representation cannot disrupt, unduly inconvenience, and burden the court in the administration of the court's business. I am convinced on the record before me that you have every intention to seriously obstruct these proceedings. Therefore, you have forfeited your right to represent yourself, which this court does not take lightly, as you have the right to act as your own counsel, but I have a duty to see that criminal adjudications proceed in an orderly fashion and result in trustworthy convictions. This time, I am ordering and ruling that the defendant has forfeited his right to represent himself based on his obstructionist behavior. His objective is to insert as much chaos into these proceedings as possible. At this time, I am appointing the Washtenaw County Public Defender to represent you in this matter until further order of the court. I will issue an order to that effect, but that is the current state of things. I'm just going to say at this point, Mr. Feaster, I don't know if you have any thoughts of motions to file, but I'm thinking I'm just going to give you a trial date.
That's fine, Judge. I guess my question is, Mr. Williams, when I met with him briefly last week, has indicated he does not want to work with me and that he is filing a lawsuit against me for something.
But your office.
Yes, Judge.
Well, look, we happen to have him as really sitting right here. Perfect.
So
this time I'm going to appoint the Washtenaw County Public Defender to represent you. I'm not saying it has to be Mr. Feaster, and just because you're assigned to this courtroom. I'm also not condoning or saying that his threat to file a lawsuit against you isn't another tactic under this same vein. So to some extent, to the extent that a record needs to be made about your quality representation in this matter, I'm also fine with that. So let me ask the Attorney General's in this matter, the Attorney General's office, are you okay with me giving you a trial date and a final pretrial date?
I'm fine with getting both of those, Judge. And I'm also absolutely fine with Mr. Feaster going on to represent Mr. Williams. I can work very collegially with Mr. Feaster. I do want to bring up, and I don't know if Mr. Feaster has a concern about it, but he did fire Mr. Feaster at district court in front of Judge Simpson. I don't know if that's a concern going forward or not. I'll leave that to him. But I don't have a problem setting dates.
Is again, at this point, if he's fired Mr. Feaster, he fired the Washtenaw County Public Defender. He also fired Ms. Woodson, who is his court-appointed attorney. Sure. We're not going to just keep going down the roster of court-appointed attorneys. I'm appointing the public defender to represent him. I'm confident that Mr. Feaster would do an excellent job. I'm also confident that Ms. Akiriak and Ruli will do an excellent job. So so based on the fact that I asked him whether he could hear me, that he is laying on the video right now with the covers over his head. I don't know if he wants to participate or not, but I'm moving, this ship has left the dock. So we are going to proceed at this time. So what I'm going to do is give you a final pretrial date in early February. And I'm going to give you a jury trial date in mid-February.
Judge, I am in trial in mid-February already.
Well, okay. I'm not
Genesee
saying
County.
I haven't given you the date yet, but
Okay.
when I give you a date, you tell me if it works, and if it doesn't, it's fine.
Sounds good.
So February 7th for final pretrial, okay?
That's fine.
That's at 1:30. And again, let me just stress to the Attorney General's office, it's not that I object to you appearing via Zoom, but if it's going to be resolved in any miraculous fashion, I'd rather have you here in person.
Absolutely.
But I understand that, if it's simply going to be proceed to trial, then I'm going to let you appear by Zoom, okay?
Thank you, Judge.
So remind me of that when I freak out that you're not here, okay?
I will, Judge.
But then, all right, so what's a good week in February, mid to late February, that you could do the jury trial?
Judge, I start a jury trial in Genesee County on the 13th, and it is a 2-week trial at least. So it's going to go the week of the 13th, and then it's going to go the week of the 19th as well. Possibly spilling over into the 26th. I'm hoping it doesn't, but it might. So I could be available in March, however.
Okay, how about early March?
Judge, I do note that my OIC is out of the state on the week of the 11th. And the only reason I say that is I anticipate this might be a 2-week trial. I think it's going to be a lengthy trial. So I just want to make sure we have enough time spent and that I have all my appropriate witnesses.
How about this? Final pretrial in this matter is Wednesday, February 7th at 1:30 p.m. Jury trial in this matter will be Monday, March 18th at 8:30 a.m. for jury selection. I don't have any other trials right now scheduled that date, so that's not going to be today because of trial. So we can count on that as a date that it's going to go. Okay.
I missed the date, Judge. You were breaking up. My apologies.
It's the 18th, March 18th.
Yep. If we
So
can.
that's a Monday morning, 8:30 a.m. jury selection.
That works, Judge.
Does that also work for your counterpart? We good there?
Ms. Peterson, are you available to start picking a jury on the 18th of March?
Yes, that works for me. Thank you.
All right, Ms. Akiriak and Rulli, let's just go down the list. Is it okay with you?
1 second, Your Honor.
Or, theoretically, you, Mr. Feaster, or
March
somebody in your
18th.
office?
Well, someone in office could cover. I'm
Right. I'm not getting into the inner workings of your office. We're gonna go with the 18th of March. So let me ask you, Mr. Williams, did you hear all that? The record should reflect that the defendant has an iPad broadcasting device in his cell. He is laying on the bunk with the covers up over his head. And I'm just gonna call that, as of today's date, another failure to participate, another reason why it is not appropriate that this defendant represent himself. So we'll see you all back here on February 7th. Okay?
Thank you, Judge, for your time. Appreciate it.
Thank you.
Thank you.
I don't know that we're going.
Actually, his name's Cooper, but it's like, I met with both of them yesterday, so.
I don't. Ms. Krejcir, are we going on the record in Williams?
If you would like to, Your Honor, that's fine. It's up to the court. If he's,
Would the Attorney General's leave?
yes,
Yeah, I think you have a date from Ms. Roberts, right? You get a motion hearing date?
yes, we got both those
So I
days.
think we're okay. I don't think we can go on the record if they're not.
Okay. Unless we want to explain to Mr. Williams what went on. I don't know if he's there.
Mr. Williams, we have a new date for your next hearing. So we're not going to go on the record today, but Ms. Krejcir will be out to explain to you kind of the next steps, okay?
Yeah.
Okay.
Yeah, we had a conference in chambers about, we have a new trial date. Okay,
Thank you, Your Honor.
thank you. I know they're on Zoom, so I know that didn't freak you out.
Washtenaw County Trial Court is now in session. The Honorable Patrick J. Callen Jr. presiding.
Good morning.
Good morning, Judge. Danielle Russo Bennett on behalf of the people.
Good morning, Your Honor.
Versus
Alex Peterson.
Go ahead.
Sorry, Alex Peterson on behalf of the people.
People versus Isiah Williams, 23265 FC.
Ms. Kracher, go ahead.
Good morning, Your Honor. Marcia Kracher on behalf of Mr. Williams. Mr. Williams, can you please state your name, sir?
I don't know who I am. So I guess you can ask the state police who has who I am.
I didn't quite hear that. Are you Isiah Williams, sir?
I don't know who I am.
Okay. Well, we'll go ahead under the assumption that you are the correct person. So your attorney is here, the attorney for the Attorney General, the people are here. So this is two things. One is there was an opportunity, Mr. Williams, you filed your own motion. We'll call it a 404B motion before Ms. Kracher was appointed to you, and that motion was denied. But I gave Ms. Kracher an opportunity to put on the record her spin, take, legally supported analysis, argument on the record. And so I've had a chance to review that and the people's response, as well as I believe there's also the, we have a motion eliminate submitted by the defendant as well. So I think those are the two things up to date, correct?
Your Honor, there's one more issue. That's not a motion, but the last time we were in court, the people referenced a supplemental police report that was being prepared by Detective Rugo from AAPD. And I guess we can address that at when I guess.
Well, let's get through the motions and then we'll address whatever next steps there might be. Okay?
Where would the court like to begin?
Well, I've had a chance to review everything, so I'm happy to hear any highlights. Why don't we go ahead, Ms. Kracher, why don't you add to what your client filed as relates to the prior 404B motion, and then we'll go from there. Okay? Okay.
Thank you, Your Honor. Your Honor, the people have asked to have evidence of other acts be admissible under 768.2B, 404B, and the doctrine of chances. I think in my brief, the court needs to make an analysis of which rules of evidence or statute apply. I'm arguing that the statute does not apply in its entirety because I've attached some legislative history indicating that 768.27B should apply to prior acts of the charged offense, prior acts before the charged offense. This offense was charged, the alleged offense occurred in July of 1982. The majority, and both myself and the people have listed out all of the acts that the people want to admit. The majority of them occurred after July of 1982, if not decades after 1982. I therefore do not believe the statute applies to those. If the statute does apply to those, then the analysis goes to MRE 403. And basically my argument would be that all of these acts are highly prejudicial and the probative value are outweighed by the prejudice of these acts. Most of them are not relevant because they occurred decades later. The court can obviously see that if these other acts evidence are allowed in, that clearly it's highly prejudicial, especially in light of the facts of this case where there's no direct evidence of a crime even occurring. All of this is circumstantial. And so this would be highly prejudicial to the defendant because there is no direct evidence supporting the charge. The interesting issue that I researched and finding is that the statute trumps rules of evidence. And again, so if the court feels the statute does not apply, then the people's argument would be under 404B, they could come in. Well, I would argue that they shouldn't be allowed under 404B because they're clearly there to show for propensity, nothing more. They would, that would actually, that's all that they're being offered for. I can get specific with each and every act. I think I counted them up. There is 10 to 12 other acts of evidence that the court wants to bring in through various witnesses. And again, the analysis really should be, does the statute apply? If it does, then the court needs to make the analysis under 404(3). If the court feels the statute doesn't apply, then 404B does come in. I would also argue under the statute that there's an issue with time here, applying the statutes to the acts that occurred after the alleged charge offense date.
Okay. Thank you. I mean, do you want to go ahead and put on the record then your argument regarding the motion in limine? I mean, it's somewhat related, or do you want to do that separately?
Well, no, you know, the court makes a good point. It is somewhat related. And and that's a good point. So there's, in one of the other acts evidence, specifically during the testimony offered at exam, that my client made a statement that he killed a baby. And that was allegedly made when during one of the acts that occurred. I haven't argued the corpus delicti rule since law school. But the corpus delicti rules states that absent some showing of criminal agency, that statement cannot come in. And I'm going to quote, it's long been a rule that proof of corpus delicti is required before prosecution is allowed to introduce the inculpatory statements of the accused. That's People v. Williams, 422-MISH.381, and People v. Allen, 390-MISH.383. So there is no direct evidence of criminal agency to this defendant, to Olisa Williams. Moreover, all of the evidence that was brought in through testimony and preliminary exam shows differently. That when the baby was last seen with Mr. Williams, the baby was in a fine condition, and there was no signs of abuse or neglect. And in fact, one of the witnesses, I believe Miss Peters, Betty Peters, she's actually, at the time of when she saw the child, she was a registered or a licensed practical nurse at University of Michigan Hospital. So I don't see there's enough of a connection between the criminality or a proof of criminality and this offense. I mean, they drudged the Huron River. They looked at a house. There's no evidence that Olisa Williams was murdered at all. It's all circumstantial. And based on that, I don't think that the prosecution has met their burden to show criminal agency enough to allow that statement to come in, Your Honor.
Okay, thank you. So I've had a chance to review, obviously, the original motion filed by the people. Ms. Bennett and Ms. Peterson, you are welcome to supplement anything in light of Ms. Kracher's argument regarding the statute or the rule of evidence to apply. And then if you want to respond any further than what you've submitted in writing to her motion in limine, I'm happy to hear that. So either or both of you, go ahead.
Judge, just briefly, because I know that as far as my other acts, notice in brief, it was very extensive, very lengthy. I only want to address a couple things being said in the objection specifically, and not in just everything that's being said today. Nothing was submitted by the defendant that actually tells us that the legislature intended for acts prior to the statute to not still be determined as other acts of domestic violence. There's nothing in the legislative intent, nothing in the bill submitted that says it's not retroactive or doesn't go back to prior acts. So the statute does apply. These are all acts of domestic violence. They can come in for propensity, but in case the court didn't believe the statute applied, we laid out extensive other proper purposes, motive, intent, etc., that lack of accident, lack of mistake, that could be used under 404B. But we submit the statute is the proper admissible avenue for this evidence coming in. This is not all decades later. I laid out in my response, or rather in my brief, we're talking about a 1982 alleged murder, and we're talking about 1980s assaults on the mother of the child. We're talking about post-murder assaults on the mother of the child in 82 and 83, 1970s assault on a witness, a material witness, an 84 assault, and on and on. The oldest of the assaults, because most of the other ones are in the 1990s, the oldest of the other assaults on an ex-wife and a child is 2018. But counsel conveniently ignores the interest of justice argument that these come in. We're talking about the allegations that he killed his child and that he put his hands on his child in 2018, that in 1970 he put his hands on his child of a similar age to Olisa Williams. So interest of justice does apply here. And so I won't go too much further, except that it's got to be unfairly prejudicial, and it's got to substantially outweigh the probative value. And in all my years, I've never had a textbook case that is more proper for what the reasoning is behind these other act statutes than the probative value of this case. I submitted People v. Anderson because I talked a lot in my brief about how these are technically other acts, but they're so intrinsically tied into the case in chief, the relationship between the material witnesses in this case, why they do certain things, why they don't tell the police certain things, why they're scared to this day. And so going directly from that argument to the argument on the motion in limine, let's talk about Mary Leslie Bryant. Why is her statement so compelling? Why would the defendant out of nowhere say, I killed a baby? Don't you know I killed a baby and I could kill you too? Other than the fact that he is allegedly strangling her at the time, he is meaning the statement to say, this is Olisa I'm talking about, and I will do the same to you or your grandchildren. So the nature of the other acts are so intrinsically tied into his alleged admission to what he did in this case. Luckily for the people, Ms. Krasher keeps saying, well, there's no direct evidence. There's no direct evidence. Luckily, all I need is circumstantial evidence, and I can prove the case by that. That's what the jury instruction says. And so, you know, she keeps indicating corpus delicti, and there's not sufficient evidence. There's a reason in my response to her motion in limine that I kind of went maybe over the top in the detail of the evidence presented at the exam, because Ms. Krasher gave you fractions of things that witnesses said, portions of things that were testified to. And when we're talking about corpus delicti, we're talking about collectively everything that gave us that corpus delicti. If Ms. Krasher's argument is correct and that we haven't met a corpus delicti, that Olisa Williams died at the hands of Isiah Williams, this court would have granted her motion to quash, and it did not. There was no abuse of discretion in the bind over. The evidence was properly considered. And so there is no, and counsel keeps saying there's no signs of abuse. There's another reason I outlined that that's not accurate. You first of all don't need abuse on a victim of homicide before the homicide happens, obviously, that goes without saying. But there was plenty of testimony about abuse and neglect of this child, including abuse on the mother while she was pregnant, the kidnapping of the baby, the confinement of the baby, multiple witnesses saying the baby was dirty and wet and not properly being cared for, had no car seat. The defendant's statement that he was getting high with the baby in the car, fell asleep, and the baby was abducted, and he simply never told law enforcement about that. And so collectively in that regard, you do have signs of abuse and neglect. You don't need it, but you have it. So I wanted to clarify as to that. The one additional point that I will point out is that throughout the motion in limine, there's this reference to speculation or merely conjecture under the Orsi case. If the court recalls, counsel cited that case when she objected or when she wanted the additional jury instructions. But this is a proper party opponent admission under 801D2. If we're talking about how this is, maybe the reference was it's speculative as far as referring to Olisa Williams in general. Well, we're talking about a little over 10 years after he's alleged to kill this baby. No other baby has disappeared in his care. He's not alleged to have killed any other baby. He is talking about Olisa Williams. Mary Leslie Bryant might not know that because she didn't know he had a child that disappeared. But he is referring to the one child that disappeared in his care 42 years ago. He is meaning that to threaten Mary, to get her to comply, get her to stay in line. And so that really ties in, like the court pointed out, to the other act's evidence. I would ask at this time that the court continue its prior ruling that the other act's evidence is admissible in its entirety under the statute. And I'd also ask that Your Honor deny counsel's motion in limine specific to these statements he allegedly made.
May I have a brief response, Your Honor?
Yep, sure.
Okay. So first of all, I would like to respond to the interest of justice. This exception should be narrowly construed, and I cite People v. Rosa 322 Mishap 726. This is that's my response. The interest of justice is that it's to be narrowly construed. It's not to be a open season gate to allow everything in. As far as learned sister counsel talking about, my client's referring to Olisa Williams when he said allegedly said I killed a baby. We don't know that. We don't know if he's being truthful, not truthful. That's purely speculation on what he meant by that. And that's the purpose of the corpus delicti. Without something to support it, that is purely leads into the juries to speculate to what was going on and to be led down the path to the conviction through prejudicial evidence being allowed in, Your Honor. If the court is, I would also ask the court, if the court is not going to deny, or excuse me, if the court is not going to grant all of my requests, I would definitely ask the court to review the specific acts evidence that are referenced in each of our briefs and decide on an independent basis if some should be stricken or not let in. I don't think that the jury instruction is enough to ensure that my client will not be unduly prejudiced by this mountain of evidence being let in that don't really relate to Olisa Williams and relate after the alleged incident occurred, Your Honor, in July of '82. Thank you.
Okay. So you are interestingly all pointing out, I think, kind of the overarching summary of this case in that it's a bit of a balancing act, probative versus prejudicial. You know, is this statutory or rule of evidence based? Is the time frame, a bar, or is it allowed under a narrowly construed exception? I mean, all of this case, and as you've pointed out, Ms. Gracher, repeatedly and appropriately, as has Ms. Russo-Bennett, that this case is circumstantial, and there's a heaping amount of jury instructions that go along with that. So my job, I believe, at this point is really to level the playing field and to allow the trier of fact in this case to make its decision. So in looking at all of these requests, both the historic ones and these two that are up for today, one of them is from history. Ms. Gracher's, I appreciate your artful argument and I appreciate your participation in this case. But again, kind of your take on this versus your unrepresented client's take. So I'm thankful for that. But it does sort of call into question what the court does as far as these preliminary matters. So that said, I've reviewed everything. I've listened to your argument. So as to the people's request to admit other acts pursuant to MCL 768.27B, MRE 404B, and the doctrine of chances, I am maintaining, or I am again granting that that request. My analysis is fairly limited. I believe I only need to analyze this under the statute 768.27B. In preparation for this secondary ruling on this, again, I went back and, as I had previously, reviewed the preliminary examination transcript. From that, specifically Elizabeth Reese, Kimberly Webb, Mary Leslie Bryant, Dana Denard, Myrtle Helena Ayers, Javon Williams, Verna Williams Anderson, Scotty Williams, they are all permitted to testify. MCL 7.6827B states in part, and I'll read what I believe are the relevant parts, except as provided in subsection 4 in a criminal action in which the defendant is accused of an offense involving domestic violence or sexual assault, evidence of the defendant's commission of other acts of domestic violence or sexual assault is admissible for any purpose for which it is relevant if it is not otherwise excluded under the Michigan Rule of Evidence 403. Subsection 4 states evidence of an act occurring more than 10 years before the charged offense is inadmissible under this section unless the court determines that one or more of the following apply. And the court does determine that subsection D does apply, admitting the evidence is in the interest of justice. This case, in my read of it, is all about domestic violence. This is exactly what this is. And so I am going to allow the evidence of those prior acts to come in. The case is a circumstantial case that revolves around domestic violence, and the testimony from witnesses listed by the prosecutor is relevant to prove the elements of the charges. Based on that, I believe the analysis under 404B is not necessary because other acts are primarily admissible under the statute 768.27B. As to the motion in limine to preclude defendant's own statement that, quote, I killed a baby, I am denying that as well. I don't believe that that statement is hearsay. I believe it is an admission by a party opponent under MRE 801D2. It certainly will be the jury's responsibility to consider and weigh this evidence. I don't find that the statement that he killed a baby is uncertain, speculative, or conjecture. How the jury takes that is up to the jury's review of evidence, circumstantial or whatever argument the court, the lawyers are going to offer to assist the jury in evaluating that evidence. That's how the jury is going to determine the weight of that and whether it's relevant or whether it is probative or not. But I do believe it is admissible and potentially could corroborate the circumstantial evidence in this case. So I think that is a ruling on both matters. One is the prior motion or the request to admit under 404B, and then the defendant's motion in limine for today. So I will look for an order to follow on those two matters. Ms. Kracher, remind me, what's the follow-up on the police report? I didn't go back and look at anything. So tell me what we need to do with that.
Well, it's on March 13th at our last hearing, Ms. Bennett.
I know there was the question of whether it was going to be produced or when it was going to be produced. So I guess just tell me what your update is, and I think I said we'll figure it out then. So let's go.
Long story short, I don't have a supplemental report.
Okay.
I've been given on March 19th. I have been given a police report and a listing of some cases regarding, and I'm not Miss Keisha Plage, but I have not been given a full supplemental police report by Ann Arbor Detective Rougeau. And I'm concerned about that, Judge, because I don't know what that supplemental report's going to tell me. Or if it's going to give me an opportunity to do some investigation. I just don't know. And in fairness, I am either asking for an adjournment of the final pretrial to come back in a couple of weeks to see where we're at with that, because I don't know what it's going to tell me.
Your
Okay,
Honor?
any updates, Ms. Russo-Bennett?
Yes, as the supplement is going to refer, and I've told Ms. Kreischer this, specifically to follow up on a witness, Keisha Plage. She is, for the court's reference, someone who came forward 14 years ago. She is someone with documented mental health issues who thought she might be Olisa. She is someone who was born 6 years after Olisa Williams. We are awaiting a certified birth record as to that. Any follow-up that Detective Rougeau's done, including talking to this woman's family, interviewing the father of her children, things like that, he is documenting to put in one supplemental report. He did not want to piecemeal it report by report. He wanted to document his follow-up entirely in one report. I can ask him to have what he has done now done within the next week, so Ms. Kreischer doesn't have to wait any further. But as he was giving me independent pieces of evidence that wasn't the report, I've been forwarding those on immediately to Ms. Kreischer. That is what his supplemental report refers to, this one witness. I don't see how this would delay our trial in any way. And so that is outstanding, and I will make sure that we have that immediately. I was asked about outstanding discovery at the last hearing, if the court wants me just to reference a couple pieces that I'm still waiting on, so Ms. Kreischer knows. We are awaiting a summary and CV from Dr. Olisa Wilson. She's the medical examiner for Washtenaw County. I was expecting it a month ago, Judge. She indicates to me she apologizes and she'll have that next week. We have the updated death certificate that was completed by Vital Records on March 14th and mailed out on March 15th, and it takes 7 to 10 business days to come. So we should have that updated death certificate any day. As soon as I have that, Ms. Kreischer will have that. The only other thing that I can see is outstanding is some pictures of Island Park in Ann Arbor. I'm going to have my agent take some photos of those. Those will go to Ms. Kreischer as soon as we have those. That is the only things that are outstanding at this point as we head into this May 6th trial date.
So today's the date and time for the quote final pretrial. So I think I gave you your jury instruction order last hearing, but I guess I'm happy to do another final pretrial check-in. If you want, we can do it all on Zoom again to not inconvenience you. We have a trial date. Absent some huge disruption, we're not adjourning the trial again. So I guess I'm kind of on board with the prosecutor in this case supplementing whatever she has to get to you, Ms. Kreischer, as soon as she has it or they have it. But if you want to do a final pretrial mid-April, we can do that just to check in, and I won't make any of you come down here in person.
Okay.
So
okay, that'll be fine, Your Honor. Your Honor, could you give us a bench conference with you, please, and the AGs?
I don't know. Can I do? I don't. All right. Yes. Hold on.
Yeah, thank you. Okay.
I haven't done anything totally by Zoom in so long. I kind of forget actually.
Okay. Thank you.
Back on the record is People versus Isiah Williams, 23-265 FC.
All right. So we are back on the record. Record should reflect a bench conference with counsel for the defendant as well as counsel for the people. Part of the discussion was to kind of lay out the kind of future possibilities. We have a firm trial date of May 6, 2024. In the bench conference, Ms. Kreischer referenced a question about competency, so I offered to give her the opportunity. If she wanted to make an oral motion today, she's welcome to do so. So go ahead, Ms. Kreischer.
Good afternoon, Your Honor. Thank you again for the bench conference. Your Honor, briefly, I've had meetings with my client. Procedurally, I believe that the last order of competency was an independent medical evaluation done approximately, had to be March of 2023 prior to the preliminary exam, somewhere around there. It was an independent exam. I don't know if that order or that evaluation is fresh. It's my understanding, and speaking to my client, that competency evaluation is merited to ensure that my client understands all of the procedures that are going on, especially when it gets into any kind of negotiations with plea and these evidentiary issues that we've been arguing about. It's my knowledge and belief that in speaking to my client, that while he understands that what he's barely understands what he's being charged with and why, that beyond that, he is having difficulty understanding and relating the facts and the evidentiary issues together. So therefore, I'd be requesting the court allow me to get an independent medical evaluation.
Okay. All right. So Ms. Russo-Bennett, is there anything in the record subsequent to the May 17th, 2022 documentation? There's not been another one.
There's been two, Judge. There was the Forensic Center in May of 2022, and then Ms. Woodson got an independent by Dr. Jeffrey Wendt, W-E-N-D-T. That was March of last year. There's not been a competency in the last year, but there's those two reports.
Right. So my review of the file indicates, again, starting with the one from May 17th, 2022, and I believe, again, the one from 2023, that both of those reports indicate Mr. Williams is competent to stand trial. Other than, I mean, there's been nothing that has changed for Mr. Williams other than time passing. So at this point, I don't find there is grounds to revisit the issue of competency. I will make the finding based on the two prior reports that he is competent to stand trial, and we will proceed on May 6th of 2024 for jury selection.
If
Do you wish to have another final pretrial, or do we just go ahead? If you do reach some agreement, you can put it on any Wednesday, or you can reach out and we'll schedule something. But otherwise, we'll just see you on May 6th.
I wish to have another pretrial, Your Honor. There may be some issues that we may need to discuss in a couple of weeks, Your Honor.
So am I here April 17th? How about April 17th at 1:30? And for convenience, in this case, you don't have to fill out the application. You can all appear via Zoom. Okay?
Okay. And is that going to be at 1:30 or at 11, Your Honor?
That'll be 1:30.
Okay, we on the normal.
I mean,
docket.
again, if there's anything to discuss, we'll discuss it. If there's nothing to discuss, you can you can cancel it. But if it's just a check-in, prior to trial, any of the above is fine with me. Okay?
All right. Thank you, Your Honor.
All right. Thank you.
Thank you, Judge.
Thank you.
3265 FC.
Good afternoon, Your Honor. Danielle Russo-Bennett on behalf of the people.
Good afternoon, Your Honor. Alex Peterson on behalf of the people.
Good afternoon, Your Honor. Marcia Cracher on behalf of Mr. Williams.
And we have Mr. Williams participating today.
If I may, Your Honor.
Okay.
Your Honor, we had confirmation from Sergeant Flynn of the Washtenaw County Jail that Mr. Williams has refused to participate in today's proceeding.
And is Mr. Burdell appearing today, Ms. Cracher?
He is, but unfortunately, Mr. Burdell is, well, let's just say this, Your Honor. He's here, but not in court clothes. Yeah.
Ah, okay.
He's here in the back
Okay.
room. We sort of caught him off guard today, but he will show up in court clothes on Monday, I assure you.
Okay.
Yeah.
All right. Today is the date and time set for, I believe, a motion in limine from both defendant as well as the prosecutor in this matter. So I'm happy to take them both up. I've reviewed all the materials submitted. So Ms. Cracher, why don't we start with your motion in limine to prohibit the medical record, omission of medical records, medical testimony, and prison incarceration.
Thank you, Your Honor. Briefly, Your Honor, is that it's my understanding that the prosecution in their case in chief wants to have medical testimony of some doctors and insert along with that into evidence some medical records. The issue I have with that is that I don't think that my client will insert a defense that he has a brain injury or he has any kind of memory issue until he actually states it on the record. in which then he is impeachable by that. Prior to that, I believe that this information is covered by privilege. And I've not been presented any waiver from the people that he has waived privilege in any evidence of his medical evidence or medical doctor testimony that the prosecution wants to put in chief. Also, I cited the HIPAA language, and I think that those are inadmissible unless for impeachment, Your Honor.
Ms. Bennett or Ms. Peterson? I mean, I've read everything, so just let me know what your highlights are.
Just going to be very brief, Judge, because I know you read everything. Just first addressing the privilege issue versus the testimony, the prison testimony. There was kind of two issues in Ms. Crater's motion. I don't believe that's accurate that until she asserts that defense, because unfortunately the rule of evidence, and maybe unfortunately for a client, party opponent statements I can put in as the prosecutor, and I am putting those statements in. So those statements are coming in as substantive evidence in the people's case in chief. So just the court I know read that there is this privilege, and the question really is, does the privilege yield for a proper purpose? And so I did cite to People v. Johnson. I'm going to lean on that, Judge, and that proper purpose for those records in furtherance of an unlawful or criminal purpose. I am putting in those statements through multiple witnesses. And so it becomes relevant. It becomes part of the case in chief, whether or not these are exculpatory statements or false exculpatory statements. And so I know the child's case says the privilege yields in narrowly defined circumstances, but People v. Johnson says this is a narrowly defined circumstance. And I thought it was interesting that Johnson notes that privilege is to protect confidential communications, not to suppress the truth. So I'm going to end on that for that. As judge, as to the request to not be able to allow any testimony regarding incarcerations, jail or prison, I cited to three pretty specific reasons why this testimony is not only relevant, but it's highly substantially material to the case. The other act's evidence, and we know the jury instruction says, if you believe this evidence. And so we have additional corroborative evidence of these other acts, witnesses, arrest cards, charges, incarceration. So that's one. Two is that it's the defendant's own statements that make these incarcerations so highly relevant. It is him telling people, including Dan Iverson, I did a decade in prison and I don't even remember that, sort of leaning on the whole idea that I would have remembered something like this had I not had this head injury. He also tells multiple people in his family that he's got a brain injury from his time in prison. And he also allegedly confesses to a crime against one of his children while in prison. As to that incarceration, I don't need to note what the charges were. I don't need to say how long he was in, but the fact that he summons his ex-wife to the prison to allegedly confess to hurting one of his children, those circumstances are really amount to the jury not hearing facts in a vacuum. He told his ex he found Jesus in prison and wanted to confess. And so it's really relevant. The final point that I'll make on the prison or incarceration testimony is in the family court proceedings from 1982 to 1983, Mr. Williams is held in contempt and jailed for about 60 days for his refusal or inability, I would submit, to bring Olisa Williams to court because she's gone. And so I think if you just tell the jury, well, he was held in contempt, but we don't want to talk about, really what occurred from that, then you're not giving the jury the facts. And so I would ask that the court deny Ms. Crater's motion on both of those accounts.
If I may have a brief rebuttal.
Sure.
Well, so I haven't got to the incarceration yet. I want to speak to the medical records. Of course, anything that Mr. Williams says is a statement that he makes. I'm specifically talking about the doctors that would testify in her case in chief prior to his testimony that he has this brain injury. I specifically did not say that the medical testimony applied to his statements. What I'm saying is the doctors that she has, I think she can call them in on rebuttal, but not in her case in chief. As far as the incarceration, yes, that's sort of what I was getting at is that I would not want the charges to be mentioned as far as, and the length of incarceration. statements that he makes specifically is fair game. I agree with that, but I would not want a whole litany of his criminal history and incarceration, especially tied to some other acts that come out to play here in the trial. I think that would be unduly prejudicial. So thank you for letting me make that clear, Your Honor. Thank you.
Sure. Okay. So defendant's motion eliminates to prohibit admission of medical records, medical testimony, and prison incarceration. I'm going to start with the obvious. I'm going to try low-hanging fruit again. It didn't work so well a minute ago. Let's see if it does now. The obvious, Ms. Kracher, is that the jury is not going to know of the current holding of your client. You know, if he is in court and he is not visibly dressed as if he is in the Washington County Jail, the jury will have no indication of that. More on that to come, because at the end of this hearing, I want to talk about what we're going to do on Monday should the defendant prove to be difficult, because I don't want a mistrial because of jury issues. But back to the motion, my review of the materials indicates to me that the records regarding the medical records, anyway, were obtained by search warrant in the investigation of the disappearance of Olisa Williams. At various points in his history, and I understand your argument, Ms. Kracher, the defendant has claimed a head injury somewhat related to lack of memory due to a chip being implanted in his head or teeth in prison. He has said to me in court that he has a traumatic brain injury. And so your client has asserted at different times that there is some sort of cognitive impairment and or lack of memory. And so my read of this is that the people are permitted to introduce evidence to prove the falsity of his prior exculpatory statement. You know, his statements have the burden. And so, you know, there's going to be all sorts of ability for you to, object and to, apply jury instruction to that. But my read of this is that the people are allowed to introduce these records in their case in chief, to address these statements about his lack of recollection, his lack of ability, potentially injury, potentially cognitive difficulty for him not to recall these things. Moving to the past incarceration issues, I've already permitted under MCL 768-27B, the matter of these prior acts. So the testimony of past incarceration corroborates the credibility of the other acts witnesses, specifically Denise Frazier, Daniel Elizabeth Reese, Kimberly Webb, Verna Williams Anderson, and Mary Leslie Bryant. And so, again, I think that counsel brings up she's not getting into what he was incarcerated for, but I think that there is enough record in the record to indicate his prior incarceration as it relates to these prior acts, that there's no bar for the people to introduce that into evidence. So I am going to deny the defense motion eliminate to restrict those records. So the people have also filed a motion eliminate and request the use of preliminary examination testimony at trial because of the witness unavailability. So Ms. Bennett or Ms. Peterson, I'm happy to hear your highlights. I've read that, and I'll hear your response, Ms. Kracher.
Okay.
Thank you, Judge. And I will again try to be very brief because I know you've read everything. And I think because the law is really, the rule of evidence was written precisely for issues like this. And I have to say precisely these very particular set of facts that we find ourselves having in this case. And so, as you recall from the people's brief, Mary Leslie Bryant is a other ex-witness. She also produced evidence that Mr. Williams allegedly made some confessions to her about killing a baby. And I'm going to be very frank for sake of full disclosure. This issue might come up again in trial with a witness who's elderly, who has memory issues. And so again, this rule of evidence is really specific in that as long as there was another hearing that the defendant had the opportunity for cross-examination and the motive for cross was similar or the same, that the testimony comes in. And that's under MRE 804.4 is specific to the death of a witness. We did unfortunately find out that Miss Leslie Bryant passed away in March, and we just found that out a couple weeks ago, hence my last minute motion. Again, it does not violate the Crawford Clause. It does not violate Mr. Williams's right to confrontation. I cited to the Barber case, the Garland case. Both of those, again, talk about what we have here. A prior hearing, prior opportunity for cross-examination, and the motive was the same. The last thing that I will note for the court is the Delaware case that the people cited in their brief. And because I suspect that I may know what Miss Kracher may object or argue, it just guarantees that the opportunity for cross-examination have been there, and that the court did not limit in scope or duration. I'd note that there was no objections to Miss Woodson's questioning of this witness at exam. She was not limited in scope or duration. She did cross this witness. As to this witness's credibility, that's all in the preliminary exam transcript. Along with the unpublished cases the people cited, we will just rely on those and ask the court at this time to allow the transcript and the reading of the transcript, the reading of the transcript into evidence for Miss Leslie Bryant. Thank you, Judge.
All right, Ms. Kracher.
Just briefly, Your Honor, this is such a serious statement that was made by this witness at preliminary exam. It's very crucial, and it is very damaging, I'll be honest, to the defense. Hence the reason why I made a motion to have it excluded. I would ask that because of the weight of this evidence and how prejudicial this is, without cross-examination at trial, I would ask the court to deny the people's motion.
Well, Ms. Kracher, I can't fault you for making the argument, although I got to tell you that I think that it does, in my read of the rule of evidence, as well as, you know, the brief cited, that this is kind of the exact reason why that we're talking about this. You know, Mary Leslie Bryant died, but prior to her death, she testified at the preliminary examination. The defendant did have a chance at cross-examination. He was represented at the time, and whether or not, you know, I mean, we've reviewed enough of the preliminary exam transcripts. I don't know whether there's a quality argument there or not, but he had the right to cross-examine, and I think he did cross-examine. And to the extent that I think that now that Mary Leslie Bryant is deceased, I think that is absolutely directly, specifically the rule of evidence that allows this. So I believe that I'm going to grant the motion and state that the preliminary exam testimony of Mary Leslie Bryant is admitted under MRE 864B1. So, so I think that's what the motions are up today.
Judge, can I bother you? I'm sorry, I was going to bother you about two quick questions, a question and a request real quick. Otherwise, I'm lest I forget to ask you before we get off this hearing.
Sure.
One is the start of the trial time. I believe you do start at 9 a.m., correct, Your Honor?
Typically, I ask people to be here at 8:30 so that we can get the jury going and be in voir dire by 9. So yes,
okay.
8:30 is the start time.
And my last request, and I did let Ms. Kracher know that I was going to be asking for this today. The court has allowed 2, I believe, witnesses for next week to appear via Zoom over objection of the defense. There is one additional witness that I would just ask for Zoom permission. I think it would expedite this trial, and I think there is good cause for it. This is Scott Powell, Judge, and he is the executive director of an organization in Alabama. It's an advocacy group for people with head injuries. He's going to talk about the group generally and just acknowledge that Mr. Williams at one time came to them. That is the extent of his testimony, and I don't think it is beneficial to any side to bring him, fly him in, get him a hotel when his testimony can be developed via Zoom, and he would be subject to cross-examination. So I'd ask that Mr. Powell be allowed to appear via Zoom next week, Judge.
Kracher, response? You can give me your general response that you don't like witnesses via Zoom, but if there's a specific on this case, let me know.
No, the general response is I don't like witnesses testifying by Zoom. I think they need to be live. Otherwise, why why not do a whole trial by Zoom? And let's just let the juries view witnesses via Zoom. We have trials in person for a reason. And I think that all witnesses should be live at a trial. Thank you.
I mean, for the reasons stated previously, and I'm not getting into my real assessment of materiality versus non-material witnesses. Like, I'm not making a qualitative statement on the import of this witness's testimony, but it seems similar that the witnesses the people have requested to be via Zoom are kind of, they're not really procedural, but they don't seem to be, this is not one of the, I'm going to put in air quotes, the eyewitnesses, the people that, are testifying about statements Mr. Williams made. They seem to be more tangential to that and some of the activities that he engaged in outside of the state of Michigan. So for those reasons, I'm going to go ahead and grant this motion and allow the final witness to appear via Zoom.
Thank you, Your Honor.
All right. So let me offer you kind of my thoughts about anticipating, Mr. Williams has at different times been cooperative and behaved and appropriate. And I'm expecting that to be the case next week. But I do want to just be on record or be prepared in the event that he isn't. So to the extent that I'm just letting you know this, Ms. Kracher, and you can share this with your client, we're going to have Mr. Williams at counsel table in street clothes as long as he is behaving appropriately and not causing a disruption to the trial. If there is a disruption, I will give him one warning, and I will certainly, admonish the jury to ignore that outburst or whatever. And then in the event of a second incident, I'm going to have him removed to the lockup in the court where we will have closed circuit TV so that there can be communication with the attorneys, communication with the client, and that. I'm, of course, not going to refer to it as the lockup. We will call it the court's conference room. But Mr. Williams will be secured in the court's conference room so that there is access for you and or Mr. Burdell, and we'll have to figure out how that may or may not work. If maybe one of you is with Mr. Williams and one of you is at counsel table, I don't know. I mean, my hope is that we don't have to worry about this. But I am directing transport to transport him even over his objection on Monday, because I don't think we can have the trial without him here. I don't think that works in terms of your ability to communicate with him during voir dire, during, objections, that sort of thing. So my anticipation is that we'll have him here on Monday. He will be totally good to go, and we will, as efficiently as possible, get through this trial.
Your Honor, I do need to make a couple more things for the record. And I know this is
Sure.
not what you're going to hear, but I really need to make a record. If I may, sir. All right. I am going to make an oral motion. I've spoke to the people about this to withdraw today. The reason being is that on April 10th, April 17th, April 24th, and today, I attempted to see Mr. Williams at the Washtenaw County Jail. And I'm able to meet with him because he refused to meet with me. In fact, we confirmed that he refused to come to the hearing today. I've not been able to discuss since approximately, I think, March 20th, late March, anything about this case with him due to his refusal to meet with him. I'm very concerned that about trial prep, especially when it comes to the point about him wanting to testify in this matter. I've had no time to prep or discuss this case with him whatsoever in a attorney-client environment, sitting down face to face. That's number one. Number two, I am making another oral motion today to send him out for competency. Since our last hearing, I received about an 8-page letter. I cannot disclose the context of the letter, but I can state that the letter was very convoluted and was it showed he, in his present state of mind, I believe, is not competent to go forward with the trial. And as we all know, competency is fluid. So I know he's had an evaluation. I believe the latest evaluation was done prior to his preliminary exam, which was held on May of 2023. It's approximately a year ago. In fact, it was a year ago. May 2nd was the second part of it. So May 1st it was a year ago. And I just don't think he is competent to stand trial, and ask the court to allow a competency evaluation to be done, Your Honor, for the reasons I've stated. Thank you.
Okay, Ms. Bennett, I'm guessing you're objecting to both of those?
I am. I actually would object to the competency, and it's one of those weird things where I'm objecting for the record, but also deferring to the court because I know competency is fluid. However, he's had 2 competency exams, and I think those have both come back to show that he is competent to stand trial. And my concern is that because we've seen the behaviors go back and forth with Mr. Williams, this could be a malingering act to just try to delay it. We know he doesn't want to go to trial right now. The second is the adjournment. I told Ms. Kracher today that for the last couple of months, I've been willing to work with her, defer to the court, maybe even stipulate. But now that we're on the 11th hour, the eve of trial, plane tickets have been bought and hotel rooms have been booked. And I cannot do that to these witnesses, and I cannot do that to the victim's mother. So I do have to object to an adjournment of the trial. Oh, and as to if there was an adjournment, excuse me, as to the withdrawal, I don't want to speak to that because that's Ms. Kracher's relationship with her client. So I'm just going to defer to the court on that particular request.
So since everyone gets to make a record, so do I. My concern about your motion to withdraw, Ms. Kracher, and I've told you this previously, I appreciate your position. I know it's been a difficult road for you in terms of communication with your client. There have been times where he's been communicative, times where he's not been communicative. I had that same experience when he was representing himself. I had that same experience, I believe, in observing his relationship with Mr. Feaster, the public defender's office. I had that same experience when he was represented by Ms. Woodson previously. And so I'm left with, how do I make sense of any representation and not adhering to firm trial dates? So I believe I was clear from the beginning of your appointment that we would be proceeding to trial and that you would be his trial attorney. I'm fine with and delighted that Mr. Burdell is going to be joining you as counsel in this matter, and I think that will add to the defendant's defense. And so at this point, I'm not going to allow your withdrawal. I understand you have made a record as to why, but at this point, we are going to proceed to trial, and I am going to have you representing him, you and Mr. Burdell. As for the competence, I'm going to echo what Ms. Bennett has stated, is there have been 2 competency evaluations. Both of them yielded results that Mr. Williams was competent to stand trial. You are correct. The most recent one was a year ago. And yes, competency is fluid, but my experience with Mr. Williams has been certainly times, even as recently as last week, I think he spoke at length. And although some of it had to do with, I think, an alleged brain injury, he was speaking to points about his defense. He was speaking to points about what was happening. I'm not a mental health evaluator. I'm not a competency evaluator. But at this point, I don't see that there are grounds to adjourn the proceedings to determine for a third time whether or not Mr. Williams is competent. So I'm going to deny those motions, and we are going to proceed to trial on Monday morning. Okay?
Your Honor, do you need an additional exhibit list for me to add? I was awaiting ruling. I did file all my filings for the court, the jury instructions, etc. And I filed an amended exhibit list, but I did not add the transcript to that for Miss Leslie Bryant because I was not sure of the court's ruling today. I can file a new one, or I can just add it to the witness list in trial if that's okay with the court.
I'm okay with you adding it to the exhibit list in trial.
Thanks, Judge.
If that's going to be read into the record, though, I'm going to leave it to you to plan how to do that. I had a trial last week where it seemed to be, I'm not sure, the lawyer was like, Your Honor, your staff will read it. And I was like, I don't think my staff reads it. So I ended up reading it, but I don't plan to read any evidence into trial this time. So.
I will likely just have my victim advocate will do the question and answer. Thanks, Judge.
Okay. All right. See you all Monday.
In a multi-day jury trial that was not live streamed to the public, Isiah Williams was convicted of the murder of Olisa 42 years after her disappearance.
People versus Isiah Williams, 23265 FC.
Good morning.
Good morning, Your Honor. Danielle Russo Bennett on behalf of the people. Good morning, Your Honor. Person on behalf of the people.
Good morning, Your Honor. Marcia Frazier on behalf of Mr. Williams.
Good morning, Mr. Williams.
Good morning, Your Honor. I believe I Vernon Williams II,
Okay.
but that's questionable.
Okay. Well, we're going to go with that. So go ahead and have a seat. Today is the date and time set for sentencing in this matter. Just to go over again for counsel, and I'll have you confirm this. There was a trial in this matter. The defendant was found guilty by the jury to count one, and we are here today for the sentencing. There are some other pending charges that are not from this jurisdiction, so I'm not dealing with those, but we are dealing with the sentencing on the trial. Is that correct?
Yes, Your Honor, that's an accurate recitation.
Yes, Judge.
Okay. Mr. Williams, I'm going to go through a number of things today. I am going to ask a number of questions. Most of those questions can be answered by Ms. Kracher, and you will have an opportunity to address me before I sentence you, okay?
Yeah.
All right. So I have had a chance to go over the pre-sentence report that was submitted by Michigan Department of Corrections. Went over that in great detail. And so let me start with you, Ms. Kracher. Have you had an opportunity to review that with Mr. Williams?
Your Honor, I'll make this brief. I do need to make a record, Your Honor. Your Honor, I went over to the Washington County Jail along with Mr. Burdell yesterday. Met with Mr. Williams. We began to review the pre-sentence investigation report. At a certain point, he ended our visit and refused to continue to participate. I attempted to engage him here this morning. I asked him if he wanted to review the PSI report. He said no. I just also want to make a record that I did provide him yesterday morning at the Washington County Jail a copy of the pre-sentence investigation report and the appellate form. So those were both provided to him yesterday.
Okay. You're ahead of me on the appellate form.
Well, I'm trying to be
Appreciate
succinct. And so with the appellate form, I discussed that again with Mr. Williams in the lockup here, and he explained to me, I asked him, did he want me to take the form and file it? He said, no, not at this time. So that's up to him how to do. I just want to make a record that those two things have been done. Thank you.
So let me just again further that record, Ms. Kracher. So Mr. Williams, one of the rights that you have is to you have the right to review the pre-sentence report that's created by Michigan Department of Corrections. So they did a background on you, they talked to you or attempted to talk to you, they attempted to reach out to other witnesses, family, other parties. They compile an entire report. Ms. Kracher told me that she gave you a copy of that yesterday and she tried to go over it with you. You have the right to have your lawyer go over every word on that. And I just want to be clear that if you choose to not do that, that's kind of on you. So we're going to go ahead today with this, but is there anything about that report that you have questions about? Do you need to, I'm not talking about challenging it right now. I'll give you a chance to speak to me, but right now I'm saying, is there anything you don't understand? Have you had enough time to read it over and all that?
Your Honor, I explained to her that at that time, I said I will refrain from want to do anything in that regard, to have the opportunity to speak to an attorney in regards of this matter. And I said, is anything in the court at this present time, then I'm refraining from even want to participate because I feel as though that it's not actually following the law that was handed down by God under Moses to give to the people.
Okay. So let me just ask you specifically though, I'm going to interrupt you though. Is it true Ms. Kracher left a copy of this for you yesterday?
Oh, yes, she did.
Okay.
I have access to that copy.
All right, so you're gonna have an opportunity to address me. But I'm just really limiting, this first part of it is just simple questions to make sure that you have had all the rights afforded to you on my side of things. You may disagree with them, but on my side of things, I need to be clear that you have a copy of this. You were given a copy of this document yesterday, correct?
Yes, sir.
Okay, okay. So, based on that, Ms. Kracher, based on your own review of the document, do you have any additions, corrections, or deletions to the pre-sentence report?
No, Your Honor, I do not.
Okay, so Ms. Russo-Bennett, before I go back to Mr. Williams with a specific question here, do you have any additions, corrections, or deletions to the pre-sentence investigation report?
Judge, I've reviewed the entirety of the report. I have no additions, corrections, or deletions.
All right, Mr. Williams, another narrow question for you. Is there anything in this report that you have reviewed or you've had an opportunity to review that you think is incorrect? And I'm not asking you to comment on whether you think the process is correct or that, but of the information that's in the report, you either have heard Ms. Kracher read it to you or you've had an opportunity to review it yourself. Of that material that you reviewed, is there anything that's not true?
Your Honor, I can only take a state, like I said before. I'm not in a particular mind to want to state that I've even taken the time to even look at it because I feel as though that is already blatant out of order.
Okay, I understand that, and hold that thought. I'm going to give you a chance to explain it to me, but that's not what I'm asking you right now. Okay. All right. Before we get into victim impact, let me ask Ms. Bennett, you submitted a lengthy brief on an area that, in my estimation, I don't have a lot of discretion. I mean, I know I have some discretion. So I kind of read through the entire, back 30 pages of your analysis of second degree, but I'm not necessarily inclined at this point to proceed under that analysis. If I change my mind during this hearing, I'll come back to you for further comment. But in the event that I don't, do you have any comment on the recommended or the required sentence in this matter?
Absolutely not, Judge. That was just in case those filings were scored, and it's, the memo was more for and the order of disposition already reflects it for the one count murder one under multiple theories, and that's what we'd be asking.
Correct. Okay. All right. Ms. Kracher, again, knowing that, if I proceed under the jury verdict in this matter, that I would not have, other than all the discretion that I have, the actual charge does not give me guidelines. So there's no guideline contemplation here. So my question to you is, do you have any comment on the recommendation of MDOC for sentence in this matter?
No, Your Honor, I think Your Honor summed it up succinctly. You have no, there's no discretion given the verdict. There's absolutely not. This is a mandatory life without parole sentencing. And as far as the guidelines that Madam Prosecutor has submitted in the scoring.
Well, if we get to that, let's comment on it.
Okay, sure.
Get to that, then I don't think we need to get to that.
Right.
All right. So Ms. Bennett, I understand there are two victim impact statements.
We have two people speaking from the family, Judge. They will be reading several impact statements. May they come to the podium?
Of course.
We have Denise Fraser Daniel, and we also have Elizabeth Johnson.
Okay.
Morning. My name is Denise Fraser Daniel.
Good morning.
Today is a bittersweet day for me and my family. Sweet part is Isiah will get what he deserves, and the bitter part is we will never again have Olisa Susan. My dear Olisa was absent, has left a gaping hole in our lives. And I remember when she was born August 10th, 1981, that she was so chubby and filled out, which is the reason why I named her after her Aunt Susan. Her murder has left me with pain that I never thought possible. Isiah, silence is a cruelty beyond measures. You have taken from me the most precious gift from God, and now you deny me the chance to lay her to rest. You may think that your silence will protect you, but it will only add to your guilt and shame. You may have taken my Olisa's life, but you will never take away my love for her. And I pray somehow I'll be able to bring her home to rest. The majority of your life has been leaving broken spirited women behind who have crossed your path, including myself. I made excuses for your behavior and kept coming back to lies after lies. But when you took my daughter, that was the last straw. I know this is stronger, but I hate you, Isiah.
Yeah, take your time. Take your breath. Every word that you say, it's okay.
For torturing me and my family for 42 years, knowing we would never see Olisa again, my sweet baby. Never to hold her in my arms, kiss her cheeks, and sing to her or watch her grow into womanhood while missing the special milestones and events. Olisa's brothers, Matthew, Michael, and Nelson, will never have a chance to shower her with brotherly love the way they showed their love for their big sister Elizabeth. Elizabeth has been my rock for myself as I endure the unknowing of what happened to Olisa. She too has been mourning in her own way because she remembers Olisa, holding and kissing her and playing with her. My youngest son, Nelson, told me to tell you that you took away a sibling that he was unable to get to know, look up to, learn from, laugh, and be a little brother to. You took away someone who could have been anything in this world, yet she's gone because of someone unfit to be around any child, let alone adult women with supervision. That's why we're at this point sentencing you to prison. Her stepfather, James, has also been there to support me as well. He never knew Olisa, but was still stood by my side as I grieved for her. By my side when I had to request a death certificate for her, and talking with Detective Iverson in Attorney General's office. So you see, Olisa had many people on her side believing she would come home. Hopes and dreams shattered because of you, Isiah. I don't know if I will ever forgive you, but with God's grace, someday I hope I will, but not today. I'm Elizabeth Harris.
Your time, man. It's okay.
I would like to say thank you to Detective Iverson for reopening my sister's case and not giving up and seeing this case through. We wouldn't be here today without his determination to solve this case. Thank you to the Attorney General and the team. Honorable Judge Simpson, Honorable Judge Collin, and the jury, and the support from family, friends, and the community. Because of you, Isiah, and your actions, I didn't get to be big sister to my little sister, Olisa. You took that from me. You took away from our family seeing my little sister growing up and seeing her become the beautiful woman I know she would have been. You took away my brothers from having 3 big sisters to only 2 You took away from my children having an auntie. You took away the chance for my mom to have even more grandchildren. Because of your actions, I missed out on laughing and crying together with my sister. You took away my friend. You took so much from us. We may never know what you did to Olisa, but you do. And I hope that every time you close your eyes, you see her face and she haunts you every single time. I hope you never have peace for the rest of your life. I hate that our tax money is spent taking care of you. I'm standing here on the behalf of my sister for justice. I'm standing here so her soul can be at peace. I'm standing here so my family can have peace and closure. I'm standing here for the victims that we know of and the victims that we don't know of, so there be justice. I'm standing here so no other family has to go through any more hurt from this monster. I'm standing here asking the court that Isiah Williams will never be free in society again and will spend the rest of his life in prison without parole. And I have a note here from my brother, Michael Daniel. Isiah, 40 years you have left a stain on our lives that will never go away, or at least I thought it wouldn't, but today is our retribution. Today we take our power back that you stole. Today we no longer have that dark cloud over us. Today that demon is locked away for good. No more suffering for my mom, no more suffering for my family. Justice has finally prevailed. My sister is in God's hands and shining down on us with the rest of our family. Your days of being the villain are done. We no longer worry about you because we know you can't do any harm to anyone else. Good riddance, you monster. This is the last time I will think of you as a monster because you have just now been defeated. My family can now heal and move on from this and move on from you. Thank you to everyone that has worked tirelessly to get this guy. Thank you, Michigan, for finally making it stick. May the Lord continue to protect my mom and family, and may he bring peace to our hearts. Love you, Mom. Thank you for being the strongest woman that I know, the superwoman of my life. God's got you and God's got us. Continue to be strong and resilient. And I'm glad that you are here today, so you can hear your sentence. So you be put away for good for what you've done to my family. I hate you. I wish you just rot in hell. I've never had my sister again, ever. The only thing I can take with me for the rest of my life is on Valentine's Day, and she and I are matching shirts, and we having a good time at my school. That's the biggest memory I'll have of my sister. I just pray that you get everything that is coming to you, and you will never, ever, ever have peace, ever.
Ms. Gracher, for any allocution, anything else, Ms. Bennett?
Just very briefly, Judge, because I don't know how you, there's really no reason to follow that, but every defendant has a right against self-incrimination to have a defense, to say I didn't do anything. And so I want to be very, proceed with caution for what I'm about to say, but this man has never exhibited an ounce of remorse, an ounce of any emotion other than indifference for the life of this child. An ounce of outrage. The only outrage he's ever exhibited is for himself, for the pain that he is going through, being locked up for this. And at the end of the day, he can proceed here that he didn't do anything wrong, that the jury got it wrong, that he didn't kill her 42 years ago, despite the fact that no one's ever seen her again. But he kidnapped her 42 years ago. She disappeared in his care and custody, and he has never answered for it. He has expressed nothing but lies and indifference and outrage for himself as the victim. And yet, again, there's no remorse for that. So if you just ignore everything else, the fact that he took this child and tortured her family over her absence for 4 decades, the sort of indifference and lack of remorse and lack of any humility for it. I've never seen a verdict and a sentence today more worthy of a defendant, and life without parole is very fitting for Mr. Williams. And I'd ask you to sentence accordingly. Thank you.
Ms. Preacher, do you have any elocution on behalf of your client?
Just briefly. First of all, my client does have the right to remain silent. The burden of proof is clearly on the prosecution. My client stands here today professing his innocence. I understand the AG's about lack of remorse, but again, I go back to he has a right to sit here, and it's in a jury instruction, to say nothing. He has that right. Therefore, if there's any leniency that the court is going to take in consideration, I would not ask the court to judge this man by his silence. We have a trial record, we have all that. So any kind of leniency that could be given, I understand that's mandatory. I would ask the court to do. There's nothing much more to say. The victim's impact statement were very, very traumatic and justifiably so. This is a case that, in my years of practicing law, the numerous factors and tragedy in this case, it's immense. And it is one of the most tragic cases I've been involved in. But again, my client professes his innocence here today. Thank you.
Okay, Mr. Williams, this is an opportunity. I want to just be careful. I'm gonna listen. If you want to speak to me, absolutely, but we are going to probably, if I have to interrupt you to put a time cap on it, I'm going to do that. I'm not telling you what that is. I want you to be able to tell me anything you want to tell me before I sentence you. So this is your opportunity.
Thank you, Ron. I appreciate that. And excuse me, Ron. Sure. Yeah. I appreciate the opportunity to address the court and mainly to Denise.
I'm going to just let you know, though, that this is really your opportunity to speak with me. So I will, if you have something that you think is appropriate to say, you can address it, but I just want to let you know, this isn't a dialogue between Denise and you. This is really your one opportunity to speak to me before I sentence you. So go ahead.
That's why I was taking the stand for, Your Honor, was to be able to express what I know to Denise. I tried to do this here when the state court took and sent me a summons to take an appearance in court regarding their matters of Denise. And I frequently wrote to them and told them I was willing to take and bring to the court what I knew. And I'm standing now, saying the same thing. I had the opportunity, being a brain intervention, that someone brought to my attention in 2000, and I was staying in Thompson Tower, and a young lady came to me and told me that I had met a young lady living there in Thompson Tower, and brought to my attention, do you know who that is? And I told no, that I don't have a knowledge of any of my children or any of my family, that I don't know.
That's why I was in Michigan, to try to learn about a family. And she said, that's your daughter. And she's now been kept with a guardian. And I started conversing with the child on numerous days, and I broke bread with this child. And even to a point that where I scheduled a party to go with the child to the palace. That time we was going in here, a rendition, you understand, of Tyler Perry. I even rented a limousine. And we both went there to the palace. And I had tickets up in the balcony. But an usher came to our party and with a wheelchair and escorted us as we was like royalty to the front to be able to witness that play. And when we got ready after leaving to return back to the limousine, her guardian was there. And she was to take a leave and go back with them. And the only thing I know then is that maybe the guardian had called when we had left from Thompson Tower with her and had inquired where we were and then met us there. And she took and go back home with her. But I left with something when I left in 2000. I explained to her, I said, Olisa, I don't have a knowledge of the past. And that I'm going per my psychiatrist here in Ann Arbor to Alabama Heritage Foundation to be taught how to live with brain injury, to see if they can help me be reclined or be retaught. And I had a portrait given to me. And now for some reason, I remembered it, and I remember the quote on it. That quote, it was only like fishnets. And it stated, oh, what wealth we weave when we first set out to receive. Oh, what wealth we received is taking what? When we set out to deceive. She wanted that portrait, and I said, no. I said, I want you to give it to my niece, Linda, who I had been asking to come in and spend time with the child once I was gone and look after her and cook her a decent meal because she was always complaining. Well, my garden don't really cook to my satisfaction. So my niece, Linda, was coming on my behalf and helping cook a meal for her. And she enjoyed that. But she didn't want me to give that portrait I left with her to Linda. And she stressed to me, and she always called me by my first name. She said, Isaac, I want that portrait. I want it. I said, but I'm leaving it for you to give to Linda to be a comfort and a cook for you while I'm gone. I had that time with that child, but everybody don't seem to know. That's why the Holy Spirit told me when I came to this court, you have an alibi. And that's what I gave to the attorney. And I told the attorney, I said, all I know is that I've been, you understand, constantly brought children claiming that I was their daddy, and I had no knowledge. And several of them have been in this court here. They claim I'm a violent individual, that I have beat their wife, their mother up, that I have no relationship with them, that they're afraid of me. I'm a monster. I'm a cruel individual, that I would take and beat their mama with a board. So I didn't know. So I came to Washington County with my wife, Helena, my honeybee at that time that I met when I came here in 2000, who now God had called home in 2021 of July. We came here to the court and I asked the court, will you help me? Because I don't have a knowledge about this woman who claimed to be my wife. And they said, who was that? They said, the one that I did 10 years in Jackson for assaulting her. And they said her name was Elizabeth. Was Elizabeth Williams, now Elizabeth Reese. Can I get a copy of the transcript? They said, of course. So when they told me the price of it, I couldn't afford it. So the lady came with the transcript. She said, well, ask the judge if he would waive the price. And they did. They gave me Judge Brown, his giving me that gift of that transcript of Elizabeth Williams back in the 80s, where I had assaulted her, of her claim that I had slapped her in the car, but she jumped out, me traveling 70 miles an hour, but she didn't sustain any injury. But that I ran after her and beat her down with a board. So I read the transcript. And then I read what the eyewitness said. She lied. That's what the eyewitness said. She saw Elizabeth enter her home, and that I wasn't in her home in the backyard beating her down with no board. But that was just from my understanding. I'm not here pleading the situation with me. I'm just bringing it to that thing has been brought to my attention. So then I'm by a family who claim to be my sisters and brothers. They say, well, your son has been died in an auto accident. Again, they urged me to go before Judge LeBeau in Monroe to learn something about a family that I had no knowledge of. Well, I was supposed to have 5 children by Elizabeth and didn't even know who Elizabeth was. But by the grace of God, I was able to had to go before the court, and Judge LeBeau had me on the stand, and he asked me, do you know who the child is? Now, I tell you, this was regarding $300,000, and I told Judge LeBeau, Your Honor, I'm not here for no money. I said, I just came here to take and tell you that no, I don't have a memory. I don't have a memory of any of these people they called me my children. I don't even have a memory of this person called my wife. That's what I've been dealing with in this case here with Denise. I don't have a memory of these things. But I do know what the Holy Spirit gave me. When he told me that child that I met in 2000 and broke bread with and went to the palace to see, you understand, that was Olisa. That's what the Holy Spirit told me. And so I sent out feelers to go and try to find the child that I met in 2000. And I told the attorney. I said, I don't know what her name is. I said, but I know what she told me at that time. And I remember, they said, well, what do you remember? I said, well, I remember she took and told me she was 19 years old. That's what she told me. The girl that I broke bread with. The missionary was the one who told me, that's your daughter. So I advised them and the investigators, I said, well, then go over there to Inkster Church, Seventh-day Adventist, and see if you can inquire who was this child guardian. To see if that was indeed, that they're telling me here now in 2024 that that was not Olisa Williams. That's what I'm saying to her. I'm not trying to take and tell them that I'm no good guy. All I do know is that what I've learned of my knowledge in coming aware from death of 1995. And when I had the pleasure of listening to the Almighty God have a verbal communication with me. And this was really profound. I was sitting in the car of Dana, not knowing who this is. But the hospital took me to Dana's car and said, "This is your car." I said, "No, it's not my car, I don't think." When I looked at the registration, because I don't think you understand, Isaac is Dana. But that's a social worker from the hospital took and told me. And I left in that car over at Dan, what was it? I guess was pronounced as I can remember, Dundee Lounge on 23 in Ann Arbor here. And the Spirit of God took and directed me to Cincinnati, Ohio. I was there until someone sent people to find me, because I didn't know nobody was looking for me. But they sent an individual to me, and he came to me and said, "Well, I've been looking for you. Your family's been looking for you. We need you to take and sign over your property that you don't lose it for taxes." I said, "Well,
I'm not following this, Mr. Williams. So
yes.
You need to sort of pull this back into what we're.
Well, I'm trying to take and bring a knowledge of what I know and who I've come to take and say who I am. Because I figure that's what the court want to know, who I am. And I've been trying to find out who I am since 1995. But I'm giving you a scenario of what I've learned about who I am. That's all I'm doing. That's all I can do. And I'm saying to the court, I wish that we could have, and those detectives could have found this one that I met and to try to discern who that child was. That's all I'm trying to take and bring to the attention of this court. So I don't have a problem, because I was blessed, Your Honor. I was sitting into the bunk in the Washington County Jail, and the Holy Spirit took and sent someone with me and took and gave me a book. It was written by John Pepper, who was a descendant of the Chief Justice Clarence Topper's grandfather. And I started reading that book, and it sent me to John, the 3rd chapter, the 3rd verse, and took and made it plain. For me to get back, you understand, to heaven, I got to be totally born. I have to be born again. And I've been constantly going over the scriptures, learning how to be born again. And through my prayer and meditation and the blessings of our Father, by his grace, and the Lord Jesus Christ, for him going to the cross for me and taking my sins for me, freed me of my sins, and blessed me with a new birth. Born again, not of the will of man, but born of the Spirit. I had the first opportunity of even speaking in tongues is when I was last here in the bullpen, been brought from the jail, and cried out in our Father's name to send someone to help me. And God blessed me to speak in tongues. I laid on that cold floor, and a warmth came over me. And when Holy Spirit took and baptized me to speak that in tongues of the Holy Spirit and bless. So I am no problem. You can send me to life, to death. I don't have a problem, because absent from the body is present with the Lord. I'm free. I just wish there was some way we could have found that child that I met that would help Denise and her family, that it will heal them, that I don't think she's dead. And I'm telling the court, I don't believe she's dead.
Anything else you want to tell me, though, about you?
That's what I'm here to take and talk about, the Deb, I'm here to take and say, I'm wishing you understand that what I saw will be presented to the court
I understand what you
for
just
their family. Well, I thank you for that opportunity. That's all. And
Thank you.
like I said, I'm free. God bless you. And bless you, Denise and your family.
All right, you are welcome to have a seat.
Excuse me. Hold on, brother. Hold on, don't grab me. You already grabbed me and beat me up.
Mr. Williams, you're welcome to have a seat.
You take that, you gonna give him another order to beat me up? You gonna have him get an order to beat me up?
Mr.
You took him had him before beat me up.
Take him back. Oh, take him out back. Oh.
Yeah, smash my head up against the wall and everything else, beat me all up. They said you ordered it.
So I would like the record to reflect that the defendant did have an opportunity to address the court. He did so for approximately 20 minutes. He was invited to be seated. Security urged him from the podium. He then said that previously assaulted by security at my order. I didn't order that. I'm reasonably certain security has never assaulted him. There are cameras everywhere today, so I think we're all pretty well assured that everything is recorded, so not troubled by that. Would proceed then to sentence in this matter. If he is quiet, you can open that door so that he can hear us. But the record should reflect, the video would reflect this, but the record will reflect the defendant is back in lockup at this point. The only thing I would say is that there have been 2 matters filed since the verdict was entered by the court through the jury. On May 12th, looks like Mr. Williams filed essentially a statement of alibi that he referenced today in some length about meeting someone in 2000. And then also it looks like Wednesday, April 17th, where that I think was a prior. I'm actually not clear at all what it is, but it was kind of response to the court's attorney standby counsel. So I'm just not clear kind of what it is. So a couple of things though to proceed and respond to. I would like to note, and I would have said this to Mr. Williams if he were standing here, that throughout all of the proceedings and all of his recitations to the court, Mr. Williams has asserted this closed head injury that has resulted in his inability to recollect. He doesn't know, he doesn't remember his children, he doesn't remember his family. I would point out that even in 20 minutes today, there was a reference to going to the palace to see Tyler Perry. I mean, I couldn't remember that I went to the palace 2 weeks ago and who I would have seen. And even if it had been Taylor Swift, of whom I'm not a huge fan, but I don't know that I would remember that. And so the fact is, again, 24 years later, the defendant has an exactly clear memory of a trip to the palace to see Tyler Perry. He references Judge Brown, who has now been retired from this bench 2 or 3 years. He references a trial proceeding that I believe would have occurred, again, decades ago, and remembers that with clarity. He even pulls out of kind of another jurisdiction, Judge LeBeau from Monroe County. So again, I'm struck by the ability to remember in specific detail and names and faces and events, and yet whole swaths of things are not memorable to him. So, and at least as far as the testimony of the Brain Institute from Alabama, it is not a medical intervention facility whereby the defendant would have had treatment there, surgery, medication that would have restored his memory. And so again, I am struck by the incongruity or inconsistency of whole areas that are forgotten. And yet all of a sudden there seems to be an alibi from 2000 where there is memory of a wheelchair, of a play, of breaking bread with. I don't know the truth of any of that, and I have my own suspicions about it, but I can't speak to that. But at this point, I just have to place on the record that as I listen to the defendant today, I am struck by his quote of webs we weave and practice to deceive. And I can only say that it strikes me that this is a convenient memory or loss of memory where the opportunity for solace to the victim's family has been amply presented. And it is today is the first time I'm hearing of this alibi where miraculously that might have given hope. I would also reflect the defendant's statements about the detectives in this matter, and I would reflect to him that, let's say that at the time of the disappearance of Olisa in the 1980s, we know of at least 2 detectives who were assigned to that. There were actually more, I believe. But let's just say there were 2 at that time. I think then that became a cold case, and there was another interim couple of detectives who investigated, and then they're kind of brought to the current iteration of detectives who, more on that in a moment. But let's just remember that it was the job, it was not the soul, because this isn't the only case, but the whole purpose in this case was for those detectives to find Olisa. And they devoted hours, weeks, months, years to finding Olisa, and no one has found Olisa. So I would suspect that a woman who has a guardian, court-appointed, church-appointed, family friend-appointed, a guardian who breaks bread with a defendant in 2000 and goes to the palace and is treated like royalty, I'm pretty sure the detectives would have followed up on that lead and would have found that person and would have made a determination of whether that was Olisa. So the fact that the court is hearing this for the first time today strikes me again as another evasive, lack of memory, convenient way for this defendant to muddy the water, create smoke in a way that is hurtful beyond measure. So I don't know that there's anything more that I need to place on the record as far as response to the defendant. I'm going to address this again to Ms. Fraser Daniel and your family, your extended family. Because often in sentencing, I will speak to the defendant because one of the elements that the court has to consider in sentencing is that idea of rehabilitation. I don't know that I need to spend a lot of time on that today, sadly. So in many ways, words kind of fail me, and I find myself in an unusual spot in that case. I'd like to start by saying thank you to the lawyers and the witnesses and the detectives in this case. I'd like to thank both the defense team, Ms. Kreitcher and Mr. Burdell, did an excellent job, kind of late to the game. There have been a number of you representing Mr. Williams throughout these proceedings. I think you did it. I think you did a good job, an excellent job, and as good a job as you could have done, all things considered. So thank you for your professionalism and your treatment of this case. Again, Ms. Russo-Bennett, Ms. Peterson, your team, Detective Iverson, your team, I mean, like everybody involved in that, I want to thank you again for your professionalism and your ability to present this case. It's an unusual matter and it was difficult. The witnesses all responded with composure. It was very civil, professional, and respectful. And so I appreciate that from everybody in this courtroom, family and non-family alike. Going back to the words failing me, it's in thinking about this, how Mr. Williams could murder a baby more than 4 decades ago. And that's inconceivable to start with. But what becomes more inconceivable is that he could keep Ms. Fraser Daniel in the dark for more than 40 years about that. And to string along, lead along, even by silence, sort of, again, this tacit story that he didn't know or didn't understand or couldn't remember. I mean, he was in a relationship with Ms. Fraser Daniel. He was your husband. And it's inconceivable that someone would treat anyone that way. And so where I sort of talk about, normally I would be addressing some comments to the defendant, I don't have much to say to Mr. Williams. I can only hope that this brings you some peace. It is through your expected love of Olisa, continued to kindle that through these 40 some years, that we're here today. Because if you had given up, if you had internalized it, I'm not even saying given up, like I'm not going to think about this anymore, but if you hadn't been as perseverant as you were, as unwilling to let this go as you were, we wouldn't be here today. And you know that there's nothing I can say to you or do to you that's giving you peace, hope, or joy. But the one thing that you can take from this is that through your efforts and through your teamwork with the detectives and the agencies and the Attorney General's office, through your hard work, you have some semblance of justice. And that's maybe the best you're ever going to get. And so, you know, on behalf of the court, I want to thank you for your hard work and your heartbreak and your pain through these 40 some years, whereas a lot of people would have just walked away, or they would have let it go, or they would have just tried to make peace. And I think that you brought us to a place where justice, and at least as far as I and the attorneys in this case can offer, you brought us to a place where we can close this file, and we can hopefully, in addressing your children and your family, where this gives you some peace. I mean, I heard you speak to how painful this is as well. And my only hope for you all is that you can forget this man, forget him, put him out of your lives forever. Because the only hope that you have going forward is the love your family has, and the memories of your sister, your daughter, and the fact that you hopefully can just put this now behind you and not have it. I think your brother quoted kind of a dark cloud over your family. I hope that cloud goes away. Sadly, we've got that reflected externally today too. But I hope that dark cloud can dissipate for you and your family, because that would be, I mean, people say this all the time. I mean, I literally, I mean, this is apropos of nothing. A week and a half ago, I lost my 52-year-old sister-in-law. But it's the kind of thing people say to you, like, she would want you to be happy. I'm telling you, Olisa was a baby. She were a 42-year-old woman today, what would she want you to be? Happy. She would want that dark cloud gone. You know that. We've said that to countless other people who have lost people. So you need to understand that as much as I can speak to you up here in the black robe, I'm telling you, let that go. Let that dark cloud go away. Mr. Williams is going to spend the remainder of his life in prison. I don't know what kind of hope I have for him. If he were sitting here, I don't know if he can hear me. I hope that whatever change of heart or peace or whatever he was just talking about with faith and Holy Spirit and breaking bread and Father Abba and conversion and born again, I mean, it's not my place to judge whether that's true or not. I have, again, my own opinions about that I'm not going to share today. But if that is available to him, I hope that he finds it, because otherwise I don't know how one reconciles any piece of these actions. So to that, in case number 23-265 FC, People versus Isiah Williams, count one, murder in the first degree. It is the sentence of the court, and in this case, because it is first-degree murder, there are no guideline sentencing recommendations. It is the sentence of this court that the defendant be sentenced under one count, but under both theories found by the jury, premeditated murder and felony murder, that the defendant be sentenced to the Michigan Department of Corrections for a period of life without the possibility of parole, with credit for 903 days served. Mr. Williams, as far as whatever income you earn as a prisoner, you must pay a crime victim assessment in the amount of $130 as ordered by the court. You must pay court costs of $1,611 as ordered by the court. You must pay attorney fees of $650 as ordered by the court. You must comply with DNA testing and pay a $60 fee as ordered by the court. And you must pay a $68 state cost as ordered by the court. Mr. Williams is in the lockup. I don't know if he can hear me, but we've already discussed this preliminarily on the record. Mr. Williams does have the right to appeal this if he wishes to do so. Ms. Kracher has placed on the record that she has handed him his appellate rights form. That has the information that is required for any defendant to file an appeal. In this case, it is an appeal of right. So he may do so. Mr. Williams, if he wishes to have court-appointed counsel because he cannot represent him, because he cannot pay for his own representation, he may request that of the court, and the court would grant that. That request has to be made in writing within 42 days of today's date. And so I believe the form has the rest of the information. I cannot confirm with Mr. Williams that he's received the form, but Ms. Kracher did state that on the record. He did not deny that on the record, and he did acknowledge that she left him the pre-sentence information report, and she stated that she left him both. So this time the court finds that that responsibility of counsel has been taken care of. And I believe that concludes matters unless there are any other questions by counsel.
Just to make sure the record is clear, Your Honor, I definitely don't want to belabor this one, but I just want to make sure the record is clear. I offered to take another form to him today. He didn't bring it over from the jail. He would have filled it out. I would have walked it down to the clerk's court, clerk Sachs, filed on his behalf, and he denied that.
I think you've discharged your duty. Your responsibility is to provide him the form. So I appreciate following up and even going that extra step, but you are, I think, relieved of your responsibility in this matter by having delivered that. And I appreciate your efforts in this case.
Thank you, Your Honor. Thank you, Judge.
Thank you.